Any mentioning, please?
May I have a lot of sleep?
From that side. Yes.
Last
Please be a bit louder.
18 September, my lord was pleased to file, leave was granted to file an appeal, my lord. And last occasion, lordship, we filed on appeal and recalling of the order of the appeal, but lordship was pleased to grant a leave to file a fresh appeal, my lord. We already filed the appeal, my lord, tagged with the matter 54, 55 of the my lord's list, my lord.
So what?
Kindly tagged with this matter in the appeal.
Oh, acha.
Previous appeal is there, my lord, 54, 55. My lord was
Previously?
pleased.
Yes.
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 Milord, on adjournment or lordship, Milord, I'm Milord filed the Milord appeal without certified copy. So it is in the list, Milord. But urgency, Milord, it will be Milord, the building will demolish, Milord. My own land's building is there.
Which item?
Milord, item 62, Milord. Application, Milord. If you lordship, Milord, 62, Milord. Today's list, application.
If you can give a notice to the other side, we'll
Yeah,
take it.
Yes, I
Give
can.
a notice to the other side, we'll take it up at 2.
2.
Or 2 থেকে single. Sorry. Then at 1.
Milord.
1.
My lord.
একটা সময় রাখবেন এটা।
My lord.
Item?
Item 62, Milord.
62 at 1 p.m.
My lord.
Give a notice to the other side.
Grateful to yours.
Yes, sir.
Lordship, may I be permitted to mention original side matter, Lordship? This is with respect.
When we take up origin, sir.
May I have your lordship's leave to mention one matter? This is an matrimonial appeal of 2010. I am seeking liberty to file my informal paper books. It is already been
When will it appear? No time.
no. There is
Mention after the vacation. We don't have division bench tomorrow. Immediately after the vacation mention, we'll just put it on the list and read.
much
My
obliged.
lord, item number 64, your lordship had granted me leave to file the appeal yesterday, my lord. Now, my lord, I filed the appeal, the matter is appearing, my lord. There is an apparent urgency in this matter. My lord, the apparent urgency is, my lord, this is a group 8 matter, my lord. I was also selected as eligible, and my other candidates has also been selected as eligible. From prime office, from the documents itself, I can show, my lord, that
So many other matters are
No,
similarly urgent.
no, my lord, from October, the ration articles will get distributed, my lord. I will just take 5 minutes of your lordship's time, my lord. October, the appeal will get infructuous. Even if I move the vacation, means the appeal will get infructuous, my lord. My lord,
Come back at 12. Give a notice to the other side.
Fine.
If the other side is there, only then we'll take.
my lord, my lord.
64 to 12. যখন after we rise and we sit, we'll take up this matter first. Give a notice to the other side. They have to be there.
Item number 1 with 2 for judgment.
Accordingly, FMA 939 of 2025 with FMA number 950 of 2025 are dismissed on contest without any orders to costs. Thereby affirming the impugned judgment dated May 1, 2025 passed in the 2 writ petitions. In view of the pendency of the appeals, the time limit of 90 working days granted by the writ court to the competent authority for reference of the matter to the principal civil court is extended till November 30, 2025. Consequently, the connected applications in the 2 appeals, both bearing can 1, disposed of, interim order vacated, urgent certified copies. We have granted time till November 30th so that you can prefer an appeal.
Much.
Get.
Item number 3.
Lordship, I beg to appear for the appellant.
Non-prosecution.
Non-prosecution, Lordship.
Learned counsel for the appellant submits that the appellant does not want to proceed any further with the matter. Full stop. Accordingly, FAT 424 of 2019.
Lordship, kindly record they are willing to file mutual divorce. They are willing to file mutual divorce. Kindly record.
যেটা বললাম
on
কেটে
the-
দাও। Learned counsel for the appellant submits that the parties intend to file a petition for mutual divorce. Full stop. As such, the appellant does not want to proceed further with the appeal. Accordingly, FAT 424 of 2019 is dismissed for non-prosecution in the light of the above submission. Full stop. Interim order, if any, stands vacated. Full stop. Pending connected application, if any, stands hereby disposed of. No rest to cost.
Much obliged.
Appearance to the
Give your appearance, please. Yes.
Item number 4.
Not today.
May I
Not a passover. Yes. You're appearing.
No, my lord, may matter has already been called.
Yes.
One mentioning.
No, mentioning is over. ভুল নাম্বারে দিয়েছে।
But my lord, I am appearing for the item number 4 appeal.
For you are appearing. What do you want? What correction?
Correction, my
Trustee.
lord. Uh,
In the correct number, the wrong number is
yes,
appearing.
yes, my lord.
Thank you for coming. Yes. What is the correction?
My lord, kindly, my lord, paragraph number 3, page number 2, my lord.
Yes.
The 1, 2, 3, 4 lines, my lord.
Please come closer to the microphone. 4 lines.
Line number 4, my lord, the daughters of the original owner.
Ah.
Because instead of my client has purchased from the grandson who is purchased from his grandmother by virtue of
So what should
registered
this
sale.
be instead of daughters? Grandson.
Grandson,
Instead of daughters, it will be grandson.
grandsons, two
Sons.
grandsons.
So daughters will score through daughters and put in very well.
Or kindly, my lord, thereafter, third line, Kodompukur, Moja Kodampukur,
It should be Kodampukur.
Kodampukur.
These are the two corrections.
Yes, my lord, thereafter,
Thereafter is also there. Let us complete this first. Learned Counsel for the appellants points out that there are certain errors in the judgment dated September 9, 2025. In paragraph number 3, comma, in the 4th line, comma, instead of double inverted daughters, comma, the term should read as double inverted grandsons, double inverted close, full stop. In the 6th line from the top of paragraph number 3, comma, the expression double inverted Kodampur, double inverted close, shall be read as Kodampukur. What else?
thereafter, my lord, paragraph number 4, first line, challenging the same, an appeal was preferred by the private respondents, not, my lord, read petitioners.
In paragraph number 4, comma, in the first sentence, comma, the expression private respondent should be read as read petitioners. Anything else?
Yes, my lord.
So many mistakes. Yes. Quick. In correction, we cannot give more time.
Kindly, my lord, paragraph number 5.
Yes, 5. What?
Private read petitioners challenge the said order before the tribunal, not, my lord, the private respondents challenge the order.
Read petition. In the 5th paragraph, comma, the expression read petitioners shall be read as private respondents. So this and the other page will be interchanged.
Yes.
Anything else?
No, my lord.
Thank you.
Great.
Let these orders be deemed to stand incorporated in the order judgment dated September 9, 2025. Full stop. Thank you. Next. প্রথমে লিখে দাও, although the matter is appearing in the list today with an incorrect number, comma, the matter be treated to be in the day's list. Full stop. Yes. প্রথমে এটা. Thank you. ঠিক বলেছো. কল করুন.
Item number 5.
Yes.
Also, kindly come order dated 4th September 2025. Paragraph number 6.
Yes.
The
Please
portion of the impugner whereby costs were awarded against the appellants shall remain state till September 26 or until.
Yes, we
further-
cannot take up the matter.
Yes, my lord.
You never
I
oppose.
have any
Also, this is my
It
notice.
will extend till November 30th and it will remain in the, it will appear in the monthly list.
Yes,
No, thank you.
Also, it is a part-heard matter, Lord Sir, let the part-heard.
It will remain in the list. Yes. The interim order granted earlier on September 4, 2025 is extended till November 30, 2025 or until further order, comma, whichever is earlier, full stop. The matter shall be listed in the monthly list of November 2025 under the appropriate heading.
Great. Also, let the notice be kept with the record.
Notice to them. Your notice is appearing. Anyway, file it. The receipt of notice filed today be kept on record. Extremely. For mental satisfaction of Mr. Mukherjee.
Grateful.
Thank you.
Item number 6.
Yes. What is
This is my appeal and section 5. Appeal and section 5. Appeal from an order dismissing order 21 rule 97, 98, 99.
all right?
By
So this is the section 5 first.
section 5 first.
Let us just check. What is the delay, Mr. Mukherjee? Mr.
The delay is 211 days.
What is the explanation?
Explanation is, Malad, the order is passed on 14th August 2024. Malad, we had filed a review of that order. The review was heard and heard by the court and is still pending. In the meantime, before that, we had filed an application under 227 and from the interim refusal to grant stay. That was dismissed in February on 7th February 2025 as becoming infructuous. In the meantime,
But
before
that
that,
227 doesn't have any bearing.
after for 14th August, on 18th September, we filed a review petition. Then we also filed, review petition was heard for several days. We also filed in December 24 a Section 47 application. Section 47 application. And my lord, the review application, the Section 47 has been dismissed in February 2025. February 2025.
Yes.
And my lord, pending the review application, give me 1 minute. Yes, pending the review application on 13th, yes, sorry. Thereafter, the review application is dismissed on 13th March 2025. From the order 47, from the Section 47 dismissal, we file Article 227 petition, which is still pending. In the meantime, thereafter on Section 47, dismissal, Section 40 dismissal, yes. Now, my lord, initially from the final order of 14th August 25, thereafter really, we filed,
That was the review.
no, from the 47 dismissal, 47
Filed at
dismissal,
227, you said.
yes, where 220, Article 227 we
Is pending.
filed. And the Order 21, Rule 97 also we filed Article 227 in February 2025. That is dismissed as withdrawn with liberty to approach the appropriate forum on 13th May 2025. And this appeal is filed.
Mr. Mitra, review is not an alternative of an appeal. So review and appeal are different remedies. How can that furnish an explanation?
What I do show is that we were on advice. Naturally, these are on advice. We were taking steps. We were not
negligent.
We were not negligent. We were diligent about it. And anyways, our Article 227 was proceeding which we filed in February 2025, which was dismissed with liberty to file.
Was it the same set of counsel?
No.
Yes, Mr. Mukherjee, what do you have?
But kindly takes up. And also recent judgments, well, there is some departure again and back to the good old.
Departure and every other day. Name a point, Mr. Mitra, and we have a judgment.
Yes. After my last judgment.
Yes.
But factually, we should not make ourselves very clear. Well, kindly takes up their Section 5 application. My
Section 5 is very weak. But yeah, that's something point. 5 is not very in the affidavit in reply. In the affidavit in reply.
Why? Because
in the affidavit in reply, everything.
My opposition.
Section 5, Mr. Mukherjee, we should look into the reply then.
Milord, why, Milord? I will say it's absolutely malafide. Why, Milord? I will say.
Yes.
Milord, I will just narrate not some of the paragraphs. Milord, kindly takes up. It's a very short Section 5 application.
Yes.
Kindly takes up.
Reply you have filed, Mr. Mitra. Has it been? Reply kothay? Reply? File করেছেন?
No, Milord, on the last occasion, since they were not present, so Milord, I filed my opposition.
No, you filed your opposition. Reply is not on.
Reply has not yet, Milord.
Yes, Mr. Mukherjee, let us come back. Reply has been served on you.
Yes.
Let us come back to the Section 5.
Yes, Section 5, Paragraph 2. I will not narrate very briefly because it's my eviction suit which has got, Milord, decreed up to the Honorable Supreme Court. I indicated before your Lordship, just for Milord, 1 minute. They filed, Milord, they intended to file an undertaking, they didn't file. By that time, the director of the company stepped down, and Milord, the daughters have been, Milord, inducted as a director. That, Milord, the person who has stepped down, who has suffered the decree, by independent capacity has filed, Milord, this 47 Order 21 Rule 99. So this is, Milord, in a nutshell, the conduct. Milord, she, in her own, filed and affirmed the written statement, Milord, in the suit, where he lost, Milord, the eviction decree. Now, Milord, kindly takes up Paragraph 2 of their, Milord, Section 5 application. It is first paragraph which indicates that the learned advocate on record rather advise them not to prefer any challenge of the final order of rejection of Order 21 Rule 99 on the pretext that the initial stay order which has been rejected and against that the civil revisional application was still pending. So this is one of the advice that is prompted not this delay. Paragraph 3, though the client instructed the learned advocate that an appeal needs to be filed and the limitation is going to expire, but still the learned advocate advised no to file a revisional application in respect to that. And thereafter, as promptly, as if it's a wrong forum, whenever they have realized that it's a wrong forum, so they pray for the matter to be withdrawn and to file afresh. This is the pretext of section 5. Kindly takes up my opposition. Kindly takes up first, point number W at page 11.
Yes.
That the said revisional, this revisional application is challenging the 47, section 47 rejection. Subsequent. Came up for hearing on 25th of April 2025 before His Lordship, the Honorable Justice such and such, when at the time of hearing, one of the learned senior designated advocate of the Honorable Court was representing the Ganga Bhora along with the other learned advocates. It has been specifically pointed out by the Honorable Judge that the civil revisional application being CO4.
So it is pointed out by the judge and they became.
It's no, not immediately. I will say the same learned advocate on record who is here. He was pursuing the 47 remedy. He was all along there for the judgment debtor in my suit for eviction also. So now, if your Lordship takes up my paragraph 5.
If there are third party in their individual capacity, Mr. Mukherjee, 47 may not be a good relief. So
yes,
that there
not
may
on
be a
merit.
mistake.
I have not many things to say. I am not on merit. Section, paragraph 5, I have dealt with this particular paragraph 2. I said no learned advocate can advise this kind of thing.
Oh,
that,
there are many.
Paragraph 6 again.
You are too optimistic.
Paragraph 6.
What is not you?
No, it's
cannot
really
apply your own standards.
Why, I say, he has given a ground that when the particular revisional application is being preferred, thereafter they have decided to withdraw and to file the appeal. In the interregnum period, the file was misplaced. That was the case made out. In my opposition, I have specifically spelled out within that period of time, they pursued their review application, Order 21, Rule 99.
Review of the main decree.
No. Order 21, Rule 99, rejected.
Rejected.
They say
first they did not prefer appeal because and 227 was pending against an interim refusal in that proceeding.
That's why they.
That's one. That's why they did not prefer appeal. First. Secondly, they took out a section 47 also. And the review application, review of the order passed in Order 21 99. The same order.
Deliberately not mentioned in their application under section 5. On the contrary, they have given an impression before your Lordship.
But reply they must have disclosed.
Once I have disclosed that no, it is a wrong fact that the file was misplaced. If the file was misplaced, how?
Maybe before moving, if they rectify it, then it's all right. If it was not submitted, because in one matter, we dismissed it with exemplary costs because even at the time of submission, it was not made, not argued. So that is the test for us in section 5 at least. It was not in the pleadings. You pointed out they may or may not have deliberately suppressed. They rectify. And when it is moved before us, when you take up the matter, it is at least disclosed. By that time, reply has also come. Although you pointed out.
Yes, I
maybe to
out
protect themselves, may not be to protect themselves, may have been an omission, but it's before us when the matter is moved. So it's not a suppression when it is moved before us at least. We won't go that far in a section 5, and we are clarifying this time and again.
These are my main trash of objection because I say a litigant who is persuading all of his remedies, even before your Lordship and.
So this is, you see, this is a deliberate protraction of the litigation.
I say because of page 121, the quality of litigation they are fighting with such kind of advocates. I can show before your Lordship.
What quality of litigation?
Everywhere my lord, in the proceeding, it is not that, my lord, they are taking advice of, yes, that's why I say, my lord, it's not that. Designated senior advocates are appearing day after day for them. They are taking advice of them. Whether he is such a, my lord, person, when he has himself in Section 5 application stated on oath that he advised or instructed his client that to file an appeal and limitation is going on. And he, my lord, taken advice of such a junior advocate and sat tight over the matter by filing a revisional application. When he is pursuing 47 application, I can show before your lordship, they are also, my lord, designated learned senior advocates are appearing. It's something, my lord, we are running pillar to post from 2011. And, my lord, in each and every case,
Your main decree, there was a first appeal, there was a second appeal, and then SLP.
SLP.
All dismissed.
Not, it's directly first appeal before this honorable court, decreed from this honorable court, thereafter second appeal,
everywhere they have
SLP.
lost.
Yes, yes. My lord, my lord, shown before your lordship on the last day, my lord, they, my lord, submitted before the honorable Supreme Court, I was there, that they will going to file an undertaking. Matter was adjourned to enable them to file undertaking. They didn't file. That prompted the registry of the honorable Supreme Court, my lord, to again, my lord, everything has been suppressed, my lord, before this, my lord, proceeding at page 121. Dog and a manager policy, my lord, they are going on, my lord, it is 47. Once, my lord, they have pressed, learned judge of coordinate bench of your lordship's court in a single judge, he opined how you can maintain the civil revisional application. That was done, my lord. I have given paragraph W. That was done,
Civil division application against?
my lord, against 47 rejection.
47 rejection is
Section 47 by the same, my lord.
Section 47 is not appealable.
No, so that's why, my lord, the revisional application was being filed. That was moved by the learned senior designated advocate for them.
Yes.
It was pointed out that 2199 also rejected on the self-same ground. The learned judge, my lord, opined what you have done against that, my lord, order. He said, my lord, a civil revisional application is pending. He said whether a civil revisional application is at all maintainable. I have given, my lord, even the dates and the time of the, my lord, the paragraph W kindly once looks at. I have given the, my lord, on 25th of April 2025, particularly from 12:48 hours onwards, item number 28 in the daily list from the, my lord, the now live streaming, it's available. It was done on 25th of April 2025. The same advocate on record, Mr. Das, was appearing for them. My ploy is that, Lord, I am just, Lord, running pillar to post. Lord, if your lordship is of the opinion, your lordship will give them, Lord, an opportunity to press their appeal. Lord, kindly let them do whatever Lord, they want. Lord, today, Lord, order 41 stage, now this matter is assigned before your lordship. Regular bench have released it. Ultimately, this FMAT has to be heard by a division bench. I am ready with the matter. Lord, I will leave it to your lordship, Lord. I am ready with the matter. Let them, Lord, press the matter.
Proceed. I can proceed here.
But
Mr.
this is
So
something.
this is palpably malafide.
Well, I will tell you, Your Lordship. The suit was decreed against the suit was filed against two companies.
Just see the timelines. I mean, the suit was decreed.
Suit was filed, no, suit was dismissed by the first court, and
Their suit was
their
dismissed.
suit against two companies.
That was dismissed in the
Salt Lake Property,
first appeal. In first appeal, it was
first
reversed.
appeal on the ground that the lease between the government of West Bengal and the Sunil Rai did not permit subletting. The judgments that they were both of us land, none of them were cited for the division, like the Premises Tenancy Act. That does not make the subletting bad because the tenant has sublet to the, that was not cited, I find, and none of those judgments, and the suit was, the judgment is reversed on the ground
That's on merits, Mr. Mitra. Just see, you've challenged the decree
by the company, by the
eviction suit. This is
eviction suit by the,
eviction suit is dismissed.
against the company.
Against the company is dismissed. Now thereafter you go up in appeal. You they go up in appeal, and appeal is allowed, and then up to Supreme Court you
I
lose.
said, no, not me, not me. Lordship,
The
that's
company
something.
loses.
No,
But you were a
because-
director of the
well,
company.
because I was a director, but then
This is we have to see through the corporate
well,
veil.
I had resigned. Your Lordship, kindly, if your Lordship,
Resigned when? What
my Lord, let me look at it holistically.
what independent
Lord,
capacity are you claiming,
No,
Mr.
Lordship,
Mitra?
Salt Lake Property, there was a probate.
Company was the lessee.
Company was the pre-existing lessee with,
What is your right?
well,
Independent
I
right to-
am the beneficiary under the will. Because Salt Lake Property, Lordship, at that time, I was the pre-existing lessee of the property under one Sunil Rai. Shunil Rai in 2000
Sunil was the owner.
was the government's lessee, like
The direct lessee,
a long-term lease. So Shunil Rai, let me call it my company. Those really my husband's company, whatever. So let's call it my company was a lessee from 1993. Thereafter,
the company was litigating.
yes, but
You must have
thereafter,
known about
a
it.
will was made by Shunil Rai in favor of myself, sole executor, sole beneficiary. It's about the signature. The defendant, the plaintiff, admits that it was signed in their presence. I will show from. I will show from.
Cannot say.
I will go for the. I'll go for the
Admits or not, so you, that's your case.
There's a will. Shunil Rai during his lifetime does not ask for eviction of the tenant. From 1994, when the will is executed, till 2007, Shunil Rai is living.
Did the company take this point that they, but company
Cannot take this point.
your husband's company or
Well,
your
well,
company, you are a director in the
so,
company, you must have known about the
While the-
litigation. Why
while
did you
the-
take this point in the
While
suit?
the appeal was pending,
Yes,
we had I filed the probate petition.
all right. So probate was granted when?
Probate is not granted. Now, probate is not granted, and while the probate petition is pending, they have lodged caveat, and it's a contentious cause. While the probate petition is pending, this suit is finally decreed by the appeal court.
Ultimately, it's decreed up to the Supreme Court.
Decreed
Now,
up to the
thereafter,
Supreme
you take out first Section 47, then Order of 21, Rule 99. You have exhausted all the remedies, and now they should get the fruits of the decree.
Lordship, on merits, as he
So
said,
that cannot, these cannot be grounds for not filing an appeal against the Order 21.
Merits can be looked into. The last Supreme Court judgment says merits should be looked into. Why has my order or Rule 99 been dismissed? It's been dismissed on 4 grounds.
No, the Rule 99 was dismissed. After that, you spent 211 days delay or something like that.
Yes.
So what in the interregnum, what was happening? The Section 47 was
But
pending.
in the interregnum, while the
Section 47 was dismissed first or 2199?
order first is Rule 97 or Rule 99 is dismissed in August 2024.
Then Section 47.
Then 47 is filed thereafter. After Rule 99 is dismissed, 47 is filed.
Then
There are 2 filings. One is a review. One is a Section
she
47.
exhausted all remedies. I mean,
Section 47.
say Section 47, you should have, what prevented you from preferring an appeal against the
Well,
dismissal of this?
But from the interim refusal to 27 was pending.
Can that be a ground?
Well, thereafter,
It's obvious that that would be rendered infractuous.
thereafter for the final order,
Yes.
we filed a 227. But there, I must say, there are a certain lack of.
Two things hit us strongly. One is that your pendency of 227 against ad interim order automatically gets infractuous. Any basic lawyer would say that. And you are represented by good counsel all through, as Mr. Mukherjee pointed out.
Mukul Rohatgi has appeared in Supreme Other after
Gopal Ghosh was there. I don't know.
after the possession order was after
Gopal Ghosh was there also. He knows civil law, that I know.
other side.
Dotto, learned senior
Shuman
advocate,
Dotto
appeared
appeared.
in 47.
Before 227 and he withdrew it. And he withdrew with liberty to file. Can you see
Section
the-
47 he appeared.
47, Milord, page 100. Kindly see. This is, Milord, arising out of Section 47, Milord, civil revisional application, rejection of Section 47.
Yes, and he only withdrew it. Kindly see the order.
That is not the withdrawal. That is still pending. What my learned senior friend is saying.
Logic, kindly see page 7 of the civil revisional application. Page 7.
This 1401 is challenging the rejection of 47, Milord, where Mr. Dotto appeared, and this revisional application is still pending. The same advocate on record is also there, Mr. Dash, represented and assisted Mr. Dotto.
47, he's not that record.
What is CO 1455? Page 104? That was against what?
That is, Milord, against, Milord, the 208, Milord, the application in connection with 208, Milord,
Police.
many, Milord, frivolous application was filed. This order, your lordship will get, the entire narration of conduct is being, Milord, recorded by the coordinate bench of your lordship court. This, Milord, your lordship will give, Milord, the idea what, Milord, is going on. Page 104 onwards, his lordship was taken pen to record all the conduct. Even 208, allowing the application under Section 208, separate set of advocates, challenge revisional application, that was also withdrawn.
So this is not by my client.
Section 47 was by the company.
But page 104 is not by the.
No, section 47 is also by Ganga Bhoda.
But so far as
Yeah,
page 104 is concerned, that is not by the petitioner before my lord. 104 কোথায়? এটা তো
There is a company.
by the company, but I ceased to be director before the second appeal, before the first appeal was pending.
You were in the know of the matters. You were a
Well,
director of the
well,
company.
my
Then you set up
secret-
an independent title. What prevented you from setting up the title in the suit itself or at any stage?
Well, but that I can't set up in the suit. That has to be the probate proceeding. That is the probate proceeding. In
So
the
why
probate-
can't you defend your, I mean,
Well, if a suit is filed against two companies.
company? You
So-
can ask for implement. The company should have disclosed that somebody else is the owner.
Somebody
You wait for the entire gamut to be
somebody,
exhausted.
my lord, while the first appeal is pending probate petition is filed. Probate petition can't be filed. A probate petition was filed after, while the first appeal was pending. At that time, we were still suit was dismissed against. When I filed the probate petition in 2014, at that time there was no decree against me. 2014.
My learned senior friend has not consulted with his own written statement affirmed by Ganga Bhoda,
Why, what does-
where apart from the loan in substance, they have specifically taken the point with regard to her independent right title interest in respect of the property, because they said there is an agreement for assignment made
Who
by
takes that point? The company or she?
no, by her, in the name
In
of
what
her.
proceeding? What proceeding?
In the suit for eviction. They
She
have
was a party. She was not a party.
she
The company was a defendant.
company, he was a director, she was a director of the company.
The company must have taken
No,
that.
apart from the company's point, her independent point was also taken in the written statement
By whom?
by the Ganga Bhoda.
She was not a party.
Milord, she said what, Milord? She has
She was not a party. How could she take a point?
Milord, in paragraph 27, she said no. In
Paragraph
name
27 of what?
of the written statement, Milord, I'm coming.
That is the
I-
company's written
The
statement.
company's written statement, she said, I being one of the director, the owner has executed in my,
It's a written statement of the company.
and she herself denied that there is any existence of will. What happened? What I say in my suit, I say there are numerous documents that has been executed.
Those are on the merits.
That's blood. I am not for the time being, blood. I am not inviting. That has been recorded in the order.
I am prepared,
If your lordship read
Lordship,
once
here and
the
now
order,
to argue on merits,
Yes, yes.
so that he is not delayed.
We are allowing
Yeah.
section 5 will pay costs, will impose costs. The present application is for condonation of the delay in preferring the appeal, which has been taken out against the dismissal of a proceeding initiated by the appellant under Order 21 Rules 97 to 99 of the Code of Civil Procedure. First up, next para. The delay is of about 211 days. First up, upon hearing learned counsel for the parties, we find that the plinth of the explanation is that initially a revisional application a revisional application was preferred against the rejection of an ad interim prayer made in the proceeding under Order 21 Rule 97 to 99 of the Code. First up, during pendency of the same the main proceeding was dismissed. First up, according to the appellant, the appellant wanted to prefer an appeal against the said dismissal. First up, however, legal advice was given to the appellant by the then learned advocate to the tune that in view of the pendency of the prior revisional application, there was no necessity immediately to prefer an appeal. For the next para, the other ground taken is that the appellant, in her independent capacity, on the strength of a will executed by Sunil Rai, the original lessee under the state, had taken out an application under section 47 of the Code of Civil Procedure in connection with the execution proceeding from the eviction decree in question. First up, next para. It is submitted by learned senior counsel for the appellant that the said application under section 47 was also dismissed. Full stop, next para. A revisional application was preferred against the same. That was withdrawn, Mr. Mitra.
That was That along with, that is, no, that's still pending, but then we have withdrawn the revision from the final order with liberty to approach.
That is,
comma,
47
which is still
not-
pending, which is
we
still
will-
pending,
We shall withdraw immediately.
still pending. Push up next para. The appellant contends that the appellant also preferred a revisional application under Article 227 of the Constitution of India against the dismissal of the application under Order 21 Rules 97 to 99. Full stop. However, comma, the said revisional application was subsequently withdrawn upon the court pointing out that the same was not maintainable. Full stop. Next para. Subsequently, the present appeal has been preferred. Full stop. Next para. Learned counsel appearing for the respondents, decree holder stroke respondents submits that the attempt of the appellant stroke petitioner is palpably malafide and intended to protract litigation. Full stop. The present appellant, comma, it is submitted, comma, was an erstwhile director of the company, comma, which was the defendant in the parent eviction suit, comma, which is the genesis of the entire litigation. Full stop. Upon the said suit being dismissed against the company, comma, a first appeal was preferred by the respondent. Full stop. The said first appeal being allowed, comma, a special leave petition was preferred unsuccessfully by the judgment debtor. Full stop. Next para. However, comma, it is submitted that the woes, WOES, of the judgment debtor did not end there, comma, since the paraphernalia of filing applications under section 47, comma, order 21 rule 97 to 99, etc. of the Code of Civil Procedure started. Full stop. Next para. Even an order passed under rule 208 of the civil rules and orders framed by this court was preferred by the judgment debtor, comma, it is contended. Full stop. Next para. Learned counsel for the respondent further submits that the appellant has been taking contradictory stands and that the poor quality of legal advice claimed by the appellant cannot be credible, comma, since the appellant was represented by eminent senior counsel at several stages of the litigation. Full stop. Next para. Thus, comma, it is prayed that the application for condonation be dismissed. Full stop. Next para. Learned senior counsel appearing for the appellant, comma, in reply points out that the engagement of senior counsel for the appellant led in several cases to withdrawal of applications which were revisional applications which were not maintainable. Full stop. Next para. That apart, comma, it is reiterated that the appellant had no control over erroneous legal advice given to the appellant. Full stop. Next para. Insofar as the appellant being an erstwhile director of the judgment debtor company is concerned, comma, learned senior counsel submits that since the appellant has staked claim in her independent capacity, comma, which is not through or under the judgment debtor, comma, there was no scope of the present grievances being ventilated during the pendency of the suit, comma, more so, comma, since no probate was granted. Push up, it is pointed out that probate has still not been granted, but the appellant, comma, in order to save her rights, comma, has been compelled to take out the applications mentioned above. Push up. Next para. Upon a comprehensive consideration of the materials on record and the submissions of parties, comma, this court is of the opinion that although a liberal view is taken in respect of applications for condonation of delay, comma, the court also has to be cautious that such liberal view is not abused by a litigant. Full stop. In the present case, comma, we find that all possible means have been exhausted by the appellant prior to preferring the present appeal, comma, thereby compelling the decree holder stroke respondent to run from pillar to post, comma, without getting the fruits of the litigation. Push up. Next para. However, comma, we are of the opinion that a thin thread of benefit of doubt can be extended to the appellant inasmuch as erroneous legal advice has been pleaded. Full stop. It is not possible for the court or the decree holder stroke respondent to assess or ascertain the correctness of such ground, comma, since the legal advice is privileged communication between the litigant and the legal professional. Full stop. Next para. Be that as it may, comma, although under normal circumstances, comma, the uh, the condonation application ought to have been taken more strictly, comma, keeping in view the fact that the substantial defense taken by the present appellant, comma, a third party to the suit, comma, was canvassed for the first time within the framework of law in the application under Order 21 Rules 97 to 99 of the Code, comma, at least an opportunity to ventilate grievance against the order dismissing the said application ought to be given to the appellant. Full stop. However, comma, the immense harassment suffered by the decree holder stroke respondent has to be somewhat compensated by costs. Full stop. Also, comma, we intend to take up the appeal immediately after the disposal of the present application. Full stop. Next para. In view of the above, comma, can 1 of 2025 is allowed, comma, thereby condoning the delay in preferring FMAT 216 of 2025 with costs of rupees 50,000 to be paid to the respondent by November 7, 2025. Full stop. Next para. The appeal is taken up for admission hearing. Full stop. Next para. Since questions of both fact and law are involved, comma, we admit the appeal and take up the same for hearing on the basis of the materials annexed to the memorandum and the applications on consent of both parties. Yes, Mr. Mitra, what is it?
My appeal, my Order 21 Rule 97
Yes.
has been dismissed on, memo for Peter, has been dismissed on, yes, on the ground that, well, there are really on 4 grounds. Ground 1 is that it is premature. Till I am dispossessed, Rule 99, I cannot avail of. Number two,
Give us half a second. এটা সিপিসিটাও দিয়ে রাখবেন, সিভিল প্রসিডিউর কোডটা দিয়ে রাখবেন। Yes, Mr. Mitra, what is
number 2, next ground is that section 213, I cannot even rely upon the my rights as an executor because of section 213 of the succession. Number 3 is the judgment of the High Court for eviction against the companies is res judicata against my client. Number 4 is the will is forged without a trial.
Pardon, please repeat that.
Will is forged. One line, just out of the blue. Will is forged. These are the 4 grounds on which, without a trial, the Rule 97 has Rule 99 has been dismissed.
Was there any application by them challenging maintainability or anything like that? It will appear from the order itself, probably.
Huh? That was rejected, from which they had filed a revision. That is pending on the maintainability ground.
What was the ground of maintainability taken by them? Yes, you can help us.
Huh?
Why? What was the ground of your maintainability application was rejected and you preferred a revision which is pending?
No. What my
That is Order 14 Rule 2 in connection with Milord probate proceeding, not in Order 21 Rule 99.
Different.
they filed.
So let us see the impugned order then. Yes.
It has been disposed of. Lordship kindly comes to the order and then I will address each of the issues.
The order is
14th August is the last order in this thick
March.
memo of appeal.
Yes, 14.
Page 1 is argument. Page 2, the order starts.
Yes.
Second para of page 2. Now the present petitioner,
Yes.
Ganga Bora, has filed the stay application under the camouflage of her personal authority over the suit property only to extend her illegal possession over it. The petitioner has initiated probate proceeding under forged will. Without, and I will show in their plaint they have admitted. It is posited by the opposite party decree holder that Sunil Rai never executed any will or delivered possession of the suit property in furtherance of the will to the petitioner. It is further pointed out that there or section 213 Succession Act, unless probate of any will is granted, neither the executor nor the legatee of the will is entitled to claim right of relief on the strength of unprobated will. This is the second. This is
213.
213.
Yes.
It also pointed out that the present petitioner has initiated title suit number 1 seeking specific performance of fabricated assignment agreement. As Lordship knows, Salt Lake property, when it is in those days before the, there should be 6 several agreements: power of attorney, tenancy, assignment, will, and 2 more: agreement for sale and so on. Also, the husband of the petitioner has initiated money suit 415 claiming refund of the money against the legal heirs. It is submitted by the opposite party decree holder that the petitioner Ganga Bora was the director of the defendant company against whom TS number so and so has been decreed. She had filed written statement under affidavit in the title suit 74. Now Ganga cannot claim that she had no knowledge of the alleged will under which she is now claiming her possession. Why should I? It was filed before the suit was decreed, and thereby seeking an order preventing her dispossession or eviction from the scheduled property. The petitioner cannot state that her identity as a legatee is different from that of a director in the defendant company. The knowledge of the petitioner as an individual legatee and director are the same. Thus, the petitioner cannot state that she is a stranger or third person in the suit property. Learned counsel for the opposite party submit that fact of the alleged will was never incorporated in written statement filed by the petitioner, though in the evidence it is there. I've got the evidence. As the authorized representative director of the defendant company in the present TS number so and so. Rather, the defendants emphatically denied the execution of will by Sunil Kumar Rai in their written statement. Even that the defendants as respondents FA never decried before the Honorable High Court of Calcutta regarding their right in the suit property originating out of the unprobated will. It is pointed out that probate proceeding was filed by the petitioner before the district delegate in the year 2014. Suit is dismissed in 16 and then appealed only recently. And the original suit was disposed of and appeal was preferred by the opposite party before the High Court in the years 2016. Thus, it is evident that the petitioner, as the representative director of the defendant company, had knowledge of the alleged will and the probate proceeding while pendency of the original suit as well as the appeal. Yet still the petitioner never mentioned the same before the Honorable Court or set it up as a defense in the appellate proceeding before the High Court. Thus, now the petitioner is debarred from setting up defense against execution proceedings on the basis of existence of will. The opposite party has relied on the judgment passed by the Honorable Apex Court 2024-1 in the civil cases where reference was made to a judgment passed by the Apex Court into 82 SCC, where it was held principles of res judicata only applicable in separate proceedings, but the general principles of res judicata also applicable at the subsequent stage of the same proceeding. Rule 99 is independent suit. Same proceeding, and therefore the same court will be precluded to go into that question which has already been decided or deemed to have been decided by so and so. Furthermore, the opposite party has relied on the judgment passed by the Honorable Apex Court in 22(3) RCR. Rule 99 pertains to making a complaint to the court against dispossession of the immovable property by the person in possession of the property by the holder of the decree or purchaser thereof. It is pointed out that the petitioner has was never dispossessed from the property in question. And till date, as contended and unrefuted, the possession of the same rests with the petitioner. Thus, the petitioner cannot be said to be entitled to make an application under Rule 99, raising objection. Now the reasons come. Now, under Rule 99, there is no scope for the petitioner to make such application or pray for any order of stay. Since such complaint under Rule 99 can be preferred by any person other than the judgment debtor if he is dispossessed from the immovable property by the decree holder for possession of such property. But in the present case, the petitioner has not been dispossessed from the suit property. Any objection by third party in anticipation of his dispossession is not permissible. Thus, such section or Rule 99 is not maintained. This is the first decision of the learned judge, not maintained. Furthermore, this court accepts the submission made by the learned counsel for the opposite party that no executor or legatee can establish their right in any court of justice unless a court of competent jurisdiction has granted probate of the will under which the right is claimed or has granted letters of administration with the will or copy of an authenticated copy of the will annexed. Even the petitioner under the will cannot claim herself as the legal representative, being the executrix, until probate of will is obtained. In the present case, no probate has been granted. Neither any document has come before the court as letter of administration of will being granted. Furthermore, it is found by the judgment in 2004 AIR, that is same as 2004 7 SCC 505, Justice Kapadia's judgment, which I shall show just the opposite. Referred to by the petitioner that section 213 acts as a bar to the establishment of rights under the will by an executor or a legatee unless probate or letters of administration has been obtained. This bar comes into play only when a right as an executor or legatee under the will is sought to be established. However, an unprobated will can be admitted in evidence for collateral purposes in any other proceeding apart from a probate proceeding. This itself gives the answer. Thus, the petitioner can never claim right to the suit property under the provisions of the Succession Act. Finally, this court accepts the submission made by the opposite party that Order 21 Rule 104 do not bar proceedings for removal of resistance or obstruction to possession. I don't join issue on that. Furthermore, it is not within the scope and ambit of the executing court to adjudicate and determine the rights contended by the petitioner under probate proceedings of the alleged will. It is to be examined in a different suit whether such rights of petitioner will be sustained or erased. But the same can never be examined by the executing court, by the court executing the decree, the very reason being the limited scope of examining issues relating to execution. Now it is necessary to point out that the order passed by the Honorable Apex Court in connection with title execution, so and so, having heard learned counsel for the petitioners, we are not inclined to interfere. However, the petitioners are granted 6 months' time, subject to giving undertaking. The order passed by the
Mr. Mithra question.
now, by best.
So regarding Order 21 Rule 99, you may argue probably that it's an ecosystem, 97 to 100. So 97 followed by 98, order passed under 98, touching 101, and also 99 followed by 100. So even if they were not dispossessed, this could be read as a defense to Order 21 Rule 97. And regarding 213, 211 is also there. It
vests the executor.
Mr. Mukherjee must be ready on these lines.
213, I will show the judgments.
Yes.
If 213 probate is not granted, the approach of the courts is twofold.
211 has to be taken into consideration somewhere.
And
vests in the executor and legal representative.
And if at all there is a suit where the executor is asserting a right, the suit will be stayed till disposal of the probate proceeding. And there are other judgments also that both will be heard together.
And forgery finding is obviously
forgery finding. I will just show one sentence, my lord. You kindly see why should this case at all be arising? Lord, you kindly see their plaint case. Kindly come to page 44. That is their plaint in the state petition. The plaint starts at page 31. Kindly come to page 44. Where is how does the question of probate forgery arise? from the first one, it is needless to mention here that those signatures were taken by the director of the principal defense from Shunil Rai sometime in last part of August 94. At the time of procuring such signatures from Shunil Rai by the principal defense numbers 1 and 2, those two companies, the plaintiff's husband, Shunil Rai, was indifferent and had no independent knowledge. And at that relevant point of time, he was suffering from mental disorder. For such reason, he had no mental capacity to enter into any such agreement and asked the principal defendants to produce the papers when they wanted to write down in those papers. Be that as it may, that as per the dictation of the principal defendant, principal defendant number 1, Shunil Kumar Rai, put his signature in
Cannot be
presence of the
forgery.
plaintiff.
Cannot be forgery, either mental incapacity or misrepresentation.
And for 7 years, he lived thereafter. They never got him declared an person of unsound mind. So, sign in the presence of this particular decree holder. And presence of the wife and the son. These documents were signed. Because they are witnesses. So they can't deny that. Now, my lord, just to go through the routine of the judgments, my lord. Firstly, property vests in the executor under section 211 of the succession.
That is section itself.
Section 11. So the judgments are not troubling, my lord. Order 21, rule 99.
You can cite 1 or 2 judgments on that. That we will take into consideration the defense you can raise under 2197 also.
Yeah, 96.
Because 97 order is passed under 98, which says you have to touch 101.
Yes, absolutely.
So you have a defense. That defense 99, this caption as rule 99, maybe because they have admittedly taken out 208 was taken out by. So police help application was taken out. They attempted to dispose. But we'll like to see judgments on that if you have not too many.
Not too many. It take paragraph take मिलिए ना para मिलचे तो तुम्हारे take मिल जाए तो yes.
Not too many, 3 many or 4 many. One will.
The first judgment then may I cite?
Yes.
1996 3 SCC 154. हमारा था paragraph 6. This is now, I mean, I've got judgments up to recent times, but then as but I will show one more later judgment.
Yes, yes.
Paragraph 6, the controversy no longer exists. This court in Powerlal considered the controversy and it held that even an application rule 1935(3) or 147 would be treated as an application rule 97. An application and an adjudication is required to be conducted under rule 98. Disposition of the applicant from the property in execution is not a
exactly.
condition.
98 to 100 has been taken in a. Yes, yes,
And
absolutely.
just one more, 2002 around, 2002 is
Yes, yes.
just one more. I knew this will possibly not really require too many judgments. 2002 volume 7 Supreme Court cases. Page 50. Right? সব কপিটা দিয়ে দাও তাহলে আমি তাহলে তুমি আনো নি আছে ও মনে করতে পারবো ঠিক আছে the paragraph starting maybe 12 or 13 we have already আরেকটা দিয়ে দাও একটা আমার একটা দরকার দিয়ে দাও আরেকটা জুন জোর দাও
So if you have copies from the same journal, then we'll take that.
Yes, I think all Manupatra.
All are Manupatra.
Then I'll
The third copy too.
paragraph 13 or paragraph 12. We have already, or paragraph 13, 14 will be sufficient. Dispossession is not a requirement. 13 is very clear. कौन सा? 128 है, हिंदी में जब देखिए हाँ कोई तो 27 is.
Yes. 13 is sufficient.
Next, I go on to section 213, whether it's a bar. May I cite the judgment which they had only placed, 47 SCC,
Yes.
the one relied upon by the learned single judge, 47 SCC. One paragraph will be sufficient. In fact, this will help me. 2004 7 SCC 505. This covers even implied assent without probate, paragraph 10
Yes.
at page 5.1. This paragraph, let me place.
Paragraph 10.
Paragraph 10, page 513. May I place this paragraph? A bare reading of section.
Yes.
A bare reading of section 211 shows that the property vests in the executor by virtue of the will and not by virtue of the probate. Will gives property to the executor. The grant of probate is only a method by which the law provides for establishing the will. In the case of Kulwanta Bewa, it has been held that section 211 provides that the estate of the deceased vests in the executor. And the vesting is not of beneficial interest in the property, but only for the purpose of representation.
Mitra, this is too well said.
No, next part 213 from Placidum C. Placidum C.
See, yes.
It provides that an executor gets divested of his interest as an executor from the death of the testator when he assents to a specific legacy. 213 acts as a bar to the establishment of rights under the will by an executor or a legatee unless probate or letters of administration have been obtained. This bar comes into play only when a right as an executor or legatee under the will is sought to be established. However, an unprobated will can be admitted in evidence for collateral purposes any other proceedings apart from probate proceedings. Therefore, on the demise of the testatrix, the said property vested in the executors. The question which arises for determination of the facts of this case is whether the executors assented to the vesting of the said property in the hospital in terms of section 336 of the 25 Act. In this case, the facts show that the executors never objected to the vesting of the said property in the hospital. 3 executors were appointed under the will.
Here the executor herself is coming.
So, assent also can be implied while the probate.
Gangavara was the executor.
And the beneficiary, sole beneficiary.
Good.
So the assent also is
implied.
And my lord, 2005 to now, 512 basis now. And if at all there is issue coming up of the 213, then what is the issue? 2005 12 SCC 505, that both should be heard together. This is clubbing. This is only one paragraph. It has been brought to our notice that settlement is not possible at this stage. Therefore, now remains the question whether the probate proceedings could be clubbed with the suit. Well, counsel for the respondent number 1 submitted that the civil suit is of the year 1987 and that despite various orders of the High Court, it has remained pending and the probate proceedings are initiated by the appellant in 1997 regarding the will of 84. Be that as it may, the decision in the probate proceedings on the question of proof of the will have a direct impact on the suit. Only on this short ground, without expressing any opinion on the merits of the controversy between the parties, we request the learned district judge Gopalganj to make it convenient to dispose of probate proceeding along with this civil suit. Last dekhiga eta 2006 Supreme Court. Now, Lordship, just one judgment. My juniors requested that Order 21, Rule 97, without a trial, the court couldn't have even otherwise held forgery. Just
but if it's not maintainable, yes, yes, right.
No, I'm not saying it can never, always trial is
One of the
always
grounds is that it is not maintainable because
maintainable.
that can be done.
Not
Premature.
maintainable, yes. Not maintainable, yes.
It has been held to be premature.
That is
definitely.
because of the order will. But the forgery,
But the other findings, forgery,
the will is not genuine. That could not have been there if it's a purely forged will. Someone comes forward.
forgery
Yes.
could not.
Then one may ignore 211, 213 is an absolute forgery. One files a probate petition, I'm saying. But then there has to be a trial to show that this is a forged will. Absolute forged will, so don't take the 99-2 CLG. কিংবা বলজিৎ সিং তথা পাঞ্জাবের টাকা যেটা সামনে দিয়ে দাও I'm not think 211 will be complete defense. It may be an absolute forgery. One then the
There are numerous judgments on 211-13 interplay.
yes
Settled.
very settled. But here Lordship kindly sees just one paragraph, paragraph 7. The Calcutta High Court, they can't find it, so I'm citing the last page of the judgment.
Yes.
Determination means the actual determination like a trial court, paragraph 7. With
It's
regard,
actually a suit. It has the effect of a decree. Obviously, it's a trial.
that is all.
Maybe a summary trial, but a trial.
Same ground as refusal of stay, but it has to be there. Well,
Yes, Mr. Mukherjee. Thank you, Mr. Mitra.
But the,
Bad conduct, good appeal.
let me will try.
Yes. Try and dispel our notion.
Page 31 of the stay application, my lord would get, not my plaint. What was my plaint was about. Paragraph 14. My learned friend, my learned senior friend, have invited your lordship that I pleaded the execution of various documents, including this alleged will. Why I pleaded? Because my gamut of this suit was there was the lease deed was executed in the name of my father, original lease. My father was not in a position to construct the house because he was
Your
in
father's
that-
husband, Sunil Rai?
No, my mother also died. Now, the son. My- now
this is
the
a son.
Now the son. So, my father was not in a position. He's a debt of money. He wants some money to be borrowed. And in lieu of that, he allowed the construction was coming because there was a restriction. I will have to make the construction within a particular stipulated time. And thereafter, I allowed the judgment debtor to stay over there so that
Mr. Mukherjee, we won't go into the matter.
no, I'm not.
Court has
I say
decided on 4 points. You satisfy on those
Yes,
4.
I'm on res judicata.
You may have a very good case, but
Res-
the merits have not been gone.
Not on that.
Res judicata, how can a third party be bound?
Kindly allow me for 2 minutes.
She was not a party there.
I am not on that. Kindly consider. That
Res
is the-
judicata between whom? Is she claiming under the company or through the company?
If I demonstrate before your lordship, first thing that yes,
She may have had knowledge, she may have affirmed the affidavit, she may have acted as director, she may have been the authorized signatory of the company, the authorized agent of the company, whatever. The limbs of the company. Still, Mr. Mukherjee, she is in a different individual capacity now. And two different capacities. Individual biological human being, one. Secondly, the legatee.
I am not on that. She herself in the written statement have pleaded that there was an agreement executed for assignment or transfer of the property in her favor, individual name,
Yes.
as an agent or not as an agent of the
Maybe,
company.
so what?
And
Is the written statement of the company.
it's a written statement of the company wherein this particular lady has claimed her independent right. And that has been
But if
adjudicated.
you are not a party to a proceeding or not claiming,
It has been adjudicated, Milord.
cannot. Beyond the scope
Milord,
of the suit.
The trial court said all the execution of this will and these documents are false and concocted, which has been quoted. This honorable court sitting in first appeal also have adjudicated that. Kindly consider, Milord, once the order passed by this honorable court. While passing the order
What
of
is
eviction.
what is the concept of res judicata, Mr. Mukherjee? Tell us.
Milord, I say it's constructive res judicata. I say it's constructive res judicata because, Milord, had it been a case that a person have Only canvas.
Cardinal principle is parties have to be the same or have to claim or through or under the same person.
I say
This is
if
cardinal.
if-
Otherwise, res judicata substantially involved, incidentally involved, those pale into insignificance. She is not claiming through the company or under the company, Mr. Mukherjee.
my lord, I'm today, if my lord, had it been a case that
If
this
there is an
lady-
adjudication regarding the company and some document was relied on by the company, it had to be the defendant, the company which relied on it.
my lord, the
And if that was
documents have been
decided,
exhibited, my lord.
if exhibited and held to be bad, that also does not bind the person or the signature or anybody if they were not parties or claiming to the company.
My lord, she was there.
If this will was disbelieved, if this will was held to be forged, if this will was whatever was done to the will, the parties are to be looked at, Mr. Mukherjee. It was an adjudication between the company and you, not this person or the executor were not parties there.
Very well,
Therefore,
my lord.
whatever was held regarding the will binds the parties only, or their people claiming through them, not a third party. She had knowledge, we can understand the malafide, but we cannot help you because law says that it had to be the same parties. Res judicata would not apply. She won't be bound in an individual capacity.
Very well, my lord. The order have certain other limbs also. My lord,
Four grounds, we don't find any merit in
I'm-
the
I'm-
four grounds.
Yes, yes, my lord, I'm coming, my lord. Today, your lordship is.
But we'll record your
order
submission that
21,
you say that the suit court,
Lord,
as
I-
well as the appellate court
appellate court, my lord, kindly takes up, my lord, the appellate court judgment.
held that the will was forged.
Yes. First bill তো আমাদের এখানেই আছে। My lord, kindly takes up, my lord, the judgment.
Stay application.
No, my lord, I have annexed, my lord, the judgment of the High Court, my lord, in my my lord, opposition to the Section 5 application.
Yes. Show us that.
Paragraph টা বলো।
Mr. Mukherjee, be
Lord, kindly
precise.
take up-
We have fixed the matter at
Yes, my
12
lord, kindly
and
take
the
up
matter at
page-
1.
my lord, kindly takes up page 34.
Yes.
Upon contested hearing, the suit was dismissed upon arriving at a finding that the payment made by the principal defendant to Sunil in the year 1993 was not a loan and the defendant had borne the cost of construction work, had invested money for completion of the building. The defendants had no money lending license and as such he had no right to give loan to Sunil. On the issue of eviction, the court observed that no specific prayer has been made for eviction of the defendant as trespasser or tenant, and that as such the suit is not maintainable. Next, my lord, kindly consider this. It was also observed that the story of execution of the will by the deceased Sunil was out and out false and concocted story. Now, my lord, kindly now takes up paragraph 17 of the judgment. Paragraph 17. Mr. Banerjee argues that no condition or clause in the tenancy agreement dated such and such and the loan had been advanced by the respondent number 1 Sunil. In the earlier tenancy agreement dated such and such, Sunil gave right to respondent number 2. It is independent capacity, my lord, Ganga Bhora. Even inducted subtenant in the property, the Sunil agreed to renewal of such lease would be automatic and absolute. In the memorandum of understanding dated 18 February 1994, Sunil even agreed to transfer and or assign the plot of land, including construction, up to the plinth level in favor of Ganga Bhora at a price of rupees such and such. In the construction agreement dated such and such, it was agreed that the cost of construction shall be borne by the developer, and as such the cost of estimated dated such and such, and the owner shall be liable to refund the same as 18% component. None of the agreement has been challenged by the appellant, and she has miserably failed to establish that the tenancy agreement dated such and such was a loan transaction. So, my lord, what I am on today, the interpretation of all these documents which has been
Agreement is a different agreement.
tenancy
That is not the
agreement, assignment agreement, my lord, there is a suit pending.
That is not their case also. That has not been decided by the trial.
There is
The
a
executing
independent suit filed.
agreement is out of question. The court
Agreement
held
for
only that the
assignment.
will is forged. We are not on the agreement now.
Agreement for assignment and other execution, my lord, everything interpretation of all those documents has been done by this judgment, and this honorable court found no, it is really a loan in substance. Loan has been liquidated. You have stayed enough in the property. Your possession after liquidation of loan become a possession illegal occupation. So ultimately eviction decree has been passed. So my lord, today this lady, when this eviction decree passed, stepped down and filed an application under Order 21 Rule 99 saying what? Today, my lord, Order 21 Rule 99, your lordship knows today, if I want to resist a decree, as on today, I have to demonstrate before your lordship under what capacity I do have an independent right, title and interest to stay over the property. It's not about, my lord, any right which may acquire in favor of me.
What about
in future.
211.1?
I am coming, my lord. My lord, 211, my lord, it's disturbing your lordship. My lord, kindly takes up 211.2, subsection 2.
Yes.
Because the executor or administrator, as the case may be, of a deceased person is his legal representative for all purposes and for all property of the deceased person vests in him as such. 2 is when the deceased was a Hindu, Mohammedan, Buddhist, Sikh, Jaina or Parsi or an exempted person, nothing here in context shall vest in an executor or administrator any property of the deceased person which would otherwise have passed by survivorship to such other persons. So there is a departure. If he is a Hindu, there is a departure. I am a Hindu. So if this departure is there, that's why my learned senior friend has relied upon paragraph 10 of the Supreme Court judgment that also state the position clear. Had it been a case that he is not a, but the deceased testator was not a Hindu, then the question of this operation of section 211 will arise. Today, my lord, I am stating before your lordship, this person do not have an independent qualified right, title and interest to be canvassed under 2199 for resisting the decree. That right may acquire. And had it been a case he was not Hindu, then that right may be acquired as on today. But today, the court has rightly said that today at this time, 2199, you don't have qualified that of right that you can resist a decree. It's not maintainable.
Admittedly, probate has not yet been granted.
Not yet been granted. So vis-a-vis, if we read section 213 also, this is also right as executor or legatee when established. No right as executor or legatee can be established in any court of justice unless the court of competent jurisdiction in India has granted probate of the will under such right is claimed or has granted letters of administration with the will or a copy of the authenticated copy of the will annexed. Now, my lord, pausing here for a moment, my lord, today my learned friend has relied upon a judgment of this Honorable Supreme Court said, yes, in a collateral proceeding, you can very well annex that, even an unprobated will. Nobody is querying on that proposition. But today, whether without obtaining a probate of a will, can you resist a decree being a third party under 2199?
But if the Supreme Court says that you can rely on an unprobated will in a collateral proceeding, collateral as opposed to a probate proceeding,
my lord,
it is precisely such a proceeding.
Yes, as an evidence, my lord. Again, I am saying it does not qualify as a right. Otherwise, my lord, section 211 subsection 2 becomes nugatory because it creates a departure. It creates a departure that when this right is not to be affected to some person. It's very clear. Otherwise, it is subsection 2. May I, for a read of repetition, may I read once? Again, when the deceased was a Hindu, Mohammedan, Buddhist, Sikh, Jaina, Parsi, or an exempted person, nothing here in content shall vest in the executor or administrator any property of the deceased person which would otherwise have passed by survivorship to some other person. So here, by survivorship, it's vest upon me. So Hindu, there is a departure.
This is a very interesting point you have raised, which we must say. But extremely interesting. Yes.
I say, that
very
is,
arguable. Very arguable. Yes.
That is one of the things, which has been
read with 212 and 13 and.
So, today this can be used as an evidence. Nobody is querying on that.
Or what would be the purpose of using it as evidence?
There may be other proceeding also. There may be not looking at 2199.
Maybe possession, maybe something
else. I can show it as an evidence. It cannot disqualify.
What purpose would be served?
Yes. This is a
maybe to show that the testator could read and write. What would be a collateral purpose if you can't rely on it for it? That also we have to think.
Collateral purpose may
what could be a purpose for?
Suppose, my lord, today,
give us an example.
Today, my lord, if it is not a decree for eviction, today, suppose I am protecting my possession in a separate suit, independent suit. Forget not about anything about
That's on a
anything.
higher footing. If you
No,
can use it there.
No, it's not that. I can say you arrest the proceeding. Since look, this application is there, this is the probate.
If that be so, they can do the same thing in.
Arrest the proceeding, my lord. Nobody is here, my lord, before your lordship. No application
They could do the
to
same
that
thing.
sort of, my lord, has been made. Rather, they invited and they have
If
prompted.
they can arrest the proceeding, why can't they have an
No, my lord,
adjudication?
arrest the proceeding, my lord. This is something which they ought to have prayed for. They, my lord, invited, they have participated on trial. They are so, my lord, confident.
Confident.
That, yes, they are so confident they have participated on
You were also confident before you pointed out this. We were confident against you, but now we are shaky. Yes.
But today that is, my lord, one of the ground which has been, my lord, prompted the learned trial court also. My lord, kindly takes up, my lord, that portion of the judgment.
So you say the premise of their claim is that will.
Yes.
If that goes, nothing remains.
That is the only premise.
Unprobated admitted.
Unprobated
So at the threshold, they could be turned out.
Yes. I say, my lord, at the threshold, my lord, today there are provision, my lord, under the Code of Civil Procedure. If he suffered a decree and thereafter he, my lord, gets certain right over the property, because probate court is not, my lord, adjudicating about, my lord, the title of the property. It is only genuinity and authenticity of the
So
will.
that's a different.
If that
Don't go there because
Yes.
we have 6 more minutes
No, my lord,
before you take up the other matter.
that's why I say, my lord, today my learned senior friends client do not have any independent right, title and interest which can be said to be there as on today to object or resist the decree. Keeping in mind, my lord, this lady have suffered and up to the Honorable Supreme Court, and this is one
What
of
about the other grounds? Other 2 grounds? Forgery could not have held.
My lord, forgery, my lord, the learned judge has not recorded forgery. It is the recording of the, my lord, learned trial court, that false and concocted story that has been reiterated by the learned judge. And the submission, it is not the concluding portion.
Now the present petitioner, Gangavora, has filed the stay application under the camouflage of her personal authority. This is a continuation of the submissions.
It is submitted by the land. Yes, it's submission.
And then also submission.
Similar to submissions.
Very well. So forgery is just
Your lordship will find, my lord, page number 3 of the order impugned, 3rd paragraph. Furthermore, this court accept the submission made by the learned counsel of the opposite party that no executor or legatee can establish their right. Any court of justice.
Probate was the main premise. This was the main premise.
Yes. Granted by the will under the right of as claimed, or has granted letters of administration with the will or copy of an authenticated copy of the will annexed. Even the petitioner under the will cannot claim herself as a legal representative being the executives unless the probate of the will is obtained. So, 211 subsection 2 argument is being considered.
So this is all. Any judgment?
Lord, judge, res judicata, Lord, your lordship is not with me. That's why, Lord, I am not.
Not at all with you.
Yes.
Party is the first thing which has to, or under party or through party. Yes, you may say that the veracity of the will or the agreement, those were clinchingly decided, but not between this party.
I was tempted to say that because it may be a case where the company has come forward to the defense with regard to the company itself, and the court has restricted his peripheries to the in between the defense and case of made out between the parties. But here the company's director invited the court regarding her independent right, title, interest also on the basis of the assignment agreement, on the basis of which the suit are pending.
Sir Mukherjee, unless corporate veil is pierced, we cannot do that. And in res judicata, it's completely alien to pierce the corporate veil. Corporate veil piercing or lifting, whatever you say, lifting is probably lighter than piercing. But whatever you do to the corporate entity, that is an entirely different concept. Whether it is fraud alleged, something, or a class action or something like that, we can pierce corporate veil there. But this is in an independent eviction suit against the company, we cannot pierce the corporate veil of the company, and for res judicata we cannot do that. That would be too high a proposition. Unless we pierce the corporate veil and say that this person was the, and where is the control of this person over the company? She was merely a director. Knowledge you can attribute, bona fides you can say, but we are order 22/99/101. These are decided on law, pure law and facts. Obviously, facts has to be there, But on malafide bona fide, this is not an equitable remedy. This is a legal remedy. If it was purely equitable, if it was injunction, writ, we could have understood, Mr. Mukherjee. But this is civil core adjudication due to Rule 100C. So we cannot go on equities. Yes, obviously she had knowledge. And obviously she could take out an application for addition of party. But probably that addition of party would not have been allowed because it would be widening the scope of the suit, of an eviction suit.
Milord, the plaintiff, her name is Milord, there.
Her name is there. She has signed.
The written
Her
statement.
documents are relied. Company says hard documents. Therefore, she has right. Everything. We fully appreciate your thing. I mean, your helplessness. We are also helpless there because at the end of the day, she was not the company. She is not the company. So
That's why, Milord,
even if she was a present director, Mr. Mukherjee, her attempt to be resign as a director, that does not help her. Even if she was a present director, Mr. Mukherjee, then also probably res judicata cannot.
I say, Milord, yes, Milord, I am not.
But that's an arguable thing. You have argued, you have listened. Yes.
Yes, Milord, that's
We'll
why, Milord,
record
I
also.
say, Milord, that 2199, Milord, today she do not have in view of subsection 2, today she do not have, Milord, any right.
Subsection 2 is the best argument. Let us hear Mr. Mitru on subsection. Yes, Mr. Mitru.
Section 211, subsection 2.
Yes.
When the deceased was a Hindu, Mohammedan, Buddhist, Sikh, I'm on Hindu. Let me stop it. Or an
They are Hindu, all are Hindus.
Nothing herein contained shall vest in executor or administrator any property of the deceased which would otherwise have passed by survivorship to some other person. When does a property pass by survivorship? I'm asking myself. In a mitakshara kopasanari, property passes by survivorship, not by virtue of death. Because when in a Hindu,
The will was by Sunil Rai.
by Sunil Rai, Bengali, Dayabhaga.
Daibhaga.
So by survivorship, it will never-
Gangabora is a daughter.
Gangapura is
Third party.
is the company, is the third party to whom with assignment,
So then-
tenancy.
No, the will, you say will, acha, very well. Now,
so
we cannot
so-
go by Gangabora's school.
Gangapura
To be
is not
Sunil Rai's school.
Sunil Rai's school.
Daibhaga.
In a Dayabhaga, nothing passes by survivorship. It's only on death by test, by under section Hindu Succession Act. Hindu Succession Act is on death of the testator or the deceased person. In a Mitakshara HUF, Kopasanari,
So you stress on the word survivorship
survivorship,
as opposed to inheritance.
inheritance. Survivorship, it had to make the difference because by survivorship, if it goes to now this has really become Oshios with the 6th Amendment and the recent judgments. But a Mitakshara Hindu, when he died, he did not go by succession to his son, daughter, but then other members of the Kopasanari who were entitled to right as a survivor.
But can't the daughter be called a survivor?
No, she's an heir in intestis. She's an heir in intestis. This is something argued now. I can develop with judgments that survivorship is only of a Mitakshara Kopasanari.
Which would, that this contemplates intestacy because 2 says nothing
Yes.
herein contained. That means 1 shall vest in an executor or administrator any property to the deceased person which would otherwise have passed by survivorship to some other person.
My lord, here. So, my lord,
Otherwise means apart from the will. That's intestacy.
so my lordship, when the deceased was a Hindu, nothing herein contained shall
Yes.
vest in an executor of
So
the-
1 is neutralized.
No, well, what happens is one say if I bequest a
Yes.
Hindu member of a Kopasanari, if I bequest by will,
So you should say this does not apply to the Abhaga school.
it doesn't apply to Taibaga subsection 2. But may I spoil you for a moment? If I am a Hindu Kopasanari Mitakshara member and I will away a property which is a Kopasanari property, my executor will not get it because by survivorship, my Kopasanari property goes under the Mitakshara school of law to the survivors. I cannot will away a property which is a Kopasanari property.
Or the principle be you're going because it's an accrued right already.
It is a right where on
With birth.
with the birth and with my son being born, he acquires the 1/3 right, right. Grandson being born, he acquires the right. So I cannot
That's
win
why,
them.
that is the reason it cannot be
That is the why.
vested by way of it, because it has already.
Because it's already gone on my. So that's why if I will away an co-pastorate property which is standing in my name, maybe. But if it's a co-pastorate property,
We'll consider that. But judgment cannot be delivered before this side of the vacation.
that up to yourself. But we have since Lordship keeping it after the vacation. Well,
We can
on this point. Then I
we
can.
can sit in court and right now deliver it.
No, I
The
know- I
difficulty
know
is
that.
2 p.m. one matter fixed, 1 p.m. one matter
In
fixed.
case Lordship, then on this co-pastorate, because this is something not argued court below, I find that the survivorship, I can cite a judgment or two, but it's very obvious because survivorship, you cannot will away what is passed by survivorship. It is already gone, but I can cite a judgment or two on this point.
You give the citation, give a give
So
the
tomorrow,
citation.
Ballot, by tomorrow, Lordship without delivering it to this side, Lordship said, so I can.
Tomorrow just hand over the judgment. But
Yes,
he
tomorrow
won't
I'll
have
hand over to Ballot officers. I will not to
no,
them.
he won't have an opportunity to reply to that.
Because this point is taken. This is
Lord, I only say, my lord, 211, 1 and 2. My lord, the distinction is being carved out from 1 itself. That will
it's
clinch.
one
My lord, regarding the
exception to one.
will, my lord, being made, my lord, proportionally, my lord, that distinction is not there. Otherwise, my lord, subsection 1 is being diluted by subsection 2.
We are closing arguments. Hearing is concluded. The matter is reserved for judgment.
Great.
কিছু তো 1 মাস পরে judgment হবে। তাহলে কি হবে? Let us see if you can. Then we don't know. We may deliver it tomorrow also.
My lord, your lordship have other matters, my lord, your lord.
Let us see. Yes. 12 minutes.
12 million fixed item, item number 64.
Yes, may I please your lordship?
Yeah,
I
for the
am
other side.
I'm here.
But the unfortunate other side who has been informed today only.
No. I got
But they
the
had
brief.
some
my lord.
urgency that's
One is 1 hour ago I got the brief.
that's not unusual.
No, that's very usual.
Not
That is
unusual for
actually-
your particular this
Yes,
client.
Yes, yes.
Yes, what is it?
Firstly, I apologize to trouble your lordship, my lord. Firstly, I apologize to trouble your lordship.
Why should you apologize? Your client has urgency, have come.
Um,
Your learned friend is absolutely, we are just joking. He's absolutely fair. If he's informed, he'll definitely be there. Please.
My lord, a vacancy notification was floated by the respondent number 5 subdivisional controller, my lord. Now, my lord, firstly, a
For
vacancy
what post? For what?
for FPS dealer.
I
For
feel-
FPS dealer, my lord. Now, my lord, firstly, in 2024, a vacancy notification is not. My lord, these are what the admitted facts are. I am saying that. My lord, firstly, in the year of 2024, a vacancy notification was floated.
Yes.
Now, my lord, I and the private respondents both applied for that vacancy notification for an FPS dealer. Subsequently, the notification was cancelled. Again, the vacancy ID was renotified in the year of 2025. Now,
What order have you challenged?
Now, my lord, the challenge is that, my lord, I sought for an interim order before the read court. My lord, the read court has not taken up the interim order for consideration and has directed me to take for instructions. And in fact, the read court has himself observed, the learned read court has, with greatest respect to the learned judge, my lord, himself observed that the ration articles will be distributed from the month of October. But, my lord, my interim prayer has not been considered, my lord, and
What was your interview? You have challenged what? Grant of FPS dealership to private respondent.
private respondent.
So what is the interim order? That it should be stopped, the distribution.
My
It's
lord,
a public distribution system. We cannot do it.
but my lord, I am suffering, and my lord, the subdivisional controller himself says that I am eligible, and my lord, I can for now, my lord, I can demonstrate before lordship.
Public distribution of
My lord, I can demonstrate
these are
before
food
lordship.
items. Public people will starve,
My lord, it will.
and people from the marginal sections will starve.
My lord, it can be tagged with another ration dealer, my lord, for now how it has been functioning, my lord. And now, my lord, the godown is over a Shali land, and my lord, the most important thing that I have raised before the read court is that the plinth level, my lord. Now, my lord, the plinth level, there is a condition in the notification which says that the plinth level should be more than 1 feet. I can show to your lordship, my lord. My lord, may kindly.
These are not things for which public distribution is stopped.
But my lord, I am an eligible candidate, my lord. The subdivision controller also.
This will abide by the result. You'll be entitled to damages at best. At best, damages. We'll make that clear.
My lord.
That if you are entitled, you can claim damages, or and that this will abide by the result of that we can add and modify the order and just leave it
My
at
lord,
that.
may only. My lord, may
Private respondent is not there.
My private respondent, I have served in the read court, my lord. The appeal I should be candidate, my lord. I have not served because it was a hasteful filing of appeal, my lord. But in the read court, I have served, my lord. And my lord, that has been observed, my lord.
No interference.
Then my lord.
Mr. Banerjee.
My lord.
No, Mr. Banerjee. No.
No, my lord, may only see one document, my lord. Only one document. My lord, page number 34 is a vacancy notification, my lord. It is illegible, my lord. I have annexed a type copy, my lord. 39 is the type copy, my lord.
So eligibility goes hand in hand with eligibility. Page 34, yes.
34 is the vacancy notification.
Right.
39 is the typed copy, my lord. Kindly comes to the typed copy, my lord, because it is illegible, my
The
lord.
type copy reliable? Have you checked up?
Yes, my lord.
Sometimes it is not.
No, my lord. The type copy is reliable, my lord. In fact, page number 41, the part I am relying on. The line
Is that plinth level thing?
Yes, my lord.
The
That line
measurement.
was not reliable. I have corrected it in my own form.
Yes,
my
right.
lord.
Right.
The plinth level should be 0.30 meter.
You say he did not have that plinth level.
No, my lord. And my lord, I have checked up with a surveyor, my lord, independent surveyor. I have annexed the report also, my lord. My lord, may kindly comes.
You have been held to be eligible.
Yes, my lord.
Oh, you are otherwise eligible.
Yes, my lord. Kindly comes to. My lord, it is their submission, my lord. They have handed over the instruction before the read court, my lord.
Hearing was also conducted.
Yes, my lord. Hearing was conducted, and my lord.
What is your grievance in that?
My lord, page number 65, my lord. Kindly comes.
Yes, 65. We are also at 65.
My lord, may kindly sees that during the inquiry, both applicants, yourself and Aisha Arvind, were found eligible. But the competent authority of food and supplies department, after due consideration, found Aisha Parveen as most eligible. My lord, there are no reasons for that. Why? I will tell your lordship, my lord. I have checked up with both the godowns with an independent surveyor, my lord. The best evidence I can give you the read quote, my lord. Now page number 66 kindly comes. Page number 66 is Aisha Parveen's godown, my lord. Now, my lord, makes sees the Patra FP school is a central location. Now, from the central location, his distance, her distance is 2 kilometers away. 2 kilometers away, and my lord kindly sees the
This map is produced by you, by a surveyor.
By
You
a
have
surveyor.
produced it.
By a surveyor. Now, my
It
lord,
has to be gone into by the authorities.
my lord, I
If you want, we can dispose of the writ petition by itself by saying that the representation will be. Your grievance was that representation to be considered.
I have given a
Representation has
demand
been rejected.
I have given a demand justice. They didn't consider it. They didn't
Came
consider
up to
it.
the writ petition.
I came up with the writ petition. Now, during the hearing of the writ petition, my lord, Mr. Dotto appearing for the
When is the distribution scheduled to be done?
my lord, from the month of October. That is noted in the impugned order, my lord. On the month of
We
October.
cannot hold that up.
My lord, only one prayer, my lord.
Even my lord cannot hold it up.
My lord,
I also can't, my lord also can't.
my lord,
In both
only-
capacities.
Only one prayer, my lord.
Yes.
The writ can be disposed of only for 1 month. If the writ can be disposed of in the month of November, I will not stand in the way of expeditious disposal, my lord. But my lord, my grievance has to be adjudicated for. I am ready and willing. I will not take any adjournment. My lord will kindly
Do what?
to the disposal of the writ petition. I will not stand in the way of the disposal of the writ petition, my lord.
No,
But
not that. But we are saying that we can dispose of the writ petition and direct them to consider your representation.
the representation has been considered, my lord, and they have said that I am eligible. So they have.
But they have been found to be more eligible.
But my lord, that is my point of challenge, my lord. That because they are not more eligible.
Public
Kindly-
distribution services are not stopped like this, and it's well settled now that even you see the premise of the new legislations also. Specific Property Relief Act, the change has been brought regarding infrastructure projects.
My lord,
These are all on this premise. Public systems cannot be stalled.
I mean, their go down is on a Shali land, my lord. My lord, kindly sees. Page number 68.
No interference, Mr. Banerjee. Sorry. This will, whatever happens, the outcome of this will, whatever, if if the distribution, if the FPS license is given to them, that will abide by the result of the writ petition, and also will make it clear that you will have your remedies in damage or otherwise if you are otherwise entitled to.
My lord, may kindly make that clear. My lord, then kindly writes.
Only that. Only.
My lord, then kindly writes expeditious disposal of the writ petition, my lord, because
Cannot. Intracourt.
my lord, I understand that, but my lord, my eligibility, the prima facie, my eligibility is being suffered, my lord, because they are
When
not
has
at
it
all
been
eligible.
fixed? When has it been fixed on any date?
My lord,
1 week
1
after
week
puja.
vacation, my lord. Everything
We will
will be
express our confidence that this will be disposed of. Only that. We are confident and we will express our confidence. Oh, sorry.
Well,
Yes.
of the documents are possibly not part of the writ petition.
Oh,
Page
then we
66
cannot.
onward.
My lord, the surveyor's report is not, but my
Not
lord,
part of the writ
but,
petition.
but my lord,
It's
that
a
has,
question of fact.
my lord, that
The
has
Hit
been.
court cannot go into. This
My
is
lord,
not an
that has
applicable order at
That
all.
has been
Not an
awarded in the
applicable
repetition.
order.
My lord, the documents has been awarded in the repetition. The part of the, my lord, the
But
contents
then-
of the documents has been awarded in my repetition. I can show that.
I
can
cannot
show
show
that.
that because I don't have the copy of the writ petition. at
No,
the moment.
repetition copy is annexed with the.
No. You have referred to these particular documents.
No, these documents were not annexed with the report. But my lord, these documents, the contents of these documents
The
is
private
awarded in the
respondent-
repetition.
Contents of these documents were awarded means
The repetition. My lord, kindly comes to my repetition.
shows that. For example,
Well,
page 66.
Page
Where is
59 is where.
The affected party is not here, not served.
I say, আমার এগেন্সে যাচ্ছি তো আর কোনো অবজেকশন করবে ঠিক আমার এগেন্সে
কত applicable order নেই ভাই।
My page number 59 kindly comes. My first ground for that the new notification dated 28/1/25 mandates that plinth level of the godown level should be such and such from ground level or road level. For that private respondents godown has plinth level 3 feet low from the road level. The petitioner's godown has a plinth level of.
No, Mr. Banerjee, no interference. We'll just.
My lord, kindly observe that it will avoid the results of the repetition.
Yes,
The
we'll do that, Mr. Abide by the result, and they'll be entitled to other reliefs like damages. If they're entitled, then court will consider that.
And my lord, then kindly
If
kindly writes the report to consider these documents also. The survey.
No, we won't direct anything. If you have not produced, why should it be?
A liberty to file a supplementary affidavit with the report.
We shall not give that liberty. You have to ask for that before the.
Yes.
Third learned counsel for the parties. Of the present challenge has been preferred against an order dated September 15, 2025, whereby comma, it is argued, comma, petitioner stroke appellant before the writ court. Full stop. Next para. It transpires from the impugned order that the learned single judge merely directed counsel for the petitioner to take instruction regarding fact narrated by the learned additional government pleader to the effect that the license of the impugned vacancy notification has already been granted in favor of the private respondent, and allotment has already been made in favor of the private respondent, who will distribute the ration article since the first week of October 2025. Full stop. Next para. Learned counsel for the appellant argues that it is evident from the communication made to the appellant, comma, annexed at page 66 of the stay application filed in connection with the appeal, comma, that the appellant was also eligible as the private respondent, even in the perception of the respondent authorities, for grant of FPS license. Full stop. Next para. However, comma, it is contended that it will also transpire from the layout of the land, comma, as reflected in the map annexed at page 66 of the stay application filed herein, comma, that the specifications of the property required to be offered by the candidates, comma, to be eligible, comma, was not met by the private respondent. Full stop. Apart from the land being land of the private respondent, apart from the land offered by the private respondent being a shally land, comma, the plinth height of the godown did not meet the criterion as per the vacancy notification concerned. Full stop. Next para. Learned AGP submits that the documents now sought to be relied on were not part of the writ petition. Full stop. Next para. Learned counsel for the petitioner appellant submits that although not annexed to the writ petition, comma, the contents thereof were referred to in the writ petition. Full stop. Next para. Learned AGP also opposes the prayer and points out that there is no infirmity in the impugned order, and that since license and allotment have already been granted in favor of the private respondent, comma, the learned single judge was justified in not granting any interim order. Full stop. Next para. We find substance in the contention of the state. Full stop. Next para. Insofar as the impugned order is concerned, comma, we do not find that the same tantamounts to a double inverted with the judgment within the contemplation of the latest patent for interference by this court. Full stop. Next para. In any event, comma, it is reflected from the impugned order that the FPS license as well as the allotment have already been issued in favor of the private respondent, who is to start distribution of the ration articles from the first week of October 2025. Full stop. Next para. Keeping in view the public interest element involved in the public distribution system of ration articles, comma, no interim order ought to be passed at this juncture, comma, which will paralyze the said distribution system, comma, thereby adversely affecting multitude of people coming from the marginal sections of society. Full stop. Thus, comma, there was no illegality or infirmity in the impugned order in not granting interim orders in favor of the writ petitioner stroke appellant. Full stop. Next para. As such, comma, the impugned order does not call for any interference. Accordingly, MAT 1704 of 2025 is dismissed on contest without any order as to cost. Full stop. Can 1 of 2025 is disposed of consequentially. Full stop. It is, comma, however, comma, made clear that any action taken in the meantime shall abide by the final outcome of the writ petition, and it will be open to the writ petitioner stroke appellant, comma, if otherwise entitled in law, comma, to claim other reliefs by way of damages or otherwise, which is subject to the consideration, which shall be subject to the consideration of the writ court. Full stop. We, in any event, comma, we are confident that the learned single judge shall dispose of the writ petition early, and as such, full stop, early, full stop. Yes.
My lord,
Arjun
only-
certificate.
only one prayer, my lord. Can it dispose it of not? Can it dispose it of instead of dismissal, my lord? Or because that will have a bearing over the learned single judge, my can't because my
Let
lord
it
has
have-
granted me some relief, my lord. My lord has granted me
Give some relief to the learned single judges.
my lord. Can it dispose
No,
of
no,
my lord?
dismissal is dismissal. This disposal business, no. If you partially set it aside or modify it, then it's a disposal. Let us be very clear on this.
This is not an
We have
appealable
dismissed
order.
on
That's what I
merit.
said. It's not an appealable order at all.
Intra-court appeal does not lie. Latest patent, it does not
Yes,
come within the
that's
contemplate of a
the interim
judgment.
order. Lordship.
Obliged.
We gave him the highest benefit of doubt because of his youth and because there is a yes deemed refusal of stay may have some ramification, but in this case, no.
He's
You already issued license, allotment,
everything.
everything done.
Lordship, great.
Item number 7 with 8.
Item 7, I'm appearing, my lord, for the defendant respondent. My learned friend is appearing also for the same party, but in item number 8. 8, my lord. But then appellant,
Where is the other side? You are for Parvati Charan,
I'm my lord for, yes, I'm my lord for Devi Charan. Devi Charan.
Devi Charan.
Devi Charan. And my lord, here, my lord, it's an old appeal to.
What is the matter against? Probate.
No, my lord, there's a suit filed claiming by the plaintiff declaration
Which
that.
is the plaintiff? You or the other?
No,
side?
I'm the defendant.
So Parvati Charan filed this suit.
Parvati Charan, my lord, Parvati Charan. Bhagavati Charan filed the suit. And then his son was substituted.
Parvati son of Bhagavati.
Parvati son of Bhagavati, yes, yes, yes. And thereafter, my lord,
Yes.
suit was filed by the original plaintiff.
Suit for declaration of title.
Declaration of that he's a trustee. That he's a trustee of the trust, where, my lord, then injunction application was filed. The learned
Injunction regarding restraining you from?
restraining from dealing with the trust property.
Who are you as per him?
As per him, I'm the other trustees. So, my lord, here what happened was that
Injunction has been
refused by the trial court.
Right.
Upon contested hearing. Thereafter, an appeal was preferred. In 2005, they obtained an order in the appeal not to create any third-party interest in
the
wrestling.
2005 appeal.
2010. I'm sorry.
So that is one appeal, their appeal.
Yes, my lord, that is their appeal.
What is your appeal about?
My appeal is my learned friend is appearing. My lord, that is, I'm not briefed.
Why have you preferred an appeal
My
against it?
lord, in this appeal, my lord,
It is the same order.
no, my lord. In the another order, my lord, the Parvati has been appointed as a trustee, my lord, violating the
Appointed as a trustee means?
new trustee appointed, my lord, by
By the court.
not court, my lord, by a deed, my lord, deed of a new trustee.
What is
my
the
lord.
impugned order in the other appeal?
My lord, in this order, my lord, the impugned order, my lord, the Parvati, my lord, the
What is the impugned order?
impugned order, my lord, I have challenged that order, my lord. The new trustee appointed by the London
Is that
court-
appealable? Under which provision? New
To
appointment
my
of new-
learned friend is order 22 rule 10 being allotment. That's an
Appealable
from order 22 rule 10. Though I'm not appearing in that matter.
appealable order, my
Let the other set come. Let's take it up after the vacation.
We
What can be done?
Give notice, my lord, to the learned advocate who has earlier
Do
appeared.
that. Do that.
Mr. Shorodipto Banerjee had been appearing for
both the
appeal.
appeal, my lord.
Acha,
Oh, he's not. No, oh, I'm told that he has been informed that he's no longer appearing in the matter. Shorodipto Banerjee. Can I give notice?
you are for Devi Charan, you said.
Yes, I'm alert for the Devi Charan and Omio Charan. My lord, the different numbers 1 and 2. Respondent numbers 1 and 2.
I am also Devi Charan in the
Yes,
appeal.
Devi Charan and
my lord, Omio Charan, my lord, the two respondents.
learned counsel for Sri Devi Charan. বানানটা এখান থেকে দেখে করতে হবে
Charan Rokit and
দেবী
Omio
চরণ রকিট আগেকার বান দেবী চরণ রকিট রক্ষিতের and অমিয় চরণ রক্ষিত in FMA 565 of 2011 sorry in FMA 861 of 2005 and Devi Charan Rokit himself in FMA 565 of 2011 are present in court today. Full stop. However, comma, none appears for the other side in either of the appeals at the time of call. Full stop. Next para. The learned advocates on record for Devi Charan Rokit and Omiyo Charan Rokit are requested to serve a notice on the on their adversaries কথাটা use করো না on the other parties comma directly and stroke or through their learned advocates comma indicating the pendency of the matter in the list. Full stop. It is made clear that in the event the in the event Parboti Charan Rokit is not represented on the next occasion, comma, the matter may be taken up ex parte in the absence of the said party. The matter shall next be listed in the matter is adjourned till after the upcoming annual vacation.
Right.
It will appear immediately. It will remain in the list actually.
Grateful. my lord.
পড়া হয়ে গেছে? What will be in the list?
Item number 9.
Your Lordship, I am.
Yes, Dr. Dev, we don't find merit in your appeal. We went through it again and again.
Huh?
Went through it again and again. No merit in your appeal. You admitted it
Your Lordship, I am.
because review
Law.
to one
suffering
is concession by council. One concession by council. We admitted it definitely because concession.
Hard clock, I am suffering from.
We understand, but this concession was there. You took advantage of partially your
No,
part of the
Lordship, I am.
your part of the concession. You took
I did not get my 4 promotion. I did not get my salary. I was.
Considered
I
to
was
that.
not. And I have.
Considered to.
I have.
And concession on fact is binding. Concession on law is not binding. Fact is binding.
It is that I was prevented. I was not allowed to work there arbitrarily and maladroitly. I was prevented from 5th September to 5th August.
But Doctor, didn't you receive gratuity and notional retirement benefits?
Nothing, no gratuity without.
Those were granted to you. Those were granted to you under the order.
Gratuity without interest as per Payment of Gratuity Act. Provident Fund, even I didn't get my
Did you get a single
because
paisa?
Provident-
Did you get anything? Did you receive anything?
Something I got, but.
What have you got? Whatever was agreed to by both parties.
No, they have not agreed because the company is closed and the Ministry of Railways have
When
taken.
the order was passed, the review is of an order dated August 2nd, August 2007.
They
On
have-
that date, it was please let us finish. Let us finish. On that date, it was recorded that it was a concession given by council of the parties that you are foregoing the interest and the rest will be given to you.
I also filed a case 10189 in 2011, and the case was heard by Justice Ashim Banerjee, and he at that time Ministry of Railways has taken, and they have increased the salary 3 times, which I have not received. I have received very poor salary of 14,470, but they have increased to 42,000. But arbitrarily, my name was not paid by Gulakhori Nag, and the person, chief manager of Southeastern Railway, who was entrusted with the job of closing the company, he said, what I do, your people did not give the name, so you better apply to Railway Board. Accordingly, I made 4 representation to Railway Board, then GM Eastern Railway, and they said we have no objection provided there is a court order. And the fact remains is that in the Supreme Court order in Sikant versus Bharat Heavy Industry, that I want to read out the next other day. I can read out next. They said if any workman is willing to work but was prevented by the employer, then in that case, that employer is bound to pay his or her salary along with consequential benefit. Shall I read out the order of Supreme Court, sir?
Yes.
Which I annexed and can 12 at page 17 to 20. I have annexed that order. Annexed that order. Page, and only I am referring para 30. Para 30.
Can 12 bar kore din.
Para 30, Your Lordship. Your Lordship, I am only reading out the para 30.
Recent can.
Srikant
You will be relying on which cans, Dr. De? Can 12 only for the time being?
Your Lordship.
For the time being, we will look into can 12 only. Which page? Can 12
Page 17 to 20. It is annexation 1.
Annexation 1. Yes, yes.
Srikant versus Bharatat Movers Limited.
Right.
We must frankly admit that we are unable to uphold the situation.
Which paragraph you are reading, Dr. De?
Para 30. Para 30. Para 30. Page 20. Para 30, Your Lordship.
para 30. Yes, please
We
continue.
must frankly admit that we are unable to uphold the contention of the respondent company. A similar situation has arisen in Jane Sivastava and a similar argument advanced by the employee. The court, however, negated the argument, observing that when the workman was willing to work, but the employer did not allow him to work, it would not be open to the employer to deny monetary benefits to the workman who was not permitted to discharge his duty. Accordingly, the benefits were granted to him. In Shambhu Murari Sina 2, also this court held that since the relationship of employer and employee continued till the employee attained the age of superannuation, he would be entitled to full salary and allowances of the entire period he was kept out of service. In Balaram Gupta, in spite of specific provision precluding the government servant from withdrawing notice of retirement, this court granted all consequential benefits to him. All consequential benefits to him. The appellant is therefore of salary and other benefits is entitled. The appeal is accordingly allowed with cost. Your Lordship, Justice Showmanship has agreed with this, and His Lordship, what I said the next day, that is Annexure 2. Annexure 2. Annexure 2.
Ajay, you had asked for an assignment before Justice Sen. What happened then?
As Justice Sen was taking the other party said you are not, you have no determination, and he was very.
No, it was, you said you would take assignment.
Yes. But
Assignment.
His Lordship take the matter on something.
What did he say?
He wants to take the matter. The other party said no, Your Lordship.
Cannot be.
Yes.
I can.
What
Could never do.
His junior was
Court would
present.
never do.
His junior was present. He said, Your Lordship, you have no determination. You cannot take.
No, if
this."
it
He
was assigned, he could not have said that. You
He was arrested, but
not
I will
correct
not
me.
take this matter. That was the thing was there. That he said that I will not take that. He said my that time I was there with
Justice Sen released it.
Subrata Government. He was not there.
Justice
His
Sen
junior was
also.
there.
Justice Sen also released it.
He's released the case. There's a order in this, Your Lordship. There's an order that this court cannot take this matter because that time I was with Subrata Bhattacharjee. The court is different. He give that he has released the case.
রিভিউ অ্যাপ্লিকেশনটা একটু দিন তো, যেটা রিভিউ মেইন রিভিউ।
He has released the case.
না, এটা তো এফএম এটা না? দিস এ রিভিউ অ্যাপ্লিকেশন। এটা তো উই আর হিয়ারিং এ রিভিউ অ্যাপ্লিকেশন টুডে।
No.
FMA.
FMA.
Let us see the impugned order once.
See this, Your Lordship. That
What is the impugned order? Date of the impugned order, Dr. De?
of Justice Sen.
No. This we are hearing the appeal. Appeal is against an order.
9 September. You have taken.
মেমোটা কোথায়? মেমো
9 September. This order.
এটা
In your order, Your Lordship has said that.
not that. Let us come to the order against which you have preferred this appeal. This appeal is still pending. Mr. Chakraborty, this appeal is pending. Appeal was disposal. Just file a review.
He subsequently filed an application.
Filed the application. Can before that can 1089.
That was not in the nature of review, as has been observed by Honorable Justice.
Your
But we
Lordship,
made it a review application and
Your
Your Lordship has said it is a matter of review.
Impugn-
You're on 9 September. Kindly see your order. Kindly see your order.
it's the only thing we have seen till now.
But
It's the only thing we have seen till now.
Impugned order is
Other than the judgment you cited.
dated 23rd August 2005. That is the impugned order.
thereafter,
23rd August.
same judge was heard. Allow me to say, Your Lordship,
Against that order,
after
he
second that can 10189 of 2011 was heard. Thereafter, as per the order of Justice Abhuvata Chakraborty, can 12 of 2024 was filed. I was very much entitled of service, and I was. Your Lordship wants to see my
We'd
High Court enrollment that I want to place.
23rd August 2005. That was the order of Honorable
Nah.
Single Bench against which the appeal was filed.
Kindly see my enrollment
disposal
that
করে
last
দিয়েছে।
day you have ordered me.
অগাস্টের অর্ডারে অ্যাপিল ডিসপোজাল করে দিয়েছে, করে দিয়ে সেখানে ওদের কম্প্রোমাইজ কনসেশন রেকর্ড করে ইয়ে করে দিয়েছে। Second order 2007 order to বার করতে হবে।
Lordship, you have said that last day to file the enrollment order of Bar Council.
Keep it with you. Why are you showing us the enrollment?
You want to show the enrollment, the number.
We wanted to see your enrollment.
Not enrollment, the number, the date and number. That
Your
is,
enrollment number. We. Why should we?
whether I am an advocate after my service as retirement as assistant manager, I enroll
We
myself.
never asked for your enrollment number.
No, that day you have asked, Your Lordship.
No, we only inquired of you whether you are an advocate or not an advocate.
Yes, yes.
You said you have joined.
I want to
Have you disputed that? Have you disbelieved that?
submit my documents.
We don't want to take it.
It's all right.
You are saying that you are an advocate. We'll disbelieve you.
Oh, that 2003.
If we really disbelieved you, Dr. Te, we would make it so clear that there would be no option but to produce this.
Please excuse me.
only
I
one
only 1959
We don't disbelieve.
I have enrolled my name.
Who is disbelieving that?
2003.
Anyway,
Only
yes.
one interruption, my lord. I have taken instruction from my learned friend.
Yes.
When it was assigned before Honorable Justice Sen was of the opinion.
He was the person who shouted and said,
No, he did not shout. He is telling me that justice.
the culprit is for you.
That is order is there, Your Lordship. In the
Yes, then
Justice
what?
Sen
Justice Sen
expressed an opinion that since on earlier occasion Justice Sen was pleased to hear it with Honorable Justice Sougata Bhattacharya, therefore for assignment before that bench the matter was released. This is
Let that bench be constituted then.
my lord, this is the instruction why it was released on that day, not for a fresh assignment before any other bench. Justice Sen was of the opinion that Justice Sen would see to it.
Whose brainchild was it to assign to us? The
Lord,
Secretary to the Chief Justice will issue a rule against him.
signed by his
My
Chief
lord,
Justice.
this is the instruction. My learned
Chief
junior
Justice
brother
has
is saying that he
assigned
did
the
not raise
same
any objection. On that impression, it was released. He did not express any opinion against.
Have you got a copy of the second August 2007 order?
Yes.
Order of 2nd August 2007, because you have treated to be a review of that. সব তো উল্টো পাল্টা করে রাখা কত বছর ধরে আছে কত বছর ধরে জন্য আছে
Yes, Your Lordship is there.
সবাইকে আর্দালি ফার্দালি যারা আছে ডেকে খুঁজতে লাগিয়ে দিন তো ফাইলগুলো খুঁজুক 2nd August অর্ডার কোথায় পাওয়া যাবে
I was prevented, I was not allowed to work, and I am entitled of this order.
No, we are wanting to see the 2nd August order.
This is the second order.
Is it annexed anywhere in your applications?
This is the second August order.
You have it? No, you must have only one copy. Is it a part of any application, Dr. De? Any application?
What?
Is it an annexure to any application?
Yes, it is.
What is the application number?
CAN 10189. CAN 10189. Page 11. Page 10. Page 10. I got heart block. I could not say properly. I'm sorry for that and wasting.
No, Dr. De, if you want, you can sit and argue also.
No, this is all right.
No difficulty, you can sit and argue.
No, I was.
You can sit and argue, no difficulty. Actually, no difficulty.
I was arbitrarily not get for promotion. I was not get the highest salary that was given by the railway board in the 15 September 2010 after taking that Bunsander company, and that salary I was given the effect from 1997. 3 times higher.
Dr. De, please come to the order of 2nd August 2007.
Thereafter, also the case was heard by Justice Banerjee and
Maybe heard by several benches. We are not interested. This is the last order which was passed. This is the order disposing of the appeal. Now, unless this is recalled or reviewed, please let us finish. Unless this is recalled or reviewed, we cannot have any window to the matter because the appeal itself.
So much, Your Lordship, kindly think about this.
Dr. De, you are not understanding what we are saying. It's our limitation that we cannot impress upon you.
No. I'm
By 2nd August 2007 order, the appeal in connection with which the present application has been filed, the appeal itself was disposed of. It was disposed of on recording a concession given by the appearing parties. So it's a consent order. You
No,
have
just
now
not
filed an
consent.
application for reopening that.
Consent order, Your Lordship. Dr. Pal came and within 2 minutes he left. No consent order. He
Within
left
2 minutes, the
immediately.
concession was given. Dr. Pal was very fast.
No, he left.
So now you, otherwise you don't have any case whatsoever. You are making it very clear. But we converted your application because your application is for an application for new cause of action. This is the caption. For new cause of action arising out of non-existence of burn and standard order 47. Just you have mentioned order 47, but no ground of review was revealed. So we formulated two grounds in our order
Yes, Your
that we
Lordship,
treated is one. First ground is whether the concession given by counsel, that is Dr. Pal, on behalf of the parties is binding on the parties without there being any specific instruction in that regard, and or any power being given to counsel for giving such concession. So whether that is binding on one. Secondly, whether in view of the coordinate bench by the order under review having granted gratuity and notional retirement benefits in favor of the applicant, deeming you to have worked till August 5, 2003, when you are deemed to have and August 5, 2003. These were the two questions formulated. Second is dependent on the first, because if concession remains, then there is no scope of any reopening that order. Now, let us come to that order of 2nd of August, please. Dr. De, please read that out for us.
Page 10, page 10.
You read out for us. Just, you need not read out the entire order. You may start from
What the order?
who was the respondent there?
The salary.
Fund standard was the respondent. Very good.
I cannot read out, Your Lordship. So, I'm suffering from this. I don't need any notional benefit. I don't need any other gratuity or provident fund, because the provident fund is exempted fund. They are keeping that money which is deducted from my salary is under their custody, and this is allowed by Provident Fund Act and rules.
We are reading out the relevant portion of that order for you.
So
Dr. De, you have to hear us. If you want us to hear your matter, you also have to hear us.
Yes.
If you stop hearing us, then we'll stop hearing you. No. It's as clear as that. So if you say something, you have to hear us. Please come to page 14 of the application. This is a continuation of that order dated 2nd of August 2007, by which your appeal was disposed of, in which you have filed a reopening application. Please come to the second paragraph of that. Have you got it? It starts with today.
But I couldn't read out. It is so.
We are reading out for you. We are reading out. It says, today, when the matter is called on, Mr. Mujumdar, learned counsel appearing for the respondents. Respondents means bond standard, them. Appearing for the respondents on instruction contents that in deference to the desire of this court, the respondents are ready and willing to substitute the order of removal from service by order of premature retirement as on August 5, 2003. Dr. Pal, learned counsel appearing for the appellant, that is you, on instruction, means from you, has accepted such proposal. Mr. Mujumdar further agrees to withdraw all allegations made against the appellant by the management so that the controversy is resolved once and for all. In view of the concession made by the appearing parties, we dispose of the appeal by the following order. Then it was held, the appellant would be treated as retired from service with effect from August 5, 2003. The allegations brought against the appellant would be treated as withdrawn and or cancelled. The appellant would be entitled to all retirement benefits available to her up to August 5, 2003. She would, however, be not entitled to salary for the period from September 5 to August 5, 2001 to 2003. She would, however, be entitled to all notional benefits. So everything was given except September 5, 2001 to August 5, 2003 salary. This was held to be on concession. Now, a concession order, as you know very well, you're an advocate, a consent order cannot be challenged unless you approach the same judge or the same court and say that concession was recorded wrongly. That has never been done. The judge has retired, both judges have retired. We will retire soon. After so many years, 2007 order, now it is 2025. Now
Can 10189 of 2011, the case was heard.
Filed after say 17 years almost, this application.
No, your lordship, there is, I filed the order on can 16 in can 18, but that has not taken. You see that so mentioned orders there is.
We have
this-
found out only one point in your matter. Please take your seat. We'll ask Mr. Chakraborty. Then we'll seek a reply from Mr. Chakraborty.
Milord.
We have to read the order as a whole, right?
Milord.
So, if you please come also to page 14. So, page 14 is the crux of the matter.
Milord.
So, the concession given was recorded, and on the basis of that concession, this order was passed. There was no concession recorded to have been given by Dr. Pal regarding her salary not being given. We are just reading out this portion.
So mentioned as-
Today, when the matter is called on, because Dr. Dey has some difficulty, Mr. Chakraborty, we prefer to read it for her. Today, when the matter is called on, Mr. Mujumdar, learned counsel, appearing for the respondents on instruction contents. Now, this is very important, that in deference to the desire of the court, the respondents are ready and willing to do what? To substitute the order of removal from service by order of premature retirement as on August 5th, 2003. This is the first concession given by you, that it will not be a removal but a premature retirement. The date will be August 5th.
2003.
Dr. Pal, learned counsel, appearing for the appellant on instruction, has accepted such proposal. So this was the proposal which was accepted. Next sentence, Mr. Mujumdar, it was on your behalf, unilaterally, further agrees to withdraw all allegations made against the appellant by the management,
No allegation.
so that the controversy is resolved once for all. So two concessions given by you, Mr. Chakraborty. First is termination, removal of service from service will be replaced by premature retirement,
Premature retirement. And
which you have done.
Yes.
Yes. Withdrawal of allegations. Dr. Pal agreed to this removal of substitution of removal from service by premature retirement. This was agreed to by Dr. Pal, right? No other concession was recorded or given by Dr. Pal.
But that
So
is-
therefore, both of us, can we talk together? Please take your seat.
So
No, you have to take your seat.
I beg to be excused.
You have to take your seat. Now, Mr. Chakraborty, the rest which follows is an adjudication by the court. Because in view of concession made, who gave the concession, they agreed.
Yes.
They gave no concession. In view of concession made by the appearing parties, we dispose of the appeal by the following order. Now, then the order follows, everything is given to her. Notionally, premature retirement was on August 5, 2003.
Milord.
So therefore, why shouldn't she be entitled to the salary for August 5, 2003? She is notionally, she was in service. Give that salary, get it over with. No further assignment, nothing else.
But since I am appearing for the respondents and not for the appellant, I have some points.
Yes, your points. Now we are on your points. It was not a concession order. What could be a justification for depriving her of the salary if she's notionally deemed to retire on August 5th?
Without giving any.
Kindly come to the first portion of this order.
Yes.
The order of the learned single judge was recorded.
Yes, Mr. Chakraborty, please take us there.
Actually, Milord, can 12 টা খোলো তো? It is
Liable to be dismissed on merits.
specifically recorded that that is the period during which the appellant actually did not work. And that date, the appellant was working in Bond Standard Company Limited since 1971. She was charge sheeted on the ground of tampering leave application. She was-
Tampering?
Leave application.
Leave application. Mr. Chakraborty, learned single judge granted her liberty to approach the civil court for her claim for salary for the period from September 5, 2001 to August 5,
Milord,
2003.
all papers are not with me. Actually,
No, we are reading from here only.
yes, yes. I obtained some.
Nobody challenged this order. So this order remains. The division bench recorded that learned single judge gave her liberty to approach the civil court.
This was recorded on the ground, Milord. Actually, Milord, I am in some difficulty because the writ application and the memo of appeal
Nothing.
order, nothing is there with me.
Understood.
It was the instruction specifically from my client, from the railway authority.
Mr. Chakraborty, let us pass a wrong order. The quantum of salary which be such that you'd be deterred from taking out an SLP.
I'm submitting 2 points on that. Thereafter, your lordship. I
So
will-
So the quantum of salary is less than the SLP advocate's costs. So we'll take that risk. Give us the salary.
After this order was passed on consent, the appellant took out a contempt application.
He has
For the
done so many
portion-
things.
For the portion
Chakraborty, you can also appreciate, I mean,
which he actually got,
what did she get?
for the benefits, notional benefits and
Other things she has got.
Other retirement benefits, he filed an application for contempt.
Acha.
That was heard and disposed of.
Dispose of by holding that you have paid her the notional
No,
benefit.
no. There one interesting part is there.
একটা সময় ফিক্স করেছিলাম না? You have to give it part hard, Dr. De. Another matter has been fixed at 1. Mr. Chakraborty, sorry, please come back on the next day. We fix an urgent matter.
Please.
Heard in part for further hearing on October 24, 2025. The reopening day after the vacation.
You know, instead of 24th, may it be on the next Monday,
November
27th,
27th?
as you know.
Very well. তাহলে October 24 না করে October 27.
On 24th October, I have some difficulty. I may not be able
No
to
difficult.
come in time.
Dr. De, we'll take it up next. It will appear in the list next on 27th October, the day after the reopening date. Please come back on that. কনসেশন ওটা ছিল যদি বাকিটা একটু ধরা সময়টা কাজ করেছে যদি ধরে নেওয়া হয় যে সার্ভিস থেকে রিটায়ার করেছে কাজ করেছে তারপরে যদি এন্টারটেনমেন্ট থাকছে রিটায়ারমেন্ট যদি একটু ধরে দেবে কোনো একটা অ্যালিগেশন নিয়ে যে কাজ করে সেটাও তো রান করুন কল
1 PM fixed matter item number 62.
Yes.
Private respondent.
You have violated legitimate expectation. Mr. Ghosh was not supposed to come. Yes. What is the matter, Mr. Ghosh?
Madam Lord, your lordship, let us see the petitioner's predecessor interest lord was recorded owner of in the CS record of 40 decimals of land in DAG number 170. Lord, your lordship will get the record of right at page 52. It is kindly come to page 52, Lord.
Be very precise, Mr. Ghosh, because we
Lord,
sit up to
yes.
1:15
Lord, yes, I know.
from 2 p.m. single.
Happened, Lord, this 52 decimals of land.
What is the case about? Just tell us what is the order of the impugn order.
The case is, Lord, that Public Works Department, the private respondent complained that I have encroached the Public Works Department land, which is in front of his
Right.
land. But there was a complaint and this case is that out of 40 decimals, 20 decimals were acquired by the Public Works Department long back. So we are in possession of 20 decimals then. But thereafter it appears that my name has been deleted. It has been recorded in the Public Works Department as wrongful occupier in our name. If the owner, our name is wrongful occupier.
20 decimals.
20 decimals. But therefore it
Now,
appears.
you claim by virtue of what? Only the previous records of rights.
Records of right, that is not admitted position. There is no dispute.
That is still there. The records of rights are in your name.
Yes, record of right was our name.
But
So for 20 decimal, it is not dispute.
no dispute.
But therefore, what happened? Lord, BLRO corrected record of right. Thereafter, the matter went to the.
Corrected against you. Somebody else's.
My share was 6 decimals. It was deleted, and the entire property was recorded in the name of
Private dispute.
public.
No,
No,
20.
not private.
PWD.
Public Works Department.
Only 20 decimals.
So what happened thereafter? The
So you challenge that you sought a further rectification of the record of right.
not share rectification. Now, Lord, after hearing conclusion, all along their stand is 20 decimals have been acquired. And when the matter was challenged, appellate order was challenged before this honorable court in writ petition. Lord, initially writ petition was admitted and interim order was passed, direction maintaining status quo with a direction upon the state, we actually survey the land and find out where is the 20 decimals from that. On the date when the matter appeared,
Page
extension
151.
of interim
Page
order,
What did you challenge in the writ petition?
writ petition challenged the appellate authority's order.
DM, sir.
Order
Yeah.
SPM, divisional
10-4.
magistrate passed an order. on
No, order regarding what? Correction of record or right?
No.
10-4.
10-4 10-4 of the.
Very
public
yes.
municipal-
Please continue from there. Yeah. So status quo was granted. They were to ascertain.
Yes, ascertain.
No.
But on the returnable date, they failed to ascertain that they said took time. That is. But on the on the behalf of the private respondent, from the pocket they find out, put out one paper before the learned judge and say that it is the entire land has been acquired. And on that basis, without giving
Which
any
pocket was it? Right pocket or left pocket?
that-
Must be right pocket because this is against
No,
leftist principles.
No, we were not provided even that. And my learned
No copy was given. Nothing annex. Not.
even not after passing of the order, when the learned judge directed them to hand over a copy, we approached them with a letter. They declined to give it.
Mr. Samant was there.
No,
I did
not my private respondent.
I was there.
Private
I did
respondent. You are for the private respondent. It was your pocket from which it came out.
I made an application under section 6 after passing order. My lord.
No, that copy should have been given to them. Later on also you did not.
That the authority which has provided, he was present in the hearing. Now, nothing was produced. They are also admitted 20 decimals. Now, all on a sudden, Lord, they brought out this paper, and on that basis, order has been passed. And Lord, specific direction has been given to evict us from our specific case. If it is found upon survey that we are in wrongful occupation, we shall ourselves demolish our proceeding.
No, let us see where the learned single judge has relied on that document.
No, dear Lord, can you come to the impugn
Just show
order?
us that portion. Impugn order, yes.
Paragraph 8.
Yes. Lord, paragraph
Mr. Raj.
yes, sir. Page 154. Page 154, paragraph 8.
No problem.
This report was never produced before the appellate authority.
The authority who has provided the report, he was present in the hearing.
What authority provided this
Not
report?
what you say. Response number 11. Response number 11, engineer, public works department.
Although he is not going to work. Although he is not correctly.
His report.
Report of the BLR also.
Yes, Mr. Samanto, how could it be sustained? The report produced by an engineer, how can that have, first of all, how can that have evidentiary value even? Report engineer, your engineer maybe. Yes, your engineer giving a report which says apparently that the plot was acquired for a public purpose. But no document is relied on. The court learned single judge does not rely on any document regarding that acquisition or something like that. LA case, nothing.
That was not.
And even if
Admittedly,
section,
that was not.
and even if section 4 notification was there, up to section 16 there is no acquisition, no vesting. Yes, we have to set aside this order. We'll remand the matter to the learned single judge. And we will permit you to produce that document by filing a formal affidavit upon giving them a copy. You will be permitted to use that. The present challenge has been preferred against an order whereby the learned single judge, primarily relying on a purported report issued by the respondent number 11 authority to the effect that the land in question was fully acquired for a public purpose, dismissed the writ petition of the present appellant, which was preferred against concurrent findings of both the authorities under section 10 within bracket 4 of the West Bengal Highways Act 1964. For the next para, learned senior counsel appearing for the appellant submits that the said document was produced for the first time before the learned single judge at the hearing without service of any copy thereof on the appellant. Even subsequently, no copy thereof was served on the appellant. Next para, heard learned counsel for the parties. There are certain palpable, there are certain illegalities in the impugned order to the extent that no opportunity was given to the appellant stroke writ petitioner to deal with or controvert the purported report of the respondent number 11 authority dated September 16, 2025, which was not a part of the records either before the first forum or the appellate authority or the writ petition, but was produced for the first time during arguments of the writ petition, arguments in the writ petition by the private respondent. For sub next para, hence, comma, the principle of audio alterum partem is squarely hit. For sub next para, secondly, comma, there is sufficient doubt. No, there is sufficient doubt. Secondly, comma, from the observations made in paragraph number 8 of the impugned order, comma, it is evident that the report of the respondent number 11 authority merely revealed that a notification under section 4 of Act 1 of 1894, that is the Land Acquisition Act, comma, was produced. Full stop. Next para, although it has been recorded by the learned single judge that land losers have been awarded with compensation, comma, particulars of which have been mentioned in the report, comma, the respondent number 11 is not an authority under the 1894 Act empowered by statute to decide on the questions of compensation and or acquisition. Full stop. There is no mention in the order of the learned single judge as to any document to show that compensation was actually awarded or paid to the appellants. Full stop. Next para. Thirdly, comma, a notification under section 4 of the 1894 Act is merely the first step towards an acquisition proceeding. Full stop. A notification under section 4, comma, after compliance with the rigors of sections 5 and 5 capital A, comma, has to culminate in a declaration under section 6 of the 1894 Act for the purpose of inviting objections. Full stop. Only after an award is passed, comma, unless possession is taken prior to the same under provisions of section 9 on notice, comma, the vesting is complete upon possession being taken in terms of section 16 of the 1894 Act. Full stop. Thus, comma, a mere report of the respondent number 11, comma, to the effect that there was a section 4 notification and mention in the report of compensation having been awarded to the land losers could not be a determinant at all in the adjudication to be done by the writ court. Full stop. Next para, lastly, comma, respondent number 11 is the respondent number 11, comma, who furnished the report, comma, is the assistant engineer of the Holdia Highway Subdivision of the Public Works Department within bracket roads, comma, which is the acquiring, which is the
Requiring.
pardon?
Not acquiring authority is state.
No, not the acquiring.
The requiring authority.
Which is the beneficiary of the purported acquisition. Full stop. Next para, thus, comma, the PWD has a vital interest in the matter and a report authored by an assistant engineer of the PWD, comma, who is an employee of the said party, could not have prima facie authenticity as a basis of the impugned order. Full stop. Next para, thus, comma, the impugned order cannot be sustained. Full stop. Accordingly, MAT 1668 of 2025 is allowed on contest, thereby setting aside the impugned judgment dated September 18, 2025, passed in WPA 17881 of 2025. Full stop. Next para, the learned single judge is requested to hear out the writ petition afresh on merits in the light of the above observations, upon granting opportunity to the parties, comma, including the private respondent, comma, if they so require, comma, to furnish additional documents by way of proper affidavits. Full stop. If so filed, comma, an opportunity may be given to the other parties to controvert the contentions in the same in writing. Full stop. no orders to cost urgency.
The interim order was there.
Interim order?
Interim order of status quo, my lord. Is there- Justice
151.
Basu was-
151, page 1.
Page 151.
Status quo was there previously. The interim order of status quo which was subsisting during the pendency of the writ petition shall continue till November 30, 2025 or until further order of the writ court, comma, whichever is earlier, full stop. It will be open to the writ court to extend, vary, modify and or vacate this such ad interim order at its discretion upon giving opportunity to the parties of hearing. Yes, Mr. Pal.
Item number 63 is also very urgent matter, Lordship. Would your Lordship take up tomorrow, Lordship?
Tomorrow we cannot. Tomorrow the entire structure is fixed and up to 12 original site.
Actually,
What is the urgency?
Lordship, urgency is that not only my passing rights has been taken away, Lordship, the poor villagers has to pay each 5 lakhs. 4 petitioners there without any assigning any reason. Cost imposed 5 lakhs for each petitioner.
Under which provision?
Lordship, as I have filed this writ petition, that is the way.
This is against
63, Lordship, item number.
63 that is need.
Item number 63.
Respondent is not there, Lordship.
Stands disposed of accordingly.
Lordship, 117 impugned order. এদিকে শুনুন।
117?
Lordship, 117.
What was it? Let us see the impugned order.
Order, Lordship.
Better to read that.
Lordship.
Or what? The relevant portions you can read. What was the writ petition about? You are the writ petitioner.
Lordship, I am the Lordship, para 2, Lordship. By filing 2 writ petition or file, Lordship.
Yes.
DM, Lordship, initially there was a writ petition for passing rights of both parties appeared and the Honorable Court directed DM to file a report. And the report has been challenged by both the parties. In filing WPA 23065 of 2024, the writ petitioner has prayed for issuance of approved writ and writ such and such. Authority commending him to set aside the order dated 18/6/2024, that is the order passed by the DM, and order dated 25/22/5/2004 as passed by the coordinate bench in court WPA number such and such. Lordship, para 5, Lordship. It is further contended that it is the further case of the writ petitioner that the aforementioned plots of land are now recorded in the name of the writ petitioner, that is Shubhendu Dubey, that is respondent herein, Lordship. Of the said Shubhendu Dubey is in lawful occupation of the aforementioned plot of land. It is further argued by Mr.
You are private respondent, is it?
Lordship. No.
You are private respondent.
I am private respondent. Lordship, both
in the writ petition?
Lordship, I have filed writ petition. They have also filed.
You are not Shubhendu Dubey, you are the other.
No, Shubhendu Dubey is now private respondent in this writ petition, Lordship, in this appeal. It is further argued by Mr. Roy that some undesirable person of the society who are the petitioner in WPA 24582, that is my writ petition, of the associates made an attempt to encroach the aforementioned plot of land of the writ petitioner, Shubhendu Dubey, and they have also made an effort to create a pathway over the aforementioned land of the petitioner. 6, Lordship. It is further argued that it is a further case of the writ petitioner that finding no other alternative, the writ petitioner approached various state authorities for ventilating his grievance, and since the grievance of the Shubhendu Dubey was not entertained, the said Shubhendu Dubey had approached this court by filing such and such case wherein a coordinate bench of this court by his order dated 22/5/2024 director respondent number 4, that is DM, to consider the representative of the writ petition in accordance with law. Lordship, next para 4, Lordship, kindly. Page 4.
Page 4.
Internal page 4. Lordship,
yes.
5th line. It is further argued by Mr. Roy that by the same order dated 18/6/2004, the respondent of 4 authority most surprisingly came to a finding that there exists an urban pathway across the above-mentioned land of the writ petitioner, which is being used by the villagers or Uttar Rampur village. Lordship, I am skipping over, Lordship, because time is short.
You are one of those villagers?
Lordship, petitioner. Para 11, Lordship. Page 121.
Yes.
On being asked by this court, Mr. Rahabir, however, could not subsist by filing any documents whatever as to how the writ petitioner in WPA 24582 of 2024 have got a right to user of alleged pathway over the property of the writ petitioner. On being asked further by this court, Mr. Rahabar could not produce any documents of title of deed of the writ petition WPA number 24582 of 2024 over the property of Shubhendu Dubey, nor he could produce anything to substantiate that the writ petitioner WPA number 24582 of 2024 have even an easement right of pathway over the property of the writ petitioner in WPA 23065 of 2024, that is Shubhendu Adhikari. Sorry, Shubhendu Dubey. I am sorry. Para 12, Lordship.
Yes, Shubhendu.
Dubey. I had to,
No, your case is Shubhendu is not Adhikari of that land. Yes.
that is both sides case. Learned advocates appearing on behalf of the respondent state and its instrumentality submit before this court that in absence of any material irregularity in the order dated 18/6/2024 as passed by the judicial district magistrate, there is hardly scope to allow the instant to writ petition. And Lordship, I am skipping over the para 13 first 5 line, Lordship. It comes in paragraph 2, WPA number 5th line, Lord, 6 lines.
This is paragraph 13.
Paragraph 13, Lordship, 6th line, as rightly pointed out.
Yes, yes.
By Mr. Roy that in the order under challenge 18/6/2024 as passed by the respondent, no authority, the said respondent 4 authority particularly admitted the right, title, interest and settled position of the writ petition. Shubhendu Dubey in respect of LR plot number, Lordship, LR plot number has been mentioned, Lordship. Lordship, there is a map that this LR plot number does not belongs to Shubhendu Dubey. 1 or 2 LR plot numbers belongs to Shubhendu Dubey and other is not, Lordship. Para 14, sorry. This court is really astonished that as to how the respondent number 4 authority, being the jurisdictional district magistrate, came to a finding that for a considerable length of time, a portion of the said plots of land has been used by the local villagers as their pathway. Coming to the factual aspect, WPA 2452 of 2004, it reveals that it is the case of the writ petitioner in WPA 24582 of 2024 that writ petitioner are residing in the nearby area for a considerable length of time, and the writ petitioners and their associates are using the land of the writ petitioner for approaching to the main road, Rampur Chakulia bypass road, as already observed by this court that in WPA number such and such, the writ petitioner have made no avowalment in such capacity, which capacity they are using the said plots of land as pathway. Lordship, I am skipping over the.
You have taken the under the leadership of the MLA and all. You have used political clout and you are saying villagers.
Lordship, this is the no avowalment of the DM or DM's order, Lordship. That has never reflected in the DM's order.
Leadership of MLA, where does it come from?
Only submission of the respondent. And on the basis of that submission, this observation has been made. Lordship, I shall show the.
No, on careful perusal of the report as prepared by IC Chakulia police
2
station.
years back. And after that.
No, 2 years back, that report of the IC said that you came with the MLA.
Lordship, I shall show, Lordship. I shall, Lordship, what I will, Lordship. After that, writ petition moved. And the High Court, Honorable High Court directed GM to consider. And that order, they have not, they have both sides challenged, but that has not considered here. Lordship, para 18, Lordship. In view of such, this court, while
DM has not considered.
DM considered, but while considering that both sides challenge the DM's order, but in this order, Lordship,
considered and said that Shubhendu Dubey is the owner of that property.
Owner, and we are using the pathway for last 20 to
Both
25
were held by them. So you challenge his ownership part and he challenged your pathway part.
In view of such, this court, while disposing the petition, directs the judicial district magistrate, the respondent for authority WPA of 2002 to take appropriate steps for removal of all dump mud from the abandoned land of the petitioner. Shubhendu within 45 working days from the date of communication of the server copy of this order, and cost of such removal of such mud are to be recovered from the petitioner in such and such. In the event the petitioner do not, I am not.
What do you do? What is your affidavit? What is the affidavit? The writ petitioner?
Daily wages.
Daily wages, Lord.
Labors, daily wages.
Business you have said.
No, one.
In affidavit.
So far one. So
And others?
Others are daily wages. Q suffer Q kichu
Lordship, I am
one is
instructed, Lordship, one is business, doing the business, and others are daily wages. Some are catching snakes and some are other things, Lordship.
So what business?
Business, nothing with venue chala na. Alu
He has no such specific instruction what type of business, Lordship.
Vene alu niye je bikri kore.
In the writ petition, what was? Let us see the writ petition. Sometimes it is done casually.
Lordship,
Look into the writ petition.
page 20, Lordship, petition starts.
Same business. It has copy pasted. He has copy
Yes,
pasted.
it's copy paste. Lordship, I am told
You're a
that
businessman, you can pay.
Lordship, I am told that he's selling vegetables.
You should be
That is
careful
the
in your
business.
affidavits.
That is not there, Lordship, but others are villagers, Lordship, because the grievance, Lordship, I am just conclude this and then I shall show the DM's order. Para 20, Lordship. Since the writ petition in WPA number have approached this court for exercising high prerogative jurisdiction of the court on a flimsy ground, having no right, title and interest over the property of the writ petitioner Shubhendu Dubey in WPA number such and such, this court imposed cost of ₹5 by each upon the writ petitioner, the help half of which shall have to be paid writ petitioner Shubhendu Dubey within 30 days from today, and remaining portion shall have to be deposited also within 30 days with the office of the legal service officer. Without any reason, as I have approached this, because Lordship.
But Mr. Pal, one thing, costs will consider. Regarding the, you say that you failed to show anything to substantiate your claim of this urban pathway. There is a recording. This is not a civil court. We are aware of this, but you challenged
Lordship
that recording in his name. Why should it be recorded as urban pathway? What right do you have? Otherwise, common user easement right, something like that.
Easement right, that is the my first point is only point, easement right. And Lordship, number two, Lordship, this is a writ court has no jurisdiction, Lordship. Civil court has got the jurisdiction.
Yes,
Supreme
Mr.
Court observed that.
Mr. You are there.
I'm taken as surprise.
This is the Mr. Rai who has.
I am the Mr. Rai. Taken as surprise that actually.
We understand. Yes,
I
the
could not
notice was
follow
given.
that, after 115 matters will be taken up.
No, due to the urgency of
Lordship, I am
particularly the 5 lakh.
Yes.
Lordship, stay this and fix any date after reopening, Lordship.
This is our jurisdiction.
Yes.
Mr. Rai will just stay the operation of the cost part till 15th November. We'll fix it on the reopening date.
And other parts should remain, Milord.
No other.
No other part. Other parts is there.
Let us see.
Other parts is there.
Other parts is not.
Lordship kindly sees. This is a case.
No, let us see the other part. We have obviously you have a right of hearing, you said. But let us just check up what are the other parts. I have approached this court.
Lordship, para 18, to remove the garbage at the cost of the petitioner, to pay cost.
This also has to be stated.
And para 23.
This also has to be stated, Mr. Rai.
Para 23 also.
Because if this takes place, then this will become infectious. We'll fix it on the reopening date.
No, Lordship kindly sees.
Yes.
3 parts of orders are there. Number 1, court finds this particular person has no authority. I am owning a land. There was 2 to 15 years border proceeding. Lordship kindly sees on record. I overcome it. After all these things, one fine morning, a mob entered. This is the report. Report he is saying, though I am not, but I am from my memory I am saying, Lord. A mob entered in my area, forcefully dumped mud, created a pathway. I reported to the police, I reported to the SP. DM asked the SP to cause an inquiry. Following which the IC reported that yes, a mob entered, there is criminal tension, there are tension in the area, and MLA other thing at the instance of these persons, MLA other thing, this thing has been done.
Mr. Pal will stay the operation of the cost only for the.
For the other part should remain. Milord, why my property? What right they have got to encroach upon? I cannot enjoy my property.
No, two or three other things are there. One is that the easement right or not, whatever is there in the records of right,
Not
Mr. Rai,
record,
the
I
court
will
could
show
not
me,
go
Lord,
beyond
that
that.
a land
the
which is
court-
being where there was agricultural
Mr. Rai,
land.
this was not a civil suit.
I am not concerned about that. Facts remain on the face of record.
Fact remains that on the face of the record, their villagers' right of pathway is there
that
recorded.
is not there.
It's a report of the
No,
DM.
report of the DM purpose to the finding. That is the
Therefore, that is still there as of today.
No, Report means, my lord, report
It
says.
says it's a common pathway.
No, that is not there.
235.
That is not there.
Lordship,
I tell
235,
you,
DM
so far
report,
cost pass to the
Best
person, my lord, I
235.
am in a position
second
after
part of the
15
DM.
matters taken. Now I am not in a position to assist
Start
your
from
lordship.
234. Start from
Lordship,
234.
is my position. Just I have heard that this matter is taken, I am rushing here. Lordship, so far, EP lordship show.
DM's order records that
What is
it's
the
a path-
problem? Does
Mr.
somebody dumped something in my?
Sir, you have to let us complete. Otherwise, you cannot answer if the
Yes.
question is not complete.
Yes.
Our question is the DM's order, which you have challenged before the writ court,
Yes, yes.
itself records, because you have challenged that portion of the order,
Yes.
that there is a pathway. Urban pathway is the mention, is the exact term used.
My question, my
You have
submission.
not finished.
Yeah.
They have challenged the other portion that it's recorded in your name. Both of you have challenged. As of today, the DM's order says, the DM's order proceeds on the premise of the records and says urban pathway is there, but the other plots are in your name. Yes.
No, that is not the fact.
Lordship,
Why,
DM's order has
my
not said-
predicament is I am without any brief. I am to argue. My predicament is I am without any brief. That is not the fact about. Their problem is that the observation has made by the DM, this part they have challenged, that pathway to be prepared. They are saying their challenge is to the extent of that DM said that a pathway, we have no plan to raise any pathway. That part they have challenged. Only that part. DM said, Lord, whatever there, we have no plan to raise any pathway. Over my property, had it been a case, they have acquired it, I could have understood. Had it been a case, there has been a requisition, I could have understood. DM said, we have no plan. Their challenge is how the DM can say they have no plan. They are admitting, my lord. So far as, my lord, over my land, somebody who encroach upon, somebody created dam.
Mr. Pal, if you dump mud and everything, then your pathway also gets damaged.
Lordship, wherefore, Lordship, kindly turn the police report, Lordship never stated that. Police report never stated that. Page 269, the police report, second part, Lordship.
Lordship, here's it tomorrow, Lord. If Lordship, I don't mind, Lordship, allow me to say something. So far as cost past Lordship can state. Till there is time, still there is time, let the matter be heard by your Lordship.
Present conflict, Lordship.
What is the
second
right of a
second
person? A person cannot enjoy a property at the political instigation. A mob will enter, encroach upon man's land, create a pathway. I am helpless.
All local.
I am armed with the Supreme Court decision. Supreme Court said, my lord, that this is not the way.
Of the BTO, BLLRO, and that Mr. Dubey, Bapilari, and SDO. And Lordship, the report of the DM consisted with BDO reports, BLRO reports, and everything.
No, but IC report clearly says that
IC report said, I'm saying.
simply started dumping mud over.
Yes,
but
all on a sudden, my lord, they
Mr. Pal will not stay the other portion.
Lordship, that is
other portion,
Lordship. They have not.
This fashion we should not.
Trial court never.
It will be justice to their client.
Trial court never set aside the order of the DM. Then how trial court direct this?
Mr. Pal will only stay the cost portion.
And Lordship, number two, Lordship, the civil procedures also this is in one merit, Lordship. The civil court has the jurisdiction.
The matter is taken out of turn upon being mentioned by the appellants. Full stop. Next para. Learned counsel appearing for the appellant submits that the writ court assumed the powers of a civil court in virtually deciding the right, title, and interest of the parties. Full stop. In the teeth of the DM's findings that there is an earthen pathway used by the villagers over the concerned plots of land, the learned single judge not only dismissed the application filed by the appellants, but imposed huge costs of ₹5 lakh on each of the writ petitioners. It is contended that although the IC report indicates that certain people entered the property and dumped mud thereon, in view of the recording, to the effect in view of the entries in the records that an earthen pathway exists over the plots, the learned single judge erred in law in insisting upon the production of documents akin to a civil suit in the writ court, to establish rights of easement, without granting any opportunity of adducing evidence on such count to the parties. Next para, learned counsel appearing for the private respondent controverts the arguments made by the appellant. Learned counsel submits that in view of the short notice received by learned counsel for the private respondent, comma, he could not be prepared with his brief, comma, as the matter is being taken out of turn immediately before the vacation. Full stop. Next para. Secondly, comma, it is argued that the appellant's herein forcibly entered and dumped mud over the property of the private respondent, dehorsed the law, which prompted the learned single judge to pass the order impugned herein. Push up, it is submitted that the matter may be heard on merits after the vacation, after the upcoming annual vacation. Push up, next para, we are aware of the fact that due to paucity of time, comma, since this is the last day before the upcoming annual vacation, when the this division bench is assembling, comma, we have taken up the matter out of turn upon very short notice on the private respondent, on the respondents. Full stop. Next para. Hence, comma, we do not propose to enter into the merits of the appeal at length, comma, which will unnecessarily handicap the private respondent. Full stop. Next para. However, comma, since heavy costs have been imposed on the petitioner, on the appellants, comma, who are villagers submitted to have come from marginal sections of society, comma, we stay the operation of the impugned order to the extent that costs of rupees 5 lakh each upon the writ petitioners in WPA 24582 of 2024 was imposed. Such stay shall operate till November 30, 2025 or until further order, whichever is earlier. Full stop. We do not express any opinion either way on the prayer for ad interim injunction regarding the rest of the matter in view of the reasons as indicated above, and since extremely short notice was given to the respondents, full stop, the matter shall be listed on October 27, 2025, immediately after the reopening of court, subsequent to the upcoming annual vacation.
One thing, Lordship, this is the only pathway to the highway, Lordship. Lordship,
no, you have been directed to remove the mud, Lordship, nothing else. The rest regarding correction of
para 26 of prevented us.
Only the way. Only the way, sir. Only the way, sorry.
No, para 26 is something.
Lordship, I'm showing, Lordship. Just 1 minute, Lordship.
1 million, another million on the question of technicality, Lordship kindly sees. There are two matters were taken together. Lord, two matters are taken together. One appeal filed, whether it is permissible.
We'll take it to consideration then.
Lordship kindly take it.
Lordship, one prayer, Lordship, I am not. Till they have the private respondent construct anything.
No, Mr. Pal, we don't find anything on record as the learner single judge held that this is the only pathway you have. So we won't interfere at this stage. Nothing is produced. The learner single judge specifically held. That's a finding of fact that you failed to produce any document to indicate that that's your only passage. You have a right of easement by of necessity.
Only our
we won't do that.
One thing, Lordship, till they construct anything, let them let us allow. If, without disturbing their construction or other things.
No.
May I have your Lordship's kind leave to
Yes, please.
But may I inquire one thing? Well, after the vacation, Lordship will take up assignment. Lordship will take up assigned matters on the reopening day or when it's on the Tuesdays when as a Lordship takes up.
We have not yet decided. আপনাকে কিছু বলেছি অ্যাসাইনমেন্টে কবে কবে এখন তো মঙ্গল আর বৃহস্পতি নিচ্ছি মঙ্গল বৃহস্পতি করে দিন vacation for Tuesday, Wednesday, Tuesday, Thursdays.
Well, and Lord, before your Lordship rises, my Lord, may I have your Lordship?
He was first. Yes. Yes. Order has been passed, we can't do it.
I was the junior, some other name has been recorded in the junior.
Pardon?
I was the junior in the matter, Lordship. Some
Which matter? Which item?
Lordship, on Monday it has been taken up.
Monday it has been uploaded.
It was uploaded yesterday, Lordship.
After uploading, you can't do anything. Sorry, no.
Yes, Lord, with regard to item number 31, my Lord, there is some urgency.
No.
But Lordship,
Item 63. You have to rise and sit to do.
Item 63, affidavit of service, my Lord, may I permit it to file?
Lordship,
আগেরটা affidavit of service file today be kept on record, যেটা last.
Lordship,
যেটা out of turn নিলাম, affidavit of service file today be kept. স্বরূপ যেটা করলো.
Lordship, some other name has been recorded. Lordship, I was the junior in the matter, Lordship.
It will appear as to be mentioned on the reopening date. Then give a slip.
Only
to be mentioned হিসেবে দিয়ে দাও for correction.
Only one difficulty, my Lord, item 31, my Lord. The difficulty is that I will be ousted from my property.
You may be ousted. We'll see. We'll let's show it.
Any mentioning, please?
Subject to lordship kind indulgence. So far as item number 71 is concerned, my client is 92 years old lady. She obtained a degree from the
Lord,
Calcutta.
I being the petitioner, the hearing is needed regarding this issue. Lord, kindly fixed after vacation.
Justice Basu appointed a
After vacation, I don't have determination. Then it will go to the regular.
After Justice Basu appointed a special officer for the purpose of giving possession and execution of conveyance.
No.
Possession has been
Go out of
given
turn.
by
Not
the
not
special
not out of turn. We'll just take up the list.
Only
We'll call on the list. We'll take
Item
up.
number 2.
Yes.
Lord, I am for the petitioner.
What is the matter?
Item number 2.
When does it expire? Interim order?
End of September 2025. Last third paragraph. There shall be an order of stay. Order dated.
Will extend for a limited period. Yes. The interim order granted on July 1, 2025 is extended till November 30, 2025 or until further order, whichever is earlier. Full stop. Let the matter be listed immediately after the upcoming annual vacation.
May I submit the affidavit of service?
Affidavit of service filed to be kept on.
Lordship, last day. Item number 3.
Yes.
Item number 3, my lord, I am appearing on behalf of the petitioner.
Right.
There was a caveat, my lord. Accordingly, I have served, but service was made long back, 2024. This is the affidavit of service. But now I don't see anyone appearing. My lord, this is a civil divisional application against the order. Against an order, my lord, rejecting order 7, rule 11.
What was the ground for 711?
711, my lord, because it is barred under section 85 of the Waqf Act.
Let us see the relief in this suit.
Yes, my lord. May I take your lordship first to the impugned order? Yes.
Yes.
But kindly seize the impugned order. My lord, I'll place the relevant paragraphs only. I'll not unnecessarily take your lordship through the whole thing. Last paragraph, my lord.
Yes.
Now, before proceeding with determining the issue at hand, it needs to be kept in mind that the exercise of rejection of plaint under Order 7, Rule 11 can be done only based on averments of the plaint itself and nothing else. In this instant suit, the plaint case in brief is that the pro forma defendant number 3 is the owner of the building situated at 13 Mullen Street, which is suit property herein, and the plaintiff is registered society and have been providing various operational services in the said building by virtue of the agreement with the pro forma defendant number 3 being the owner. It is the contention of defendant number 2 claiming herself to be a mutawalli of the Abdul Latif Waqf estate, and her husband defendant number 1 herein have been trying to forcibly obstruct the work of the defendant and to remove him from the suit property, and as such the plaintiff has filed the instant suit seeking declaration and injunction. So, my lord, it is already recorded that there is a dispute whether the property is Waqf or not. Next, my lord. Therefore, on a bare reading of the plaint, it cannot be said that the plaintiff has accepted or admitted that the suit property is Waqf property. It needs no admission, my lord. A mere dispute whether the property is Waqf or not is enough.
Show us the plaint.
Yes, my lord. The plaint
You can
is at
show the relevant paragraph.
page 10. My lord, paragraph 2, what they have done is, my lord, they have very cleverly drafted it.
Yes.
It is a result of clever drafting. The plaint, my lord, the averment start from page 11. The pleading starts from page 11. See, my lord, paragraph number 2.
The present revisional application has affidavit of service filed to be kept on record. Despite service, none appears for the caveat or opposite parties. Full stop, next para. The present revisional arises out of the rejection of an application filed by the defendants stroke petitioners under section order 7 rule 11 of the Code of Civil Procedure for rejection of the plaint in a declaratory suit filed by the plaintiff stroke opposite party number 1. Full stop, next para. The averments in the plaint, comma, in particular, paragraph number 2 thereof indicates that admittedly the defendant number 2 is claiming to be the Matwali of Abdul Latif and others Waqf estate, and also the owner of the building lying and situated at 13, Mullen Street, Mullen Street, Kolkata 7,20,000, which is the suit property. Push up next para. The declaration, the principal declaration sought in the suit is a decree for declaration is that the plaintiff is the lawful occupier by virtue of contract dated July 30, 2018, executed between the plaintiff and the pro forma defendant number 3, the latter having claimed in the plaint to be the owner of the property. Push up next para. Thus, an arguable question arises as to whether the learned trial judge refused to exercise jurisdiction vested in him by law in rejecting the application under Order 7, Rule 11 of the Code of Civil Procedure in view of the bar under Section 85 of the Waqf Act 1995 to a civil court having jurisdiction in matters where a dispute as to whether a property is a Waqf property is raised. First up, the divisional application, accordingly, is required to be heard on the above question. First up, next para. The petitioners shall serve a notice along with a server copy of this order on the plaintiff stroke opposite party number 1, indicating that the matter shall be listed in the monthly list of November 2025 before the appropriate regular bench having determination. First up, next para, an affidavit of service to the affidavit shall be filed before the regular bench on the returnable date. First up, next para, there shall be stay of all further proceedings in title suit number 1654 of 2019 pending before the learned Civil Judge Junior Division, 2nd Additional Court at Alipur District, South 24 Parganas, till November 30, 2025, or until further order, whichever is early. Grateful. So grateful. যদি না বলে থাকি বলে লিখে দিও এফিডেভিট অফ সার্ভিস ফাইল টু বোধহয় বলেছি। থ্যাংক ইউ। নেক্সট
Item number 4.
যখন একটা নেবো তখন পরেরটা রেডি রাখবেন, ফটাফট চালাবো। ইয়েস।
My lord, I am praying for a short passover as Mr. Corey.
No short passover. Move the matter. What is the matter? Very short passover. Next.
Item number 5.
Time for the defendant.
Yes.
I have to take brief from.
Yes, on the yesterday you asked. Yes, Mr. Rai, what is the matter?
My lord, the defendant is the petitioner of your lordship. This is an application has been filed for exhibiting.
Rai, please take the microphone a bit.
Yes. My lord, defendant is the petitioner of your lordship. The suit for declaration regarding a passage, which is the plaintiff's case is that he is the exclusive owner of the passage, and the defendant filed it along with counterclaim claiming that there
Only you, defendant number 3.
Defendant number 2 and defendant number 3 both filed. And in such a suit, my lord, the counterclaim has been filed for declaration that is a common passage. In previous to that, before transferring the property, the hostile owner amongst themselves executed an agreement where they have disclosed that this portion will be kept as a vacant for the purpose of ingress and egress to all the parties, including the subsequent purchasers also. At the time of adducing evidence, my lord, the person who was there is not executed of the document was not there. So initially, when I filed a photocopy of that agreement being a subsequent transferee, that was marked X for identification. Now the subsequently the attesting witness or the person who was witnessing that agreement, I want him to be brought to record examination for the purpose of.
At what stage?
That is, my lord, at the stage of before argument.
The evidence is over otherwise.
Yes, sir. That.
What is your application?
Yes, my lord.
And it was rejected on that ground, that belated.
And also the executed being one of the party to this proceedings is not coming forward to admit that contents. Because there is now, my lord, there is difference. He is not coming forward. I can confront that document unless until I produce the document as privacy.
So show me your
application. Page 64, your lordship will, no, my lord, page 59 is my application. If your lordship can turn to Paragraph 4. This is the document in question. Now, if your lordship may kindly consider paragraph 9.
No, where have you said that the person has now come? You have
Yes, after that, my lord, if your lordship may kindly turn to
he was not available or something like that.
no, he is not available. It is the desire of the defendant to mark that unregistered agreement as the exhibit while the vital document is required to be skip over the next, my lord. If your lordship the whether defendant number 1 and 2, though are the other executors are not coming forward to that there are written statements of counterclaim filed by the defendant number 1 and 2, but they put their signature and they have already been put their signature on the agreement as such and such. They quote they fail to tally the signature of those documents like written statement. That is something else. my
Defendant
lord.
number 1 and 2 came in the box.
In the box, but it was not there. Only a DW3 at the time of this was produced.
No, we don't. Defendant number 1 and 2 did not come to the box.
Defendant number DW1, DW2 did not.
Who are the authors of the?
Both the defendants and the plaintiffs.
So both the defendant is 1 and 2, not 3.
No, not 3.
You are 3.
And the subsequent transferee from one of the brother who was the
1 and 2 did not prove the document.
Did not prove the document. It was not confronted.
Where have you stated that the attesting witness was not?
It is not stated in that way. Only it
Why
was.
should it be permitted at this belated stage?
Well,
in the nature of Order 18 Rule 17. Is
Yes.
it? Forgotten.
Order 18 Rule 17, though it is for the court, but now my lord, the Supreme Court has said that parties can also ask for the, but must be within a reasonable time and there is possible reason for the purpose of recalling of a witness. Though it is for the court, Order 18 Rule 17 capital A was there previously. Now it has been omitted.
But even then, the
principles will
Salon
apply.
Bar Association does
Yes, the principle is applied. Well, can you consider
the principles. If the principles are applied, you have no case.
No, only on the
You have to
ground
show why.
if the court requires. Well, to that extent, well, if you
It does not require.
if you logically consider the objection which has been page 64.
What does the agreement prove?
That there is the existence of common passage. That is the there.
Oh, that is the crucial.
That is the crucial thing.
Objection. What do they say?
Yes. If you logically consider paragraph page 64, it starts. Nana, I'm drawing your attention to paragraph 10. They noted that as per code of law, expert also ample power to tally the signatures, and plaintiff denies the statement such and such.
No, that is different. Where is the impugned order? Let us see.
And other defendants by saying that kindly turn to paragraph 16, my lord, once.
16.
Yes, conducts of the defendant side, the defendant side are trying to hide something by not presenting the defendant number 1 before this learned court. On the other hand, the defendant side is using tricky manner to prove the alleged unregistered document, additional evidence DW3 Amit Chattopadhyay, who is one of the alleged attesting witness, which is not permissible by Indian Evidence Act as amended up to date. Now, my lord, can you turn to the order impugned?
But he's only an attesting witness.
Yes, at least I
Can you prove the document?
Contents of the document, my lord, to that extent he was present throughout, including at the time of negotiation.
Attesting witness can only prove that it was signed by the executant.
Yes, that is the.
But in the absence of the executants having
Contents cannot go. What is
no
called-
interference.
But there's
One of the plausible views.
one of the possible views. Well, can you consider after hearing the submission?
You have read. I've read there. That is what has been held.
Yes,
It is said
the
to
contents
principle
of the
that-
if the executed is there, in absence of the executor, how the contents can be proved? Attesting witness can prove the execution of.
The present challenge has been preferred by the. I've heard you. The present challenge has been preferred by.
His defendant number 2, alleged executor. He told, I have not executed it. This is a false document.
3 is also one of the executors. Executants.
Executor is a defendant number 2.
One and 2.
Yes.
1 and 2, yes.
They told it is a false.
The present challenge has been present revision application has been filed by defendant number 3 in a suit for declaration that passage is the passage is exclusively owned by the plaintiff stroke opposite party number 1. Full stop. Next para. In such suit, comma, after the evidence of the parties was over, comma, an application was taken out by the defendant number 3 stroke revisionist petitioner for calling for being permitted to adduce evidence of one of the attesting witness to a purported agreement, which apparently shows that the parties agreed to the passage being used as a common passage. For sub next para, learned counsel for the petitioner argues that the document is of vital importance for adjudication of the suit, comma, since the crux of the dispute in the suit revolves around whether the passage in question is a common passage or an exclusive passage owned by the plaintiff. Full stop. Next para. As such, comma, it is argued that the learned trial judge refused to exercise jurisdiction vested in him by law in rejecting the application. Full stop. It is submitted that although the agreement was produced during evidence, comma, the same was marked X for for identification and not exhibited, since the authors of the document did not come forward to adduce evidence. Full stop. Next para. However, comma, it is submitted that since the attesting witness can collaterally prove the execution of the document, comma, the prayer of the petitioner ought to have been permitted. Full stop. Next para. Learned counsel appearing for the plaintiff stroke opposite party number 1 controverts the contentions of the petitioner and submits that the defendant numbers 1 and 2, comma, who are the executors of the executants of the purported agreement, comma, have not come forward to prove the same. Full stop. As such, comma, the same was marked as X for identification. Full stop. In any event, comma, it is submitted that an attesting witness cannot prove the contents of a document. Full stop. Next para. Upon hearing learned counsel, comma, it is clear that the importance of the purported agreement cannot be overlooked. Full stop. However, comma, we cannot lose sight of the fact that defendant numbers 1 and 2, comma, one of whom is contesting the suit along with the defendant number 3 stroke petitioner, comma, did not come forward to prove the said agreement, comma, despite allegedly being the executants of the said agreement, comma, for which the agreement was marked as X for my identification and was not admitted in evidence or marked as an exhibit. For sub next para, the learned trial judge was justified in observing that the contents of a document can only be proved by its executants. For sub next para, it is also well settled that the attesting witness can only prove, comma, at best, comma, that the document in question was signed by its executants in presence of the said attesting witness. Full stop. The contents of the document are not necessarily to be known by the attesting witness. Full stop. Next para. Thus, comma, the premise on which the application of the petitioner was rejected cannot be faulted. Full stop. Next para. Also, comma, the application for bringing the evidence of the attesting witness on record does not disclose the ingredients of Order 18, Rule 17, comma, which is required to be read in the context of the previously existing Order 18, Rule 17, capital A of the Code, comma, which mandated the party seeking to adduce evidence belatedly to satisfy the court as to what prevented him from adducing such evidence during the deposition of the parties, befitting the due diligence of a prudent man. Full stop. In the absence of such proof, comma, the learned trial judge could not be faulted for rejecting the application. Accordingly, no interference is called for. CO 469 of 2024 is dismissed on contest, thereby affirming order number 75 dated January 17, 2024, passed by the learned civil judge, Junior Division, Second Court at Srirampur, Hooghly, in TS, in title suit number 408 of 2016. No orders to cause urgent settlement.
Yes.
Next.
Item number 6.
This is the second occasion when none appears for either of the parties at the time of call. Full stop. However, comma, keeping in view the fact that the matter has been assigned to this bench for a limited period, comma, I am not inclined to dismiss the matter for default. Full stop. Accordingly, let the matter be adjourned till after the upcoming annual vacation and be listed before the regular bench thereafter.
Item number 7.
I am for the petitioner, my lord. Here, my lord.
No caveat?
No.
Yes.
Trial court's order has not been, my lord, annexed, my lord. I am furnishing this, my lord.
You have filed a supplementary affidavit?
Yes, supplementary affidavit is there, my lord. Supplementary.
Why supplementary affidavit?
Supplementary affidavit with regard to
Previously also another supplementary affidavit.
No, that is in connection with restoration application.
Restoration has been allowed.
Allowed.
Yes.
My lord, here, my lord, there is no scope of interim order, my lord. I have lost both in Order 9, Rule 13 and appeal also. My lord, only issuance of notice, my lord, I shall have a chance to.
The present revisional application has been preferred against the order of the appellate court affirming an order dismissing. Section 5 was also there. That was rejected.
Section 5 allowed.
Or dismissing the petitioner's application under Order 9, Rule 13 of the Code of Civil Procedure. Full stop. Next para. The supplementary affidavit filed today be kept on record along with the original of the certified copy of the, this is the impugned order.
Yes.
Of the trial court.
Trial court's order.
Impugned order of the first court. Full
Hmm.
stop. Next para. Since arguable issues have been raised in the revisional application, comma, the petitioners shall serve copies of the same on the opposite parties, indicating that the matter shall be listed in the monthly list of November 2025 before the regular bench having determination. First of the petitioners shall file an affidavit of service before the regular bench on the returnable date. Next.
Item number 8.
Mr. Chakraborty, please ask your learned junior to give the appearances. Yes. 8. None appears for the parties at the time of call. Let the matter stand adjourned for the day.
Item number 9.
Yes.
I am for the opposite party.
Yes.
I am for the petitioner, my lord. I am being led by Mr. Aniruddha Chatterjee. He is not in court today.
On the prayer of the petitioner, let the matter stand adjourned till after the upcoming annual vacation, when it will be listed before the regular bench.
Very good.
Nothing in the matter. It's obvious.
Item number 10.
Yes.
Grateful.
Already decided by the Honorable Division.
My lord, item number 10, I am for the petitioner. My lord, this has been filed for expeditious hearing. That at that time, my lord, Order 39, Rule 4 was pending. I could not contacted my client, my lord. What is the stage of the application?
Learned counsel for the petitioner expresses her inability to assist the court in view of her having lost contact with her client. Full stop. Accordingly, let the matter stand adjourned and be listed after the upcoming annual vacation before the regular bench.
Item number 11.
That's it. Only thing you kindly accommodate us because my colleague is seriously ill. So Amit Lal Dhar.
Nothing in this matter.
You are for the petitioner?
I'm for the I'm suffering for long. Since long that is pain.
He is seriously in from January 2025.
No. He was lying with the court
6
member.
January 2025, accommodation was sought on the ground of illness of the petitioner's advocate.
That was in this January, but
He was ill then. Whenever the matter comes up, he becomes ill.
not that.
Matter
It was
didn't
lying
came up.
was in court number 6.
He was lying or file was lying?
Lying in the court number 6. And then it has
Didn't came up for the hearings.
What can
came up for
An adjournment is sought on the ground of illness of learned advocate for the petitioner. Let the matter stand adjourned till after the upcoming annual vacation, when it will be listed before the regular bench. Yes, next.
Item number 12.
Please, my lord. This is my civil revision application, my lord.
Yes.
Challenging an order of my lord. 4th of April 2024, my lord, passed by the State Consumer Dispute.
Mr. Shen, service has been effected already.
Yes, my lord. Service has been effected for more than multiple occasions, my lord.
Extension, nobody appeared for the.
Nobody appeared, my lord.
Move the matter. Yes.
Yes, my lord. Kindly, my lord, I'll just give a very brief overview, my lord. A telecommunication, my lord, service provider. I appeared for my lord Vodafone in this matter, my lord. One rather influential, my lord, complainant, my lord, Mr. Vivek Bharadwaj, my lord, who was the erstwhile, my lord, an Indian Administrative Service officer posted in West Bengal, my lord. He had, my lord, approached us for a connection, my lord. We had given him the connection, my lord, over the course of the substances of the connection, my lord. It is his case, my lord, before the consumer forum that certain, my lord, deficiencies arose in respect to the services that I have been providing, my lord. He files a complaint case, my lord. We appear, my lord. We contest the proceeding, my lord. In the meantime, my lord, due to reasons, my lord, that will be apparent from record, my lord, we failed to file a written version on time. An order, my lord, was passed that your time to file, my lord, written version, my time to file written version is off. I come before, my lord, a single judge of this honorable court, my lord, challenging that order in a civil revision, my lord. That order is set aside, my lord, subject to payment of cost, either upon the complainant, my lord, or an advocate appearing on his behalf, my lord. In compliance of that single bench's order, my lord, I attempt to serve, my lord. He does not accept it.
Who, advocate or person?
My lord, the advocate, because, my lord, I attempt to directly serve upon the complainant, my lord, at the address that is indicated in the cost title of the proceeding, my lord, comes back as undelivered, my lord. Therefore, my lord, in exercise of my bona fide, my lord, I attempt to serve upon the...
Refuses.
He also refuses, my lord, on the ground, my lord, there's no, that he does not have instruction, my lord.
On the ground that?
He does not have instruction to accept it, my lord. This is a bit interesting. So, my lord, I bring these facts to the record of the Learned Commission, my lord. The Learned Commission takes note of this, my lord. I file an affidavit, my lord, duly verified by me, that these are the true and correct facts. Now, therefore, since there's no default on my part, my lord, to file the, to furnish the cost person.
Permit me to file.
And then the district commission says, sorry, too bad, nothing doing. Since you have not filed the cost, I cannot allow you to file it. That is the impugn order, my lord. That's 4th of April. I'll place that order, my lord.
No, the impugn order is State Commission's order.
Yes, my lord. The State Commission's order.
It was filed originally before the State Commission.
Yes, man. It's with the
So why don't you go up to the National Commission? Revisional jurisdiction is also there.
Yes, I'm very grateful, my lord. This is not an appealable order, my lord. I'm only seeking review.
No, revisional jurisdiction is also there. Section 21, I forgot.
My lord, under the 1986, I'm carrying a case, my lord. I was aware, my lord, this would have fallen from your lordship, my lord.
This is the first point which will...
Yes.
Have you got a copy of the Act, Mr. Sen?
Yes, yes, I do, my lord.
I'm handicapped, I don't have... This is not the regular determination now.
What a copy. Yes.
So, 86.
Show me the appellate provision. What is the
Yes, yes.
21 or what?
Yes,
Forgot the section.
Yes, ma'am.
Yes, 21.
21.
Now, B is there. 21B is revisional. Just exactly similar to section 115 of the code.
Yes, my lord.
So why don't you go up there?
My lord, may I place the order, my lord? That will possibly clarify the issue, my lord. Because what the commission really told me, my lord, is to go before the High Court and get an appropriate order from this.
Shows that?
Yes, my lord. Kindly takes, my lord, page 72 of my lord, my application.
This is the impugn order?
Yes, my lord.
All right.
4th of March. My lord, 4th of March. Sorry, my lord. 4th of March 2024.
Yes.
Kindly, my lord, may I place the order, my lord, if my lord permits. Both sides are represented through their respective learned counsels. Today is fixed for hearing upon the IA and compliance pursuant to the direction of the Honorable High Court at Calcutta. It reveals from the office note that the order of Honorable Court passed in CO so-and-so is tagged with record this day. My lord, this is the earliest CO, my lord.
I've seen it. Shows the High Court order.
Yes.
Page 58.
Yes, page 50. I'm very grateful, my lord. Page 58. My lord, the operative part, I will not trouble your lordship at all. My lord, kindly takes page 60. The penultimate paragraph.
Yes.
My lord, the 4 lines from the bottom of the penultimate paragraph starts with cost of rupees 20,000 to be paid to the opposite party number 1 or to the learned advocate on behalf of the opposite party number 1 within 10 days from date. Now, my lord takes my service, my lord.
Despite service, none appears for the opposite parties. Full stop. Next para. In view of the limited conspectus of the present revision, comma, this court exercises jurisdiction under Article 227 of the Constitution of India, since in the circumstances of the case, comma, the revisional jurisdiction of the invoking the revisional jurisdiction of the National Commission under Section 21 within bracket small b within bracket of the Consumer Protection Act 1986 is not considered to be equally efficacious, comma, although an alternative remedy. Full stop. Next para. The the present petitioner was late in filing its written version before the State Consumer Disputes Redressal Forum, full stop. As such, such written version was refused to be accepted by the State Forum, prompting the petitioner to move a a civil revisional application before this court under Article 227 of the Constitution of India. Full stop. The said civil division, bearing CO number 2824 of 2023 was disposed of by a coordinate bench with a order dated September 19, 2023, whereby the petitioner was directed to file written version within 2 weeks from the date of communication of the order before the learned commission, provided costs of rupees 20,000 was paid to the opposite party number 1 or to the learned advocate on behalf of the opposite party number 1 within 10 days from that date. Full stop. In case of default, it was observed by the learned single judge, the proceeding will continue ex parte. Full stop. Next para. The petitioner subsequently tendered the said amount of cost within time to the opposite party number 1. Full stop. However, the service could not be effected since the postal article returned. As what? Unserved?
As my lord, addressee absent, my lord.
With the endorsement, within double inverted, addressee absent. Full stop. Next para. Following the direction of the coordinate bench, the petitioner then tried to tender the cost to the learned advocate appearing for the opposite party number 1 in the state before the state commission. Full stop. However, the said learned advocate refused to accept the same on the ground that he or she, do you know? He did not have instruction to receive such amount. Full stop. Next para. On such count, the petitioner affirmed an affidavit disclosing all the above facts before the tribunal, before the state commission, and requested its written version to be accepted, since there was no default on the part of the petitioner in tendering such cost within time. Full stop. Next para. By the impugned order bearing order number 30 dated March 4, 2024, the tribunal refused to accept the written version with the on the observation that the order of the honorable court, that the order of the learned single judge, learned coordinate bench, dated September 19, 2023, was not complied within the stipulated period, and further holding that the written version which was filed on that date by the present petitioner could not and should not be accepted. Full stop. Next para. The prayer of the petitioner to bring necessary order from this court was, however, permitted. Full stop. Next para. It is upon hearing learned counsel for the petitioner, it transpires from the impugned order itself have they admitted that they had no instruction?
That's by
yes, they said something.
That's page 73, my lord. Kindly take the second paragraph.
Yes, I saw somewhere but lost it.
Yes, my lord. Page 73, second paragraph. On the contrary, learned counsel appearing for the complaint has candidly submitted that he does not have.
So from the impugned order, that it was recorded therein that learned counsel appearing for the complainant stroke present opposite party number 1 candidly submitted that he had not received opposite party number 1.
Opposite party number 1.
Candidly submitted that he had not received any instruction from the complainant stroke opposite party number 1 regarding receipt of such costs. Full stop. Thus, it is evident that the cost was tendered by the present petitioner pursuant to the direction of the coordinate bench dated September 19, 2023, and there was no fault on the part of the petitioner in respect of non-compliance of the said direction. Full stop. Since it is the opposite party which could not be served, opposite party number 1 which could not be served, despite the cost having been tendered at its address as disclosed before the state commission, and the learned advocate for the opposite party number 1, comma, in violation of the direction of this court of the coordinate bench, comma, refused to accept the cost as well, comma, this court is of the opinion that there was sufficient compliance on the part of the petitioner to deposit the costs as directed by the learned coordinate bench. Full stop. Next para. In such context, comma, the expression in the order dated September 19, 2023 that double inverter মধ্যে cost of rupees 20,000 oblique dash to be paid to the opposite party number 1 to the learned or to the learned advocate on behalf of the opposite party number 1 double inverted clause shall be should be construed as double inverted cost of rupees 20,000 oblique dash to be tendered title tendered to the opposite party number 1 and or the learned advocate on behalf of the opposite party number 1. Full stop. Next para. Having as such, comma, complied with the said direction, comma, there could not be any fetter for the state commission to accept the written version of the petitioner. Full stop. However, comma, for the ends of justice and in deference to the order of the coordinate bench, comma, the petitioner ought to be directed to deposit the cost before the state commission with the liberty being granted to the opposite party number 1 to withdraw the same without prejudice to the rights and contentions of the parties. Full stop. Accordingly, CO number 895 of 2024 is allowed, comma, thereby setting aside order number 30 dated March 4, 2024, passed in interlocutory application number IA/145/2024 in connection with complaint case number CC/214/2013 and directing the state commission to accept the written version of the present petitioner, comma, provided the same is filed within 7 working days of the state commission. Full stop. Next para. Simultaneously with the filing of the written version or before such filing, comma, the petitioner shall also deposit the amount of cost of rupees 20,000 with the state commission, which shall, comma, upon being tendered, comma, be accepted by the state commission and retained by its appropriate department with liberty to the opposite party number 1 to withdraw the same without prejudice to the rights of any of the parties. Full stop. No orders to cost.
My lord, only one indulgence, my lord, I must indicate. My lord, we have served, my lord, the check of the cost, my lord, to the opposite party number 1. He has accepted it, my lord. The
When?
demand draft, my lord, the 20,000 cost. My lord, now he has accepted it to, my lord, to,
now means,
my lord, after the last order, my lord, passed by Justice Hiranmay
hit
Bhattacharya.
that.
My lord, I didn't want to interrupt your lordship while lordship.
Yes.
My lord, this is the affidavit of service, my lord. I apologize.
Orderটি চেঞ্জ করতে হবে। আমি মাঝখানেও বলেছি যে subject to the deposit of cost.
I apologize, my lord.
CO number dispose of যেখানে বললাম সেখানে CO number disposal যেখানে হবে বলো। ফুল স্টপ দিয়ে দাও, ওখানে ফুল স্টপ দিয়ে দাও, বাকিটা কেটে দাও। Since it is submitted by learned counsel for the petitioner at this juncture that subsequent to the filing of the revisional application.
No, my lord, subsequent to the last order, my lord, of 29th of July 2025, my lord, we had, my lord, undercover.
Subsequent to the filing of the revisional application, comma, the opposite party number 1 has accepted the check to the tune of rupees 20,000 by way of costs sent by the petitioner. Full stop. As such, comma, no further direction is being passed to deposit the said amount. Full stop. Next para. However, comma, the state commission, comma, before accepting the written version formally, comma, shall ensure, comma, upon ascertainment through an affidavit which shall be filed by the petitioner before the state commission to that the said amount has the said check has check stroke demand draft has actually been accepted by the opposite party number 1. You will file an affidavit before the state commission disclosing particulars regarding the acceptance. Subject to that satisfaction, version will be accepted. And Mr. Sharkar was there all the time. Yes.
Grateful, my lord. Grateful. I'm deeply obliged. My lord. Grateful.
Pass over item number 4.
This is my application.
Item number 4, you are there. Take your seat. Have to wait for some more time.
He's
Yes.
been through an accident, so I was asking him to leave.
Yes?
He's been through an accident. He still has his.
Huh? What happened?
My car became damaged, my lord. I came through Ola. The driver was talking with the over the phone, and secondly, we told tax, my lord. Just one lorry, my lord, attended the brake, and he just that.
Could have been serious. Thank God. Yes, Mr.
Lordship, this is a short Order 7 Rule 11 application.
Yes.
On the ground of Benami transaction, Section 4C. It's not within the exceptions.
Not within the exception.
So we had taken out an application under Order 7 Rule 11.
Why rejected? Why 711 rejected?
Yes, the 711 was rejected on the ground that evidence needs to be taken.
Show the relevant paragraph from the plaint.
Yes, my lord. Your lordship will kindly take the plaint.
Yes.
The plaint is at page 14.
Right.
Lordship will take paragraph 2.
Yes.
Lordship at page 15.
Got it.
That the property mentioned.
What is paragraph page 23B? Typed copy.
Typed copy. Typed copy is there.
Very well. You refer to the paragraphs. I'm following from the typed copy.
Yes,
23B.
Lordship will kindly take paragraph 2.
Yes.
That the property mentioned in schedule is situated in plot number 156, measuring about 0.033 classification Dana land. They intended to sell the property mentioned in schedule A below hereunder called as the suit property for sake of brevity in Monja district Hooghly, and the plaintiff from his own fund, kindly mark, plaintiff from his own fund purchased schedule A property, but the plaintiff at the very time was bachelor, and though if after marriage the proposal of the wife,
he thought so much.
He thought so much. Other brothers
You'd marry, and if the anyway, his problem, not ours.
More particularly mentioned that at the very time the defendant
Very convoluted. So, but Benami is there.
Benami is there.
And please, do you have a copy of the act?
Yes, my lord.
I've
Yes, my lord.
entirely forgotten the language of that exception. Benami transaction থাকা উচিত. What is the section which
Section 4.
4.
Prohibition of the right to recover property held benami. No suit, claim, or action to enforce any right in respect of any property held benami against the person in whose name the property is held or against any other person shall lie by or on behalf of a person claiming to be the real owner of such property. No defense based on such right in respect of the property held benami, whether against the person in whose name the property is held or against any other person, shall be allowed in any suit, claim, or action or on behalf of a person claiming to be the real owner. So now the exceptions, nothing in this section shall apply. Where the person in whose name the property is held as a co-parsoner in a Hindu lordship, this is not the case in the present scenario. Where the person in whose name the property is held is a trustee, neither has been this. This is categoric in order. In our application under Order 7 Rule 11D, we had categorically taken this that it's not within the exception, and it's admitted in their affidavit in opposition to the Order 7 Rule 11.
So this is not where the person in whose name the property is a co-parsoner in a Hindu, no.
It's not a co-parsoner.
No, and the property is held for the benefit of the no. B where the in whose name is held,
Held in trust.
Trust. No.
It is also not within a trust.
Benefit of another, he's a trust. No, does not. Any person. And 3, there was some relaxation also.
Yes,
Section 3, just name of his wife or unmarried daughter, and it shall be presumed. This was purchased in the name of his brother.
Brother, he says it's in the name of the
Not
brother.
a dependent, nothing.
So it doesn't come within the purview of the exception.
So we don't want to see, I don't want to see your 711 application, just the order.
Your lordship will kindly take the order. It's attached right to the end. Your lordship will take just the second last paragraph above ordered.
What is the date of the order? The entire bunch has been annexed.
Lordship, 5th December 2023.
Yes. find from the plaintiff. Mixed question of law and fact.
Yeah.
Yes, what do you say?
I say, my lord, this is coming under the exception, my lord, of section 2(9), my lord. A2. That's, my lord, the fiduciary relationship, my lord.
Brothers, all adults, all independent. How is it a fiduciary relationship?
Now, my lord, that time, my lord, they were all, my lord, bachelor, my lord.
Bachelors are
Yeah, I understand, my lord. My lord,
cannot
I
take
say,
care of themselves.
my lord, even, my lord, may I say, even if I say,
He was also, you were also a bachelor, your client.
no, my lord, fiduciary relationship, why, my lord, I'm saying, my lord,
So bachelors have
at the
anyway,
stage of Order 7, Rule 11, my lord, I must get the opportunity to establish my claim. Whether it was, my lord,
oh, your suit is barred under section 4.
may I say, my lord,
You won't get that opportunity.
whether it falls under the exception or not.
It's clear from para 2 of your plaint.
My lord, kindly takes, my
That
lord,
is the
one.
premise of your plaint.
But-
And you seek a declaration of ownership.
Right.
Although the property is standing in their name, brother's
I
name.
say, my lord. But 2(9)(a)(2), that's, my lord, a person standing in a fiduciary capacity for the benefit of another person, my lord.
And the indications
And, my
are
lord,
there in the examples.
And, my lord, may I say, my lord? Yes, my lord. These are, my lord, these includes this, my lord. Apart from, it's not that, my lord,
indicative.
other persons who are standing
Whoever
in
is in fiduciary
Yes.
capacity, yes.
My lord, and, my lord, apart from that, may I say, my lord, my prayers, my lord, if my lord will see, there are 4 scheduled properties, A, B, C, D. My lord, it's admitted that, my lord, the 4 scheduled properties are, my lord, unpartitioned. And, my lord, not all the, my lord, deeds with regard to all the scheduled properties are standing in the name of the defendants. Plaintiff does have a right.
This is not a partition suit, declared.
But I understand. But kindly take.
You understand that much?
Right.
Then you must understand this is barred.
Kindly takes, my lord, that's B. Even if my lord sees the prayer B, that's, my lord, for the permanent
This is
exam.
constitutional ancillary.
Yes.
We have to go by the principal relief, sir.
My lord, may I say, my lord? My lord, the suit cannot be barred, my lord.
It is barred.
Part, my lord.
But not in part. What do you say in part? The declaratory relief is the principal relief. We have to go by that. Injunction is consequential to declaration.
Yes, my lord.
Oh,
My lord, the
not-
permanent injunction, my lord, kindly considers one thing, my
We'll
lord.
consider. I am considering and passing the order. 2 defenses. Your defenses. 2(9).
Yes.
B2.
Yes.
And partially cannot be rejected.
May I show other portion?
What is the other?
Kindly see once, my lord.
Be quick. Others are waiting
yes, yes.
before vacation. Vacation urgency.
My lord, the fiduciary relationship, my lord, has also been
Fiduciary
admitted.
relationship
But
will-
that has been admitted in the written statement also. But I said that it has been purchased.
Plaint.
I know, my lord, but since they have taken the objection under Order 7 Rule 11D,
What does D say?
they have
We have to
admitted.
look into the written
No,
statement.
they have said, my lord, it has been
Part of law.
purchased. They said, my lord, that has been purchased by the father. They are also not saying that has been purchased by.
Forget them. Their defense is immaterial for Order 7 rule. You know that very well. The present challenge has been preferred against an order whereby the application of the defendant stroke petitioner under Order 7 Rule 11 of the Code of Civil Procedure was rejected by the learned trial judge on the ground that mixed questions of law and fact are involved. Full stop. Next para. The brief facts of the case are that a suit for declaration of title and for permanent injunction has been taken out, has been instituted by the plaintiff stroke opposite party number 1. Full stop. In paragraph number 2 of the plaint, comma, it has been claimed that the property mentioned in Schedule A within bracket with regard to which the declaration has been sought, bracket closed, belonged to one HON'BLE Pal, Padmavati Pal, Shamoli Chakraborty and Piali Bhattacharya. And they intended to sell the property mentioned in Schedule A and that the plaintiff, from his own fund, purchased the A schedule property. Full stop. It has further been stated in paragraph number 2 that the plaintiff at that time was a bachelor and he thought that if after marriage the proposed wife of the plaintiff does not accept the other brothers of the plaintiff, namely Sandip and Swapon, within bracket, the pro forma defendant and the defendant number 1 in the suit, bracket closed, and to keep a good relationship in the family and to please his mother, purchased B scheduled property in the name of pro forma defendant. Full stop, next para. It is also averred in paragraph number 2 that at the said time, the defendant number 1 and the pro forma defendant had no financial capacity to purchase the property in their name. No, B is a part of A.
They're separate properties. The reliefs are sought only in respect of Schedule A property. If your
But,
lordship takes
but he says that B
is purchased in the name of another brother.
No, therefore he was right. The Benami is in respect of B.
Lordship, the Benami is in respect of A is what he alleges.
He says he purchased from own funds, scheduled property.
The B property is relating to another brother who's the defendant number 2. The plaintiff allegedly purchased in the name of the defendant number 2. And
No, A scheduled property stands in the name of
the defendant number 1. And the reliefs are sought only in respect of Schedule A property. Although all the properties are given, no relief has been sought. The prayers are only in restrictive to.
But in the plaint, he says that he purchased from his own fund a scheduled property, but he was a bachelor at such and such, and to keep a good relationship, purchased B scheduled property in the name of pro forma defendant. He says B scheduled property was purchased in the name of pro forma defendant.
Yes, that is in the name of defendant number 2. But there is no relief sought for as far as.
Yes, therefore, why should the plaint be? Where does it say that a schedule was purchased in the name of brother?
Lordship, in paragraph 2, out of his own funds.
A is purchased from his own funds.
But
he does not say it was purchased in the name of someone else.
Lordship, the deed is in the name. Lordship will kindly take paragraph 8, read with paragraph 8, that the plaintiff. Typed copy ta kaun pata hai? Lordship will kindly take 23E, that the plaintiff asked the defendant number 1 what was the reason of this drama and stated the defendant number 1 is not absolute owner of a scheduled property, rather lame lender. In spite of that, the defendant number 1 wants to sell this a scheduled property.
Yes. Next para. Thank you. In paragraph number 6 of the plaint, comma, it has been alleged by the plaintiff stroke opposite party number 1 that the defendant number 1 stroke petitioner started divulging after 29 years that he is the absolute owner of a scheduled property and he will transfer the a scheduled property to another person. Who's up next para again, comma, in paragraph number 8, comma, it is of the plaint, comma, it is alleged that the plaintiff asked the defendant number 1 stroke petitioner what was the reason for the double inverted drama, double inverted clause, and stated that the defendant number 1 stroke petitioner is not the absolute owner of the scheduled property, rather name lender. Full stop. Next para. The principal relief in the suit is a declaration that the plaintiff is the absolute owner in respect of a scheduled property, having 16 annas right, title, interest, and possession thereof, and that the defendant number 1 is the mere name lender, and by virtue of sale deed number 1034/1993, comma, the defendant number 1 did not acquire any right, title, interest thereof. Full stop. Next para. Thus, comma, it is ex facie evident from the aforesaid paragraphs in the plaint as well as the principal relief sought therein that the suit is categorically barred by section 4 of the Prohibition of Benami Property Transactions Act, 1988. Full stop. Subsection 1 of section 4 provides that no suit, claim or action to enforce any right in respect of any property held Benami against the person in whose name the property is held or against any other person shall lie by or on behalf of a person claiming to be the real owner of such property. Full stop. Next para. Learned counsel appearing for the plaintiff opposite party number 1 seeks to rely on section 2 within bracket 9 within bracket capital A within bracket তারপর আবার within bracket small b তারপর within bracket small ii of the 1988 Act to argue that where a person standing in a fiduciary capacity for the benefit of another person towards whom he stands in such capacity holds the property, comma, it comes within an it forms an exception to the definition of Benami transaction. Full stop. Next part, it is argued that since the plaintiff and the defendant number 1 were bachelors at the relevant point of time and in fiduciary capacity with each other, comma, the bar under section 4 does not apply. Full stop. Next para, it is also sought to be submitted by the plaintiff stroke opposite party number 1 that apart from declaration, comma, a decree of permanent injunction was also sought in the suit. Full stop. Since it is well settled that the plaint cannot be partially rejected, comma, the learned trial judge was justified in rejecting the application under Order 7, Rule 11 of the court. Full stop. Next para. However, comma, the contentions of the plaintiff stroke opposite party number 1 cannot be accepted. Full stop. The expression double inverted fiduciary capacity, double inverted clause, indicates that one person is dependent on the other in some manner whatsoever. Full stop. Two adults, comma, who are not the dependent of each other in law cannot be said to be in fiduciary relationship with each other. Full stop. Merely now, since the plaintiff and the defendant number 1 are brothers, comma, they could at best, comma, at the relevant point of time, comma, be in fraternal relationship, but not in fiduciary relationship. Full stop. Next para. Subsection 3 of section 4 also provides for certain exceptions to the bar under the said section. Full stop. Clause small a of subsection 3 envisages situations where the person in whose name the property is held is a co-parsoner in a Hindu family, Hindu undivided family, and the property is held for the benefit of the co-parsoners in the family. Full stop. On the other hand, comma, clause small b within bracket of subsection 3 contemplates a situation where the person is in whose name the property is held is a trustee or other person standing in a fiduciary capacity, and the property is held for the benefit of another person for whom he is a trustee or towards whom he stands in such capacity. Full stop. Next para. To come within the exception under section 4 within bracket 3, comma, the plaintiff had to plead at least one of the said exceptional situations. Full stop. Whereas the concept of co-parsoner in a Hindu undivided family has not been brought in the picture in the plaint at all, comma, there is no averment in the plaint that the property was held for the benefit of another person by the plaintiff, comma, for whom the plaintiff was a trustee and towards whom he stood in fiduciary capacity. Full stop. Thus, comma, the exceptions to the bar under section 4 within bracket 1 of the 1988 Act are not attracted to the present case. Full stop. On a plain reading of the plaint itself, comma, a bar of law under section 4 of the 1988 Act is evident, comma, bringing the plaint within the ambit of Order 7, Rule 11 within bracket small d of the Code of Civil Procedure. Full stop. Next para. Insofar as relief small b, comma, regarding permanent injunction is concerned, comma, the same is merely a consequential relief, comma, entirely dependent upon the principal relief sought in prayer small a of the plaint, that is a decree for declaration that the plaintiff is the absolute owner in respect of the scheduled property which admittedly stands in the name of the defendants. Full stop. Next para. In such view of the matter, comma, the learned trial judge refused to exercise jurisdiction vested in him by law in rejecting the application of the defendant number 1 stroke petitioner under Order 7 Rule 11 of the Code of Civil Procedure. Full stop. Next para. Accordingly, CO number 363 of 2024 is allowed on contest, thereby setting aside the impugned order bearing order number 15 dated December 5, 2023, passed by the learned civil judge, Junior Division, First Court at Hooghly in title suit number 220 of 2022 and rejecting the plaint in the said suit. Full stop. No orders to cause are certified.
Grateful.
Thanks.
Item number 13.
And this is the affidavit of service, my lord.
Yes.
The respondent, ma'am.
But here I'm the defendant.
You're for the other side.
Respondent.
Very
Plaintiff.
good. Yes, yes.
I'm the defendant in a suit for declaration and injunction.
Right.
Now, my lord, we are the electricity company, my lord. But the plaintiff who filed the suit, there is according to the plaintiff, the bill is not properly been raised. There is a billing dispute. Now he filed a suit for declaration and injunction. In that suit, he filed an application under Order 39 Rule 1 and 2. We filed objection upon a contested hearing regarding the maintainability of the suit. The suit injunction application has been rejected.
You have not annexed the plaint.
But this is my. Now, my lord, against that, my lord, an appeal has been preferred. Now, my lord, appeal has been preferred by them. Now, my lord, the learned lower appellate court on the first day, after filing of the appeal, they filed an application for injunction, restraining us not to disconnect the connection.
Order 39 Rule 1 and 2 was allowed.
Rejected, dismissed.
Dismissed altogether. No, I didn't. Yes.
No additive. Appeal preferred. Now, in the first day, my lord, the learned district judge was of the opinion that he may be permitted to deposit an amount, and we have been restrained from disconnecting his supply. Now, my lord, matter ultimately transferred to the additional district judge. Now, my lord, if your lordship see the order of the learned additional district judge, we have raised the point regarding maintainability. Now, my lord, first I will show to your lordship the trial court's order if your lordship wants. But that is, my lord, although, my lord, we should not paginate it, but, my lord, it has been wrongly paginated, my lord, page 31. Page 32, rather. Or the appeal. This point was considered that the plaintiff is not maintainable.
No, those your WBRC, those regulations.
Yes, 55, my lord, that the billing dispute RGR.
It has not been referred to here.
No, but the only, my lord, this point was argued, my lord, that, my lord, if you let see page 33, my lord,
It is only the sections 145 and.
but my regulation 55 has not been referred. Now, what happened? Kindly see, my lord,
Anyway,
the
yes.
title appeal, miss appeal, my lord. If you lordship see the final of the order, my lord, in the miss appeal, my lord, internal page decision with reason, my lord, internal page 6. No reason has been assigned. Only as the district judge has entertained the appeal, therefore it is required to be allowed.
You have restored the supply. They have paid the money.
We have paid the money, 10 lakh.
10 lakh.
And you have restored.
Connection has not been disconnected. Connection.
They have given us notice for disconnection. But
We have given.
You won't do that if they deposit.
Yes.
Now, at the learned lower appellate court, if you lordship see, my lord, no reason as the learned district judge had passed an injunction order. Therefore, my lord, he has not gone into the merits. But I should not use this word mechanically, my lord, allowed the appeal. My
So
lord.
mechanically you can use. Nothing stronger.
No reason. No.
Even if you think about that, but don't say that.
Our first submission.
Interim mandatory injunction? What mandatory injunction?
But not mandatory, my lord.
Page 7.
But
was-
mandatory, it is written.
He thought it was mandatory for him to pass because his decision has passed it. Yes, how do you support this?
But only one thing, but we have.
You know very well that regulation 55 is there.
Yes, but only one thing, but we have.
What one
paid.
thing?
They have the opportunity for Order 7 Rule 11. They can go through that, And only one,
See the merit of your submission.
no,
So order settled definitely, but even injunction, it's well settled now that prima facie case includes maintainability of the suit.
yes,
That had to, and on that ground, trial court has rejected.
yes.
How could he, without deciding that, do it?
He has given the finding reasons that the prima facie issue whether the suit is maintainable or not. that
But
has
they
to be
are,
claimed first.
it would be
Yes, I have-
inequitable for us now because they have put in that
I
10 lakh.
paid.
Now,
That is the thing.
demand is more than
But may I say, but kindly come at page 17 of the application once. 17. Page
17 of the application.
Yes. There is the order rejecting by the trial court, that is 11th August order.
কি হলো সাইড ধরে ধরে চলে যাচ্ছে কেন 17 years.
Yes, page 17, my lord, kindly see the order records at the bottom portion, fourth line, it was reduced to 26 lakhs 18,000 from 44 lakhs 68,000.
This is a billing dispute. Let
Yes,
me
billing
reject the plaint from here and go to the
Kindly not do that, my
and
227 is not-
till it is decided by the appropriate authority. What is the authority?
RGRO.
RGRO.
Yes.
They will not disconnect subject to your going on paying regular payment. Let me reject the plaint. That will be beneficial. Everything is resolved.
Already we have reduced 40.
My lord, kindly give them liberty to file an application to reject the plaint, my lord. That
But I'll have to vacate.
I mean, for that, this order, they are not paying anything. Initially, amount was 45 lakhs.
Current dues, current billing.
Nothing, only 10 lakhs. We have been injuncted.
No, there is no injunction for
Yes, my lord.
bills.
We can't, we have been injuncted.
That injunction was granted. What is the district judge's order granting that ad interim injunction? Have you annexed that?
Kindly keep it. But that has.
Let us see.
They have not been injuncted to raise bills, my lord. Only the page 7, internal page 7 of the impugned order.
No, that 10,000 subject to 10 lakh.
10 lakh. Disconnection would not be done. That much.
And the would restore the power supply within 24 hours.
We have not yet disconnected. What happened, my lord?
So what is the meaning of this order?
45 lakhs initially demand. Now, my lord, they made an application, we have reduced it from 45 to 26.
No, you are directed to restore. Nobody pointed out that it has not been.
What happened, my lord? We have given a disconnection notice.
It is, yes, it is stated here, recorded here, the district judge was inclined to allow mandatory injunction. Ex parte on condition that they would deposit 10 lakh and within 24 hours you will restore.
That is absolutely wrong. What happened, my lord? When the trial courts, my lord, dismiss the injunction application, we give a notice for disconnection that you have not yet paid the amount.
That you have said.
Then they have filed an application for injunction stating that, look here, they have given disconnection notice. Then the district judge passed that order. Now, my lord, we have already reduced from 45 to 26 lakhs.
This was the bill for COVID period where the factory was not even working, and they have their own statement that in 2020 they have found a faulty meter, and that was changed in
This
2022.
suit is not made. Where is the plaint?
Plaint has not been.
Plaint is the first thing you should have annexed. You take a point of maintainability, Mr. Mukherjee, plaint not annexed.
This is my fault.
That is not the plaint.
My plaint is there.
But with greatest of respect, 227 court cannot bypass the
I'll bypass everything.
law given
Go
under
up.
CPC.
What does CPC say?
Legal 227 gives a supervisory powers to the honorable.
Yes, what can we not do? That is what we are asking.
I'm only saying that the Order 7 Rule 11 is a separate procedure. They have to take steps under Order 7 Rule 11 to initiate.
Not mandatory. In injunction, definitely can be considered. And prima facie case, a component of prima facie case is maintainability of the suit. Well settled. That is within the CPC. Where is the plaint? Where is the relief? Relief is not there. Except relief, everything is there.
But
no, without a plaint, Mr. Mukherjee, you should not have moved. You please hand over your copy of your plaint.
Well, I do not have. I do have only the revision, my lord. I am not before the lower court, my lord. This is in Purulia.
No, I'm setting aside. Sorry.
Order. My lord, kindly give some liberty to the petitioner to in this puja time.
What liberty?
In this vacation time, my lord, there will be no forum to approach.
Yes, the plaint is here, my lord.
What forum?
There will be no forum.
Supreme Court does not have long puja vacation.
No, not Supreme Court. My lord.
What is the forum?
Consumer forum I have to go. Consumer forum Purulia.
Against my order?
No, my lord. I'm not saying that. I'm saying if the order is Vacate it
Not
and they
consumer forum.
and if they disconnect the same, if they give
You have
disconnection
to
notice,
approach the grievance redressal officer.
GRO.
RGRO, then ombudsman if you
Yes,
lost.
ombudsman also.
I was willing to give you that liberty, but you are not willing to take that. So
I do not have the plaint. I cannot
very well. Noted.
plaint.
We'll proceed on the papers which are there. You handed over this? You've checked up the reliefs?
Yes, my lord, the prayer is not like the other suit restraining us from disconnecting, and the schedule 1 and 2 has been given.
This is not the plaint.
Initially, I thought it is injunction application.
Yes.
But my lord, kindly see, my lord, this second page of the copy which has been handed over, suit for declaration.
Wrongly copy pasted.
This is
You have claimed in your revisional application that it is a declaratory suit.
this is
You have
the-
asked for crave leave for producing the present revisional application arises from an order whereby the appellate court reversed the order of the trial court rejecting the injunction application of the plaintiff opposite party and granting injunction till disposal of the suit. Push up next para. The suit was filed for a declaration and permanent injunction, comma, raising a billing dispute regarding electricity connection being given by the defendant stroke distribution company. Defendant number 1 stroke distribution company to the plaintiff stroke opposite party. Push up next para. The revisionist petitioner raised an objection before the learned trial judge during the hearing of the temporary injunction application that the suit was not maintainable in view of the operation of section 145 of the Electricity Act 2003 and the extant regulations enacted by the West Bengal Electricity Regulatory Commission, whereby the appropriate forum for deciding billing disputes is the concerned regional grievance redressal officer, CAPSE, bracket RGRO, bracket closed, full stop next para. On such premise, comma, the injunction application was dismissed on contest. Full stop. Subsequently, an appeal was preferred by the plaintiff stroke opposite party number 1 against such order, where the learned district judge who admitted the appeal initially granted an order of mandatory injunction on to the effect that the defendant stroke distribution company shall restore the power supply of the opposite party within 24 hours of deposit of rupees 10 lakh by the plaintiff stroke opposite party. Full stop. However, comma, learned counsel for both parties submit that the tenor of the said order was erroneous to the extent that the disconnection was never effected. Full stop. Only a notice of disconnection was issued by the revisionist petitioner number 1 to the opposite party. Full stop. Be that as it may, comma, both parties proceeded on the premise that the said ad interim order was a restraint order from was a prohibitory order restraining the defendant number 1 stroke distribution company from disconnecting the electricity supply of the plaintiff stroke opposite party subject to deposit of rupees 10 lakh by the latter. Full stop. Next para. Such deposit having been made, comma, the disconnection has not yet been effected. Full stop. Next para. Learned counsel for the petitioner argues that the learned appellate judge, comma, while allowing the miscellaneous appeal merely and mechanically reiterated the ad interim order of the district judge without entering into the merits of the matter and or ascertaining the maintainability of the suit at all. Full stop. Next para. Learned counsel further submits that taking undue advantage of the said order, comma, the plaintiff stroke opposite party is also not paying current electricity charges. Full stop. Next para. Learned counsel for the plaintiff opposite party submits that that there is no injunction on the distribution company stroke revisionist petitioner number 1 to raise bills regarding current consumption on the opposite party. Full stop. Next para. It is further submitted by the plaintiff stroke opposite party that the appropriate relief of the defendant stroke petitioners would at best be an application under Order 7 Rule 11 of the Code of Civil Procedure. Full stop. The court, while deciding an injunction application, it is submitted, cannot decide the question of maintainability of the suit. Full stop. Next para, there is a cardinal fallacy in the argument of the opposite party. Full stop. It is well settled that if an objection is raised regarding the maintainability of the suit before the civil court due to lack of inherent jurisdiction, the same forms a component to be decided by the court within the contemplation of whether the plaintiff stroke petitioner has a prima facie case. Full stop. Maintainability of the suit is an essential component of prima facie case, and as such, no separate application for rejection of plaint is required for the court, even at the injunction stage, to enter into such question. Full stop. Next para, proceeding on such premise, this court finds that the learned trial judge was perfectly justified in dismissing the injunction application on the ground that, in view of Regulation 55 of the WBERC, read with Section 145 of the Electricity Act, the RGRO was the appropriate authority to decide billing disputes and not the civil court. Full stop. Thus, the civil court, prima facie, did not have jurisdiction to entertain the suit and or pass interlocutory reliefs in connection therewith. Full stop. Next para, the learned appellate judge refused to exercise jurisdiction vested in him by law illegally and with material irregularity in not entering into the issue of maintainability of the suit, even prima facie, and mechanically making absolute the ad interim order passed by the learned district judge while entertaining the appeal. Full stop. It is another well settled principle that the principle of res judicata, although applicable at different stages of the suit, does not operate in vis-a-vis ad interim and temporary injunction orders. Full stop. At the stage of ad interim injunction, the tests are different from the subsequent stage where a temporary injunction application is decided on merits and upon hearing both sides. Full stop. Thus, the ad interim order of injunction, either grant or refusal, does not operate as res judicata at subsequent stages of the injunction application itself, since the tests at each stage are different. Full stop. Next para, hence, the learned appellate judge acted without jurisdiction in mechanically making absolute the initial ad interim order passed in the appeal. Full stop. Secondly, since the suit is not prima facie maintainable in view of the above discussions, the learned appellate judge acted without jurisdiction in allowing the miscellaneous appeal, thereby setting aside the order of dismissal of the injunction application passed by the learned trial judge without adverting to the reasoning given by the learned trial judge. Full stop. Thus, CO number 966 of 2024 is allowed on contest, thereby setting aside the impugned judgment and order dated January 22, 2024, passed in miscellaneous appeal number 18 of 2022 by the learned additional district judge, fast track court 1 at Purulia, district Purulia. Full stop. Next para. There will be no orders to cause or certificate course. Prothome affidavit is filed to deliver. Eta ferat diye din onar. Yes, next.
Item number 14.
My Lord, learned counsel, on behalf of the petitioner, unable to appear due to reason of some personal difficulties, so I am praying for not today.
On the prayer of the petitioner, let the matter stand adjourned for the day.
Item number 15.
My lord, learned counsel for the petitioner.
Same.
Same.
Next.
Item number 16.
None appears for the parties at the time of call. Let the matter stand adjourned for the day.
Item number 17.
Please, your lordship, my lord, the opposite party is died. I came to know that recently he is died. And
died?
Yes, my lord. And my lord, no steps has been taken as yet.
Will
Can
grant you
give
liberty to
breathing time
Very
to
good.
take appropriate steps.
Learned counsel for the petitioner submits that as per information received from his client, the sole opposite party has met his demise in the meantime. So accordingly, learned counsel seeks liberty to take steps for substitution of the heirs and legal representatives of the deceased opposite party. Such leave is granted. Let the matter stand adjourned till after the upcoming annual vacation and be listed before the regular bench under the appropriate heading.
Item number 18.
To appear for the opposite party.
My lord, I am for the, my lord, defendant petitioner before your lordship, my lord.
Right.
My lord, 7-2 petition, 7-2 of the West Bengal Premises Tenancy Act, my lord. with
Premises
section
Tenancy Act
five-
আছে? Premises Tenancy 97. Yes.
My lord, with section 5 application, my lord. My lord, the petitioner to their learned advocate, my lord, appeared in the suit. But my lord, the said learned advocate, my lord, never advised the petitioner to file the, my lord, petition 7-2 petition, my lord. And my lord, the petitioner came to know the same only on the, my lord, 8th March 2017, my lord. After, my lord, engaging the new advocate, my lord, who advised to file the, my lord, application, my lord. My lord, the petitioners have full faith, my lord, on the, my lord, learned advocate, my lord, engaged by them, and my lord, they acted upon the advice given by their learned advocate, my lord. My lord, so the petitioners cannot be, my lord, penalized, my lord, due to the laches on that, my lord, the learned advocate. And my lord, there is a provision of, my lord, section 40 of the, my lord, West Bengal
Section 5 is
Premises Tenancy
applicable.
Act, my lord.
Section 5 is applicable. 40 says Section Limitation Act is applicable.
Then, my lord, the section 40, my lord, West Bengal Premises Tenancy Act, my lord.
You
which was-
filed a Section 7.2 application with
section?
but Section 7.1 provision is mandatory. You have to comply with that. You have to make the deposits within that time. Let us see the language of Section 7.1. Within 1 month.
But, my lord, it is not mandatory, my lord. My lord, in this regard, my lord, one judgment I am, my lord, relying, my lord.
If you rely on one judgment, she'll rely on 10 judgments.
My lord, the division bench of this honorable court, my lord. My lord.
Because there are so many judgments now against you. Previously, that was the view taken by us.
My
Which year?
My lord.
2010, 2011, no longer. So much water has flown through the Ganges, proverbially.
Page 7.
Oh, that.
Page 7, my
This is
lord.
a reported judgment. This is a reported judgment.
My lord. Page 7, my lord.
You should bring the citation, the reported judgment. This chapter is over now. And that was again 17 probably. No, 7.
And page relevant
7
portion,
was,
my lord. Page 12
yes,
and 13.
so
my
many
lord.
judgments after this.
Relevant portion, my lord. Page 12
The
and
time
13.
limit is not inflexible. Yes, but you have a point because the proviso says that one extension may be granted which shall not exceed 2 months. What was the finding of the trial court? Let us see.
Fine. May I read out, my lord? The case of the defendant in brief is that they have appeared in the instant suit on.
Did not read the entire thing. Did not. The difficulty is Section 5 is applicable only in respect of an application or an appeal. Section 7(1) does not contemplate an application. No application is required. Application is made only for convenience. Section 7(2), an application is must. Because you raise a dispute, you have to raise that in the application. See the difference of language. Section 2 says, if any suit referred to under subsection 1, there is any dispute, the tenant shall within time specified deposit the amount admitted by him to be due together with an application for determination of the rent. 1 merely says, on a suit being instituted, the tenant shall, subject to provisions of 2, pay to the landlord and deposit with the civil judge all arrears of rent. So no application is envisaged. If no application is required, no section 5 is attracted. 40 says section 5 is applicable where there is an application. Section 7(2), section 5, yes. Section 7(1), there is no scope of section 5. Trial court was correct. No interference. This judgment has become irrelevant now. You cite one or two.
Page 7, my lord.
Yes, I've seen page 7.
Page 7.
Yes, cite one or two contrary judgments, that is sufficient. Need not waste further time on this.
2018.
Cite one of the latest judgments, yes. If any Supreme Court judgment is there, cite that. Or whatever.
Lordship, I brought
Has to be at least division bench. This is division bench.
This is not division bench, single bench. Justice.
Not a single division bench judgment.
Lordship, here the 2G has also attracted. The original tenant.
The 2G, we are not on 2G.
Not taken that plea, my lord.
7(1), we cannot take 2G.
When the suit was running, both the defendants have
We
expired.
have filed the suit under the 1997 Act.
1997 Act.
Then section 7 is automatically attracted. 2G is not applicable.
And now
that will be decided in the suit.
Now the tenant has also expired. The widow of the son of the original recorded tenant.
Maybe.
Recorded tenant
That will be decided. That will be decided elsewhere, not in this process. The question is whether this
Lordship, 2000
proviso governs, because there is a scope of one extension.
Lordship, 7(1). Lordship, there is
Proviso is under 7(2).
7 day, that is it is
one extension shall not exceed 2 months.
May I be permitted, Lordship? 7 day Adventist secondary school versus Ismat Ahmed and others. It has been reported, Lordship. So I didn't bring my judgment books, so I'm not well.
What is the citation? It's online.
Lordship, it has been reported. 2025 SCC online SC 1696.
2025 SC.
2025 SCC online Supreme Court 1696. 24.
Wait, I don't have the SCC online.
Paragraph
I'll just...
হ্যাঁ পড়েছি আমার যে জাজমেন্টের বইটা মানে এটা আসেনি
This, oh, due to this, some phase has gone. Wi-Fi is not working. Sorry. Can't use this. Do you have a copy?
Lordship. Section, paragraph 24 onwards.
Yes, yes. I was wanting this one. এই শঙ্খ একটা সাইটেশনটাতে একটু লিখে রাখো শুধু 2025 SCC অনলাইন SC 16296 নামটা 1696 নামটা এটা সেভেন্থ ডে অ্যাডভেন্টিস্ট ADVENTIST সিনিয়র সেকেন্ডারি স্কুল ভার্সেস ইসমাত ISMAT আহমেদ অ্যান্ড আদার্স। এটা নোট করে রাখো, এটা পরে বলছি, এটা ওনাকে ফেরত দিও। Yes, judgment is there. Seventh-day Adventist. Now this judgment has become so well. Dismiss the division. The present challenge has been preferred by the defendant in an eviction suit under the West Bengal Provincial Act 1997. Full stop. Next para. By the impugned order, comma, the application filed by the defendant stroke petitioner under Section 5 of the Limitation Act for condonation of delay in making the deposit contemplated under Section 7 within bracket 1. You also filed a 7.2 as well as the first part of Section 7 within bracket 2 was turned down. First up, next para. Learned counsel for the petitioner places reliance on a division bench judgment of this court in CO 3443 of 2010 with CO 3054 of 2011, where it was held that the time limit fixed, comma, as mentioned in subsections 1 and 2, যেখানে subsection বলবো bracket করে দেবে, subsections 1 and 2 of section 7 of the 1997 Act to pay or to deposit with the controller or the civil judge.
7.1 was not filed. 7.2 was filed with Section 5.
Or the civil judge all admitted arrears of rent together with interest, comma, as mentioned in clause small b thereof, and consequently the time limit mentioned for this purpose as mentioned in subsection 2 within bracket 2 is not inflexible and it can be extended by the court by virtue of Section 5 of the Limitation Act 1963. Full stop. Next para. Learned counsel for the petitioner argues on the strength of the said judgment as well as Section 40 of the 1997 Act, which provides that the provisions of the Limitation Act are applicable to the 1997 Act, comma, argues that the learned trial judge proceeded on an erroneous premise in holding that the mandate of deposit under subsection 1 and subsection 2 of section 7 is mandatory and inflexible. Push up next para. Learned counsel appearing for the opposite plaintiff stroke opposite party places reliance on Seventh-day Adventist, where the Supreme Court, comma, in a recent judgment, comma, has held that where the provisions of section 7 within bracket 1 clauses small a to small c as well as the first part of section 7 within bracket 2 of the 1997 Act stipulate a mandatory timeline for deposit of amount or filing application, comma, the same cannot be overridden by the provisions of the Limitation Act. Full stop. Unless such deposits are made, comma, it has been observed, comma, the defendant cannot take benefit under the proviso to subsection 2 of section 7 by application of the Limitation Act. For sub next para, it is argued that as such, comma, the learned trial judge was justified in rejecting the application under section 5 of the Limitation Act. For sub next para, upon hearing learned counsel for the parties, comma, it transpires that section 40 of the 1997 Act does not apply the provisions of the Limitation Act to the 1997 Act in an untrammeled and blanket fashion. Full stop. The very opening words of section 40 of the 1997 Act are, double inverted, subject to the provisions of this Act relating to limitation, double inverted close, dot, dot, dot. Full stop. Thus, comma, the provisions of the Limitation Act 1963 are applicable to the 1997 Act, subject to implicit bars as to limitation as provided in the 1997 Act itself, comma, even as per section 40 thereof. Full stop. Seen in such perspective, comma, section 7 within bracket 1 within bracket small a is couched in mandatory language by use of the expression double inverted shall, comma, which mandates the tenant, comma, subject to the provisions of subsection 2, comma, to pay to the landlord or deposit with the civil judge all arrears of rent calculated at the rate at which it was last paid and up to the end of the month previous to that in which the payment is paid, together with interest at the rate of 10% per annum. Full stop. More importantly, comma, clause small b within bracket of subsection 1 of section 7 provides that such payment or deposit, double inverted with the shall, double inverted close, be made within 1 month of the service of summons on the tenant, or, comma, where he appears in the suit without the summons being served upon him, comma, within 1 month of his appearance. Full stop. Next para. Not only that, comma, clause small c of subsection 1 mandates the tenant to thereafter continue to pay to the landlord or deposit with the civil judge month by month by the 15th of each succeeding month a sum equivalent to the rent at that rate. Full stop. Next para. Subsection 2 of section 7 contemplates a situation where a suit referred to in subsection 1, that is for eviction under the 1997 Act, comma, is filed, and any dispute as to the amount of rent payable to the tenant is raised, comma, in which case the tenant shall, within the time specified in that subsection, within bracket, that is within 30 days, within 1 month from the date of service of summons, or where the defendant appears without summons, comma, within 1 month of appearance, bracket closed, deposit with the civil judge the amount admitted by him to be due from him, together with an application for determination of the rent payable. Full stop. Next para. The placement of the proviso is under subsection 2, which stipulates that having regard to the circumstances of the case, comma, an extension of time may be granted. An extension of time may be granted by the civil judge only once, and the period of such extension shall not exceed 2 months. Full stop. Next para. The use of the expression double inverted extension, double inverted close, presupposes that such extension has to be sought before the expiry of the statutory timeline. Full stop. Unless such interpretation is lent to the said proviso, comma, an absurd situation may arise where the extension application, the extension itself is sought much beyond the expiry of the limitation period, and it is pleaded that the extension is being sought only once and should be granted for 2 months from that date. Full stop. Next para. Taken conjointly reading the subsection 7 as discussed above, comma, the unavoidable conclusion is that the deposit contemplated in section 7 within bracket 1 within bracket small a and section 7 within bracket 2 within the time stipulated therein is mandatory and cannot be extended by operation of section 5 of the Limitation Act 1963, comma, read with section 40 of the 1997 Act itself. Full stop. In Seventh Day Adventist Supra, comma, the Supreme Court reiterated precisely the above proposition. Full stop. Next para. Thus, comma, the proposition laid down in the division bench judgment cited by the division bench judgment of 2011 cited by the petitioner has to give way to the latest adjudication on the said issue as decided by the Supreme Court in Seventh Day Adventist Supra. Full stop. Hence, comma, the learned trial judge was justified and acted within his jurisdiction in dismissing the application of the defendant petitioner for condonation of delay in filing the application under section 7 within bracket 2 and making the deposits as contemplated therein. Accordingly, CO number 1177 of 2024 is dismissed on contest, comma, thereby affirming the order dated January 24, 2024, passed by the learned civil judge, Junior Division, Second Court at Shialda, District South 24 Parganas, in ejectment suit number 48 of 2013. No address to cost.
Item number 19.
Yes.
But in a suit for my lord partition, my lord, plaintiff filed an application praying for making pakka construction. At the same time, defendant also filed one application for praying for repairing of the mud building house. Both the application was allowed. But though
He'll repair the mud building, then it will be broken and the pakka structure will be created.
My lord,
For the same structure.
no.
He wanted to make a different construction.
Yes, my defendant structure is made of mud.
So you wanted to repair your mud structure.
Repairing was allowed. At the same time,
He wanted to make a new construction
new pakka construction
on that mud hut differently.
on the plot in question.
Yes, very good.
But admittedly, the plot in question
Yes.
that is owned by my father, defendant's father. My lord,
Oh, they are outsiders to the family.
plaintiff claiming to be the co-sharer.
All are Janas.
Yes, that may be, my lord.
But
My lord,
the plaintiff is Ajana.
plaintiff.
He's also a Jana, son of Rabindranath Jana.
Yes.
Must be relatives in the
There
family.
was an order of status quo. Though there is an order of status quo, how my application for making pakka construction can be allowed is just contrary. My lord, kindly have a look to the order impugned. My lord, page, my lord, straightway, my lord, order impugned, first page, last paragraph.
Status quo I've seen.
Status, no, that is order impugned.
Yes, status quo I've seen, so that you don't come back to that.
Order impugned, in the opposition, learned advocate for the defendants. Order impugned, last paragraph.
Yes.
In the opposition, learned advocate for the defendants submitted that they are not admitting the plaintiff's title over the suit property, and for which they have filed a petition for production of deeds from which the chain of transfer as claimed by the plaintiff will be established. But the clever plaintiff did not provide them the deed through which plaintiff's predecessor in title, namely Vijay Krishna Maiti and Pulin Pradhan, purchased the suit property from Pulin Pradhan and Bhagavat Jana respectively. Bhagavat Jana is my predecessor in interest.
This is Purva Mednipur.
Yes, yes.
Half the population is Jana, so my assumption was wrong.
Question.
Question Purva, same. Yes.
Previously, all with them. So, in this regard, he further stated that since the defendant are not admitting the plaintiff's title over the suit property, the plaintiff shall not be granted any permission to construct any pakka building over the suit property, at least till determination of the of his title. Now, in reply to learned advocate for the plaintiff, learned advocate for the plaintiff submitted that they could not yet able to collect the deed through which Pulin Pradhan buy the suit property from defendant's father. Well, these are, if in the absence of chain deed, there is no deed. We categorically stated that my father during his lifetime never transferred. And my lord, the plaintiff who is claiming the purchase from Pulin Pradhan, no deed is there. But all substitute, there are 3-4 transfer. They are relying on the deed of later one. But
Understood.
deed by which my father transferred.
So they don't connect to your father's
Yes.
father.
So my lord, the alleged transfer by my father, it is not genuine one. And my lord, the order impugned directly hits the order of status quo. My lord, kindly have a look. Order of status quo. The
Status quo, that's why I said I have read that. Don't go back there. Let us read this. That is why
My lord, kindly have a look.
first I started with the status code. Regarding everything, nature, character, person.
Kindly have a look.
What is this?
Order of status quo.
It was hanging on your wall, client's wall, and
My lord,
got from there. It is annexed here.
Annex করা আছে? আচ্ছা, আচ্ছা। So, my lord, kindly see.
Ask your client to put it on his wall. I'll see it from the certified copies here. This is the order dated 6th of January.
Yes, 6th of January 2023.
You have annexed it. It's
Yes.
part of your.
My lord, kindly see the observation of the court. Having heard the submission of the learned advocate for the contesting parties and on perusal of relevant materials on record, it is revealed that defendants failed to establish primarily their ownership and possession over the entire suit property. On the other hand, plaintiff primarily established his ownership and possession over 25 decimals of land in the suit property. At this stage, since any evidence in record, there is little scope to purely restrain the co-sharer in the form of defendant of the suit. However, this court is also of the view that there is necessity of preservation of the property in the suit till disposal of the suit, so that fruits of the decree can be properly reaped by the parties. Otherwise, if the parties are let scot-free to deal with the property in the manner they like, them, there is every possibility that the subject matter of the suit will be vanished by the time the suit will reach its end. So, my lord, under this background, how that order sustained? I am putting question to myself. So, my lord, in one hand, there is no document of claiming co-ownership by the plaintiff, and on the other hand, my lord, there was 4 or 5 transfer. Original deed is absent, and in the under this juncture, if they allowed to raise pakka construction, my lord, then my lord, the ultimate relief, if the suit is failed, the defendant will suffer. And my lord, sensing.
Court says that they are undisputedly in possession.
My lord, that
from 1993.
My lord, it was wrong. My lord, findings. My lord, I have to, my lord, challenge it. There was no. But ultimately, he said that the court said that if in this way, it should be preserved till the disposal of the suit. It is usually status quo is.
They are also residing in a mud hut. That is their case. They also reside
They
in a
may
mud hut.
repair it. My case is repaired. There was no objection on their end. But I prefer objection.
Just because you ask for repair, why should they also be compelled to repair? They may make a.
It is not repair, new construction.
They are already residing in that portion, so the position does not change.
New construction, my lord. Then, my lord, the suit for partition, it will, my lord.
Pakka building, yes.
Pakka building, how, my lord, in the suit for partition?
Let us ask Mr. Mukherjee. Yes, Mr. Mukherjee, 2 things. One is status quo in the teeth of the directly contrary to the status quo. Without Order 13 and Rule 4, maybe your undue hardship has been considered in effect. But this is not a 39(4) application. One. Secondly, Pakka building to be constructed. He's right.
But, today, I can argue with regard to the maintainability of this revisional application very well, because your lot
39(4).
Yes, ultimately, even
was your application
caption under 151, that if it is.
Did you ask for make a single? Where is your application? Let us see whether I was interested in that also.
Yes, my application is at page 39 of my lord's brief.
But nevertheless, I shall argue on merits also.
Vacating modification not sought.
Yes. So I can argue because what happened, kindly see.
39.4.
Kindly see. Today.
Pakka construction, how can we?
I am coming to that.
You repair your mud hut.
No, I am coming to that. My case is that it's a suit for partition.
Yes.
I say, by this transfer, I got the property. My learned friend says the change is missing. His written statement, he has annexed. He said, if I can able to produce those deeds, he is throwing a challenge to those deeds. So this is the case and counter case.
You have to stand on your own case.
Yes, I am coming. Kindly see in 2022 and in 2023. First, the ad interim order, thereafter, the order was made absolute on a contested hearing where the court is of the opinion that I have able to prove my possession in respect of 25 decimals of land. No challenge to that till date. So, if I am in possession and my construction is there, maybe in a mud wall, thereafter, what happened? My learned friend has shown before your lordship the impugned order. Has your lordship got it, The impugned order, the second page in reply portion.
Yes.
First portion, my learned senior friend has placed. May I place only once? In reply, learned advocate or the plaintiff submitted that they could not able to collect the deeds through which the pulling such and such by the property from defendant's father Bhagavat Jana or Vijay Krishna Maiti from Pulin Pradhan. But they have already filed deed through which the plaintiff's father and paternal uncle purchased the property from Vijay Krishna Maiti. And it is, kindly marks this portion, it is noteworthy to mention that here that the defendant Prafulla Kumar Jana was one of the witness to the said deed. So, I am coming. So, it's a case wherein both parties are claiming title in respect of a common ancestral. There are chain deeds. The trial of the suit is yet to commence. I am protected by an injunction where my possession has been admitted. What I say, without prejudice to my rights and contention, and without claiming any equity, allow me to make construction since after my application I have created.
But there is a missing link. Their father sold the property. That is not that you have failed to produce.
No, that is in my deed.
You have produced your purchase deed.
Yes, where he is one of the witness.
Attesting witness is not supposed to know the contents. Only the signature.
I am not also on that.
And attesting witness, acting as an attesting witness, Mr. Mukherjee per se cannot operate as an estoppel against that person, because an attesting witness is just to see whether the signature is yours.
I say, the trial is yet to commence. This is, something which yet to be decided.
That is what we are saying also.
Exactly.
Pakka construction, how can you make a building?
Now, kindly see, on 29th of February 2020.
You have been living there for so many years from 1993 in a mud hut. Wait for the end of the suit.
On 29th of February 2024, has your lordship got it? The impugned order allowing me to make construction without claiming equity is being passed. My lord, kindly see my lord's coordinate bench direction. My lord, that was passed first time as per my learned friend's invitation on 3rd of January 2025, almost after 1 year. He has got
in this revision,
he has got an order of stay in respect to that.
Yes.
Now, my lord, kindly see, by this time, this is the construction which I have already undergone. By the order passed by the learned trial court, I have not done anything after this. So, I say, my lord, now, my lord, I will rely upon...
Your mother is still there. Obviously, you are deciding there.
Lord, it's the construction, Lord, that has been carried out in the interregnum period when, Lord, I was protected by the impugned order and this order was not being stayed by the coordinate bench. Now, Lord, if I Lord, just rely upon two of the judgment of this honorable court, Lord, your lordship knows, Lord, the Israel versus Samset, that view has been diluted subsequently. Why, Lord? Because nowadays, Lord, the partition suit, if the possession of the respective parties are there, Lord, if without claiming equity, Lord, what happened? If I lose, Lord, it is written in the order that entirety of the construction will be in favor of the Lord defendant. It is not that, Lord, I am claiming anything equity to that. And, Lord, pursuant to the order passed by the learned trial court, already this construction has been undergone. Lord, may I just only rely upon the division
sanction
bench?
plan for how many stories?
Lord, the sanction plan today, Lord, I am not. It's G+1. Lord, it's for, Lord, I have pleaded. Lord, kindly see.
Only one story has been made.
Yes, only one story.
Cite the judgments.
Yes, Lord, kindly see, Lord, this 2004 volume 1 CLJ page 430. It's a division bench judgment of this honorable court, Lord. Lord, kindly see paragraph
Paragraph 8 is a distinguishing factor. Here, there was prima facie by the conduct of parties, there was a partition. When Monorama Patna was allowed to raise construction and surrender occupancy. Here, there is nothing of that sort.
I'm coming to the, I'm on the proposition. Paragraph 7, if your lordship wants.
7, yes.
Yes. I'm on paragraph 7. And today I have not claimed any equity, and Milord, pursuant to the order passed by the learned trial court, this construction has already been undertaken. In the interregnum period, Milord, by the 1 year passage of time, which
1 year, no,
1 year,
2 months. 2 months.
Milord, impugned order was being passed. Milord, I have shown before your lordship, and when the stay order has been granted by the coordinator.
Impugned order was passed.
Impugned order was being passed, Milord, on 29th of February 2024. I have handed over before.
Yes, 1 year previous.
Yes.
Then what?
Filing, date of filing.
Date of filing is of my revision application.
Not date of filing. He's saying there was no stay order.
Well, order impugned order 29th February 2024, and we should have this.
It has been granted.
Stay granted, Milord, only after 1 year. That I have shown.
They has been granted after 1 year. Before that, they have completed the construction.
No. 8th April, we will swear affidavit within 2 months.
Don't understand, Mr. Putra.
And thereafter, one
yes, Mr. Mukherjee, continue.
Yes,
what else?
Stay granted.
Anything else?
Another decision bench judgment, Milord, where it is seen, Milord, in the suit for partition that the parties reside in the property, Milord, on mutual arrangement. Then, Milord, the question of equity is that let the parties be, Milord, reside or construct. Here also is a case where new construction was directed to be carried out.
Yes.
Paragraph 7.
Yes, I mean paragraph 7. Paragraph 7s are the most relevant in both these cases.
I say, Milord, this proposition has now been diluted by this judgment of, and now it's settled. But today, this has been done. And if something will happen at trial, Milord, the equity portion is also been looked into by the learned trial. I say, Milord, in view of this progress being made, Milord, if today, Milord, this order is being, Milord, interfered with by your lordship, whatever construction I have undertaken by an order passed by the learned trial court, that will also go. Because, Milord, they will say that the order by taking advantage of that, I have made my construction, that will, so my mud wall, my mud structure gone, I have raised the structure pursuant to an order passed by the learned trial court, and that structure, if your lordship today interfere with the impugned order, then, Milord, that structure will also go. So I will be remediless.
What structure will go?
Milord, the structure I have, Milord, already raised. Because if that structure is pursuant to an order, Milord, passed by the learned trial court, which is impugned before your lordship.
Yes.
That structure I have raised in the interregnum period.
That will consider.
That
I'll consider. Yes, but I set aside this order. I'll not direct him to demolish the portion already constructed. That will be subject to the outcome of the suit. But I'll allow the revision.
But only not made that clear.
No, I will be.
Otherwise, they will take steps.
No, that was in my mind.
Yes.
That will be subject to the outcome.
Mr. Mukherjee is only saying.
No, because that was not in violation of.
What is over my land? When, my lord, admittedly, my lord, there was no production of the chain deed, which is the very relevant. We challenge the very challenge that the suit is not maintainable. They are rent trespasser. For that reason, there are 4 transfer, and they are relying on the latest deed, which are manufactured one. If the deed in question from my
the defendant in a partition suit has preferred the instant revisional application against an order whereby against the portion of an order whereby the application of the plaintiff opposite party for making a pakka construction of a new building on the suit property was allowed, and the dependent petitioners were permitted to repair their mud hut on the repair the tin shaded structure situated on the suit property. Full stop. The challenge, obviously, has been thrown against the portion of the order whereby the plaintiff opposite party was permitted to make the Pakka building. Full stop. Next para. Learned counsel appearing for the petitioner places reliance on an order dated January 6, 2023, passed by the learned trial judge, whereby the parties were directed to maintain status quo in respect of the suit property so far as its nature, character, ownership, and possession is concerned, till disposal of the suit. Whosoever it is submitted that the impugned order, so far as it permits the construction of a Pakka building on the suit property by the plaintiff, is clearly violative of the status quo order passed by the learned single judge himself. Full stop. Next para. That apart, the defendants petitioners have challenged the title of the plaintiff in the suit. Full stop. It is contended that although given an opportunity, the plaintiff failed to produce the first link in the chain deeds on the basis of which title is claimed by the plaintiff opposite party. Full stop. The plaintiff stroke opposite party alleges that he has purchased from a vendor who, in turn purchased through a link of transfers, originating from the father of the defendant's petitioners. Full stop. Next para. However, such purported deed executed by the father of the petitioners have not been produced by the plaintiff despite getting such opportunity. Full stop. Thus, in the absence of prima facie proof of title, the plaintiff could not be permitted to make Pakka construction. Full stop. Next para. Learned counsel appearing for the plaintiff opposite party submits that at the stage of grant of injunction, the learned trial judge, grant of injunction, a grant of status quo, the learned trial judge came to a prima facie observation that the plaintiff has established his ownership and possession over 25 decimals of land in the suit property. Full stop. In the impugned order as well, such possession from 1993 has been recorded by the learned single judge. Full stop. Next para. Thus, it is clear that at least the plaintiff is in possession of a substantial portion of the property, whereas the defendant is in possession of the other. Full stop. Next para. It is contended that the strict propositions against construction being made by co-sharers on a joint property, as laid down in the judgment of Israel, ISRAIL, versus Samser Rahman, SAMSER Rahman, reported at 18 CWN 176, has since been diluted. Full stop. For such proposition, learned counsel cites a coordinate bench judgment in the matter of such and such reported at 2004 SCC Online Cal 2, as well as another coordinate bench judgment in the matter of such and such reported at 2009 SCC Online Cal 928. Full stop. Next para. Learned counsel submits that that the defendant stroke petitioners would not be affected adversely in any manner, since the learned trial judge, in the impugned order has categorically mentioned that the plaintiff stroke opposite party shall not claim any equity in the construction to be made by the plaintiff. Full stop. Next para. In any event, since the construction has been subjected to final determination of the suit, no harm would befall the petitioners if such construction is made by the plaintiff stroke opposite party in his occupied portion. Full stop. Next para. Upon a consideration of the respective contentions of the parties, it is clear that a prima facie opinion was expressed by the learned trial judge while passing the status quo order on January 6, 2023, that the plaintiffs have shown their
ownership and possession over the suit property. Full stop. Next para. It is well settled that at the stage of grant of injunction, comma, the court is not to consider prima facie title, but whether a prima facie case, that is a triable issue, has been made out. Full stop. Next para. In the absence of any challenge to the status quo order passed by the learned trial judge, comma, the question as to the title of the plaintiff cannot be gone into at this stage. Full stop. Next para. However, comma, the petitioner is justified in the petitioners are justified in their arguments on 2 counts. Full stop. Para. First, comma, the learned trial judge ought not to have passed an order thereby permitting the plaintiff stroke opposite party to make substantial pakka construction of an entire building on the suit property in the teeth of the status quo order passed by the trial court itself. Full stop. The prayer portion of the application filed by the plaintiff stroke opposite party, comma, which prompted the passing of such order, does not disclose any prayer for modifying, vacating, and or vacating the status quo order in any manner. Full stop. As such, comma, the parameters of Order 39 Rule 4 of the code are not applicable to the present case. Full stop. Thus, comma, the impugned order, to the extent that the same permits the construction of a building in the teeth of the status quo order, is bad on such count. Full stop. Next para. Secondly, comma, the judgments cited by the plaintiff stroke opposite party are not apposite in the present context. Full stop. In Satish Chandra Som Supra, comma, the concerned division bench had observed that when construction was made by a particular party, comma, none of the other co-sharers raised any objection. Full stop. Only when the appellants are making construction, comma, objection is being raised. Full stop. But this question, comma, it was held, comma, has to be dealt with having regard to the facts and circumstances of the case. Full stop. Although it was held that times have changed since Israel Supra and a suit may continue for generation, comma, the court considered the hardship and equity demands in the context of the particular case. Full stop. In the said report, comma, the division bench also considered that the trial court overlooked that the plaintiff purchased 1/14 share measuring about half decimal of land, which was too insignificant, and it is a principle of partition that when a property cannot be partitioned effectively, the same may be compensated by OLT money. Full stop. The same was, comma, thus, comma, one of the considerations for the observations as recorded above. Full stop. Furthermore, comma, in paragraph number 8 of the judgment, comma, the division bench had observed from the conduct that by the conduct of the parties, it was evident prima facie that there was a partition when Monorama Pattonaik was allowed to raise construction and surround her occupation by a boundary wall, which included the portion purported to be purchased by the other parties. Full stop. Next para. In the present case, comma, the defendants petitioners, comma, let alone admitting partition by their conduct, comma, are categorically disputing the title of the plaintiff opposite party in the suit property itself. Full stop. Next para. Insofar as Sanghati Pal Supra is concerned, comma, the division bench observed therein that it was evident from the report of the learned commissioner that there were 5 complete buildings of other co-sharers, and the defendant number 11, comma, that is the appellant before the division bench, has now raised construction up to the lintel level. Full stop. It was also recorded that a contention was raised that no objection was raised when the construction was started, till it reached the lintel, lintel level. Full stop. Next para. It was further considered that apart from the appellant therein, comma, the other co-sharers were in possession of their complete separate respective buildings. Full stop. Next para. The facts in the above, the factual considerations in the above judgments, comma, thus, comma, are not at all applicable in the present case. Full stop. Although learned counsel for the plaintiff opposite party has handed over certain photographs showing that the construction has partially been concluded, comma, insofar as the first ground floor is concerned, comma, the said construction, comma, as opposed to the cited judgments, comma, has been made in the interregnum, comma, taking advantage of the time gap between the grant of stay by this court and the passing of the order impugned herein. Full stop. Next para. Thus, comma, it is not a case that the plaintiffs, that the defendant's petitioner sat idle before the inception of the suit and permitted such construction even before the suit was filed. Full stop. Next para. It is an admitted position that the plaintiff admits that the defendants are also in occupation of a portion of the property by constructing a tin shed property, whereas the plaintiff claims to be in occupation of another portion of the property. Full stop. Till date, comma, before the passing of the impugned order, comma, there was no pakka construction of the suit property, comma, at least at the behest of the plaintiff opposite party. Full stop. Next para. It is well settled that the endeavor of the court will be to maintain the property in statu quo, status estabadde, statu quo during pendency of the suit, full stop, as such, comma, without any immediate justification or urgency, comma, this court does not find any reason as to why the equities balanced against each other, comma, would permit the plaintiff opposite party to construct a pakka building on the suit property, whereas initially at the time of filing of the suit, comma, there was only a kacha structure. Full stop. Next para. Hence, comma, the impugned order is bad on such account as well. Full stop. Next para. However, comma, we are not oblivious to the fact that already a portion of the construction has been erected by the opposite party pursuant to the order of the trial court. Full stop. As such, comma, the said construction cannot be directed to be demolished at this juncture. Full stop. In any event, comma, the plaintiff undertook before the trial court that the plaintiff stroke opposite party shall not claim any equity in the construction, and the same would be subject to the final determination of the partition suit. Full stop. Next para. Accordingly, CO number 1288 of 2024 is allowed, comma, thereby setting aside the portion of the impugned order bearing order number 19 dated February 22, 2024, passed by the learned civil judge, senior division at Kharagpur, district Paschim Medinipur, to the extent that the plaintiff stroke opposite party was permitted to make new pakka building in the suit property. Full stop. Next para. However, comma, it is made clear that this court does not interfere with the other portion of the impugned order, whereby the defendant's petitioners were permitted to repair their tin shed structure situated on the suit property without changing its basic nature and character. Full stop. Next para. Moreover, comma, I further clarify that the construction already made by the plaintiff stroke opposite party on the suit property pursuant to the order impugned herein shall not be directed to be demolished during pendency of the suit. Full stop. However, comma, the plaintiff opposite party shall not claim any equity in such construction, and the said construction shall be subject to the outcome of the suit. No address to cost. Next.
Item number 20.
Petitioner, my lord. This is my lord, my application.
I'm for the
against
response.
My lord, the order whereby the trial
Take the
court has-
microphone, Ms.
Yes, my lord. Where the trial court has rejected my application for addition of the parties in the plaint, my lord, in the suit, my lord.
What is the suit?
For dismiss for default, my lord, I'm not standing in the way. I would only say, my lord, it was dismissed for default in
But it was
February
done-
2024.
Yes.
The application was filed in January 2022. So, my lord, it will obviously be remanded, my lord. I only hope, my lord, that this time they proceed with diligence and within a short span of time.
Should I record that?
Kindly do not record my concession, my lord.
Fair enough. Heard learned counsel for the parties. Full stop. The limited context of the present revision is a challenge to an order whereby the application of the revisionist petitioner for addition of party under Order 1 Rule 10 of the Code of Civil Procedure
It has not been dismissed for default. It has been considered and rejected.
in a suit for what is a suit for?
It is suit for the eviction by a illegal occupant against another illegal occupant. And I am the owner. And
In a suit for eviction has been dismissed. Full stop. In the impugned order, comma, the learned trial judge recorded that the learned advocate for the plaintiff and defendant number 1 were present, but on call the learned advocate for the petitioners in the Order 1 Rule 10 application was found absent, and accordingly the said application was considered considered and rejected, close, comma, being not moved. Full stop. Next para. Although the expression considered close is used, comma, which otherwise might have been construed as an adjudication on merits, comma, the supplementation of the said expression by the phrase close being not moved, being not moved, dilutes such aspect of consideration and makes it evident that the order, comma, read as a whole has to be construed to have to be to the effect that the learned trial judge dismissed the application under Order 1 Rule 10 within bracket 2 of the Code of Civil Procedure for default. Full stop. Next para. Since for the ends of justice, comma, another opportunity ought to have been granted to the petitioners to attend and move the said application for addition of party, comma, this court is of the opinion that the impugned order cannot be sustained, and another opportunity ought to be given to the petitioners to move their application for addition of party. For sub next para, hence CO number 1293 of 2024 is allowed on contest, thereby setting aside order number 23 dated January 30, 2024, passed by the learned judge, 11th bench, City Civil Court at Calcutta, in title suit number 223 of 2021, and directing the learned trial judge to rehear the application under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure filed by the revisionist petitioners on merits. You have filed your objection, no?
Yes, yes.
Upon giving an opportunity of hearing to both parties, to all parties. Full stop. Next para. It is, comma, however, comma, made clear that in the event the petitioners are not diligent this time to move the said application for addition of party, comma, it will be open to the learned trial judge to dismiss the same again on default. No address to cause.
I'm deeply obliged.
The last one was the prize for his fairness. Yes.
Item
Next.
number 21.
21. Same. 21 same.
Yes, ma'am.
Same one. Exactly same. What is the difference? Two suits. Parties same.
Two suit intervening application made by the same intervenant.
Eviction suit two eviction suit.
Date of the order is same.
Yes, my
The order is
Title suit
also-
will be different.
Title suit, the first one 224 and 223.
My lord, both are
No,
eviction.
no. In my order, the number has to change. CO number টা 1294 হয়ে যাবে আর order number 22 dated impugn order টা যেটা dated January 30, 2024 passed একই bench in title suit number 224 of 2021.
Deeply obliged.
Item number 22.
None appears for the parties. Let the matter stand adjourned till after the upcoming puja vacation, annual vacation.
Next, after taking it up,
Item number 23.
same order. Yes.
I have the lordship's leave to mention a matter in an unusual course, my lord. Item number 217 of your lordship's list. 203, my lord. Sorry, I stand corrected. 203, my lord. This was a application filed under Guardians and Wards Act, my lord, for taking custody of the minor son. So the opposite party challenged the jurisdiction on the ground that the ordinary place of residence is wrong. So on the basis of the wrong presumption, an order has been passed for transfer of the case from Uttar Dinajpur to Murshidabad. However, the records show that the ordinary place of residence of the minor child was Murshidabad when the application was filed. So I am challenging that impugned order, my lord. The last extension for which has been paid before the trial court was till 23rd of September. I have served the opposite party, my
Will
lord.
appear tomorrow as for under the heading extension of interim order 203. Tomorrow, extension. Other side is present.
We have served the.
Mr. Haldar, you are a different matter. So if you have served, if you know who is appearing, just try to inform them. Tomorrow as extension of interim order.
Great.
Yes,
Mr.
Mr.
Lord.
Number 33. But this matter has been disposed of on contest in presence of both the parties. But the
Oh.
matter is wrongly appearing in your lordship's list.
33?
33.
30?
33.
33, yes.
Yes.
33 টা একটু চেক করে নেবেন।
It has been disposed of, my lord.
বেরোল।
On
33 দেবেন না কালকে লিস্টে, দেখে নেবেন ডিসপোজ অফ হয়েছে বলছেন উনি, ঠিক আছে?
or any order be recorded for letting the matter go out of list.
It will just not appear, it will vanish. ডিপার্টমেন্টে পাঠিয়ে দেবেন, দেখে নেবেন একবার।